Tabling of documents, Dépôt de documents, the Honourable Parliamentary Secretary of the Government, House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I have the honour, pursuant to Standing Order 36.8, I have the honour to table in both official languages the government's responses to 7 petitions.
Introduction of government bills. Statements by ministers, déclaration de ministre. Reports from interparliamentary delegations. Presenting reports from committee, présentation de rapport de comité, l'honorable député de Saint-Hyacinthe.
The Honourable Member for Saint-Hyacinthe-Bagotte. Thank you, Mr. Speaker. I have the honour to present in both official languages the third report of the Standing Committee on the Status of Women, entitled Abuse of Older Women. Pursuant to Standing Order 109, the committee requests the government for a response.
Député de Argenteau-Papineau-Mirabel.
The Honourable Member for Argenteau-Papineau-Mirabel.
Dissenting report written by the New Democrats. New Democrats find that this report is weak, intentionally weak, and does not address all the issues of concern when we're talking about elder abuse, and that much more needs to be done by the government. Thank you, Mr. Speaker.
Introduction of private members' bills. Madame Latendresse, après.
Ms. Latendresse, seconded by Mr. Godet, moves for leave to introduce a bill entitled An Act Respecting Language Skills. The motion is deemed adopted. The Honourable Member for Louis Saint-Laurent. Thank you, Mr. Speaker. This morning, the bill that I am tabling is such that people appointed by the House or the Senate, the agents of Parliament, are in a position to understand English and French without an interpreter and can express themselves in both official languages before entering their positions. Agents of Parliament cover 10 positions, and I will name them for you. The Auditor General of Canada, the Director General of Elections, the Commissioner of Official Languages, the Privacy Commissioner, the Information Commissioner, the Ethics Commissioner for the Senate, the Ethics Commissioner for the Senator, the Lobbying Commissioner, the Public Sector Integrity Commission, and the President of the Public Service Commission. For those positions, position holders must be able to speak both official languages, so the knowledge of both official languages should be required. Some parliamentarians are bilinguals, and others speak only English, and yet others only French. Officers of Parliament must be in a position to communicate with the parliamentarians in both official languages. This bill covers 10 people, but 10 people who play a very important role. So on behalf of all Canadians, we can't see languages as an obstacle, but a means of bringing people closer together. Thank you, Mr. Speaker.
Madame Latendresse, après par Monsieur.
Ms. Latendresse, seconded by Mr. Gaudin, moves that this bill be now read a first time and printed. The motion is deemed adopted. When shall the bill be read a second time? At the next sitting of the House.
First reading of Senate public bills. Motions, motion. Presenting petitions, présentation des pétitions. The Honourable Member for Winnipeg Centre.
Thank you, Mr. Speaker. I'm very pleased to rise today to table a petition signed by literally tens of thousands of Canadians who call upon the House of Commons to take note that asbestos is the greatest industrial killer that the world has ever known. They also point out that more Canadians now die from asbestos than all other industrial or occupational causes combined, and yet Canada remains one of the largest producers and exporters of asbestos in the world. They also criticize the fact that Canada spends millions of dollars subsidizing the asbestos industry and blocking international efforts to curb its use. And therefore, these petitioners call upon the Government of Canada to ban asbestos in all of its forms and institute a just transition program for asbestos workers in the communities they live in. 2, to end all government subsidies of asbestos both in Canada and abroad. And finally, to stop blocking international health and safety conventions designed to protect workers from asbestos, such as the Rotterdam Convention. Thank you.
Honourable Member for Langley.
Thank you, Mr. Speaker. I'm honoured to present a petition on abortion from constituents in the Fraser Valley. It says that whereas Canada is the only nation in the Western world and in the company of China and North Korea without any laws restricting abortion, it says that Canada's Supreme Court has said that it's Parliament's responsibility to enact legislation. They're calling upon the House of Commons to enact legislation that restricts abortion to the greatest extent possible.
petitions. The honourable member for Edmonton Strathcona.
Mr. Speaker, I rise today. It's my privilege to table a petition from Albertans calling on the House of Commons to eliminate poverty in Canada and support Bill C-233. The petitioners bring attention to the House that poverty affects over 10% of Canadians and disproportionately affects Aboriginal peoples, recent immigrants, people with disabilities, youth and children. They state that poverty leads to poor health, and poverty and social exclusion constitute obstacles to protecting and respecting human rights and exclusion from economic social development. And then, as I noted, Mr. Speaker, they call on the House of Commons to support Bill C-233, which would require the federal government to develop and implement a strategy for poverty elimination in consultation with provincial, territorial, municipal, and Aboriginal governments and with civil society. Thank you, Mr. Speaker.
The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I rise today to present two petitions. The first relates to the ongoing public demand for an inquiry on the question of what occurred in the election that took place a year ago just tomorrow, the question of deliberate misleading of voters to erroneous polling places. The signatories to this petition calling for a full inquiry are from the Toronto area as well as from Vancouver and also some within my own riding of Saanich Gulf Islands. The second petition, Mr. Speaker, calls for the full funding on a stable and predictable long-term basis for our national public broadcaster, the CBC. These petitioners are primarily from the Peterborough area, but also from Hamilton and Toronto. Thank you, Mr. Speaker.
Presenting petitions. Présentation des pétitions. Questions on the order paper. The Honourable Parliamentary Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I ask that all questions be allowed to stand.
Is that agreed? Agreed and so ordered. Orders of the day. Order du jour.
Government orders, government bills, Commons.
C-26, Citizens Arrest and Self-Defense Act.
Resuming debate, the Honourable Member for Hamilton East.
Thank you, Mr. Speaker, and I appreciate this opportunity to rise today to speak to Bill C-26, an act to amend the criminal code, its citizens' arrest and the defense of property and persons. And as I prepared for this a moment ago as I sat here, I was thinking in terms of just a year ago with the election and the impact that our late leader Jack Layton had in that particular election. And this bill was something that he believed very much in a previous incarnation, so it brought that back to mind. One of the things I pride myself in is in the Hamilton area that I attend the local Tim Hortons, I attend the local food courts, and I talk directly to the citizens that I represent. And one of the things that they believe, and I hear said quite often, that common sense isn't as common as it once was. And I think we have in Bill C-26 a fair effort on the part of the government to bring some common sense into this particular issue. Now, Bill C-26 will amend the Section 4942 of the Criminal Code dealing with citizens' arrest and to provide greater flexibility. And a little later in my remarks, I'm going to refer to a speech from the member from Trinity Spadina who actually introduced a bill in this place in the previous session, but it died because of the election. The crux of the problem was the timing of when you were able to complete a citizen's arrest. The law of the day said that you had to act on that citizen's arrest during the actual crime. And of course, sometimes that's just not the case. But it also includes changes related to self-defense itself and the defense of property, which is currently in sections 35 and 42. These changes will bring much-needed reforms to simplify, and again, there's where the common sense comes into the equation, the complex criminal code provisions on self-defense and the defense of property, and something which has been requested by the courts over the years, not just our good citizens. And at this point, I'll refer to the speech that I talked about a few moments ago. The member from Trinity Spadina had an event occur within her riding at a convenience store called the Lucky Moose, and a Mr. David Chen, who had, on May 23rd, 2009, he'd been robbed several times, and numerous times, in fact. And you know, it seemed it was a very popular place to shop, but it was a very popular place to shoplift, and he was extremely frustrated. Well, a security camera showed that an individual that he had seen robbing his store, who had left the premises earlier, was coming back for some more. And at that point in time, this individual, by the way, is 30-some years old and had a criminal record that stretched back to 1976. So Mr. Chen decided, with a couple of people he worked with, to detain this individual for the police to come. My understanding of the situation was that he held the person. The person was bound and put into a van to contain him, and it's indicated here in this speech that the police arrived within about 4 minutes. Well, when they arrived, you could see bruises apparently on Mr. Chen's body where this individual had assaulted him, but instead, Mr. Chen was charged with assault, kidnapping, forcible confinement, and a possession of a concealed weapon. Well, you ask yourself, where did these charges come from? Well, a concealed weapon. It was a box cutter. Well, if you're around a grocery store, they use box cutters all the time. It's not something that they would put on their person to hide from everybody and conceal as a weapon. And beyond that, as far as the forcible confinement, well, if you're going to detain somebody for the police to come who has a record that goes back to 1976, that individual may want to try to get away. And so, anyway, the problem for Mr. Chen is that when the 4 charges were laid against him, you have to stop to think about what he was facing, because the people in charge, the Crown Prosecutor, offered to drop the kidnapping and assault charges if Mr. Chen would plead guilty to the other remaining charges. And if he did, Mr. Speaker, he would have faced 18 months in prison and a criminal record. Now, Mr. Chen, and I'm pleased to say, chose not to plead guilty. And you have to wonder, from a common sense perspective, has our system got stilted to the point that police officers actually put in more charges than necessary in hopes of getting, as it was an old expression in labor negotiations, shoot for the moon and hope for halfway, is that they put into place a trading arrangement in advance by the charges that are laid. The Crown makes an offer, the person pleads guilty to save themselves the cost of court in a lot of cases, and that would mean that people that, had they put forward a proper defense, might well have gotten off. So it really made one wonder about the situation. Now, you'll recall, Madam Speaker, that there was a bill put in by the NDP, the member from Trinity Spadina, in the last House, and as I indicated, it died at the election. I think it was February 17th, that the government also promised to reintroduce the bill, and I want to say thank you to them, because they have. But at committee, when this bill was there just before returning to the House, the NDP critic offered 9 amendments because we felt the bill was flawed in a number of areas. Of the 9 amendments we proposed, only 2 passed, which is unfortunate, but although we're concerned about the fact that the other 7 didn't pass, there is enough content in this bill to satisfy us to the point of supporting it. You know, after careful review of the bill and hearing from witnesses, you know, that reinforced our concerns that were there. You know, our priority when we reviewed the legislation was to ensure that it didn't encourage vigilante justice or encourage people to put their personal safety at risk. We just had a horrific tragedy take place in Montreal a couple of days ago, where you had a dispute between a cab driver and a number of his patrons. And that escalated, and the young men who probably had just come from a bar were jumping on his car. They're hitting the taxi driver, and he tried to get out of there, and tragically, he ran over one of the individuals. I mean, that's a over-the-top, blatant case of a situation, but it shows you how quickly a situation can get out of hand when one group of people or persons try to impose their physical will on someone else. When you look at what happens to people when they're in a confrontation, again, I think I've referenced this not that long ago in Hamilton, where I worked at Bell Canada. One of our technicians tried to intercede between a man who was beating his wife in public. And you would think, goodness, you've got to do something. So he grabbed the person to prevent him from striking his wife and pushed the man and held him against the wall. And the man's wife came over, took off her shoe, and struck the Bell Canada worker in the back of the head. So that's an example of a situation where this individual was trying to do the right thing to protect the woman first and foremost from physical injury, and his intent was to hold them for the police to come because there's other people in the area. Without realizing the relationship was so strong between the husband and wife that she then felt she should defend her husband in the manner that she did. So there are concerns around the situations that people can put themselves in when it comes to an actual citizen's arrest. So unfortunately, as I say, the amendments that we tried to put through to deal with that weren't addressed properly. We had a number of witnesses come before committee. 1 minute already, Madam Speaker? My goodness. I don't know where the time went. If there's just solely 1 minute left, the reality is yes, the NDP will be supporting this bill. We think it's something that brings some common sense to the justice system, and we are satisfied that there was a reasonable effort on the part of the government. And so at that point, I'll conclude my remarks. Thank you, Madam Speaker.
Questions and comments? L'honorable.
The honourable member for Goma, Manitoulin, Kapuskasing.
Greatly appreciate my colleague's speech, and I hope that he'll be able to finish up, because I know he had some additional information that he wanted to share with us, and I think that he really spoke about the fact that some of the other changes that should have been considered, and we're hoping that maybe at some point in time we'll have another opportunity to change that. So I'm just wondering if he can continue a little bit of his speech on this issue. Thank you.
The fact that I tend to tell the stories and I get a little bit away from my prepared text. But again, there's self-defense relative to a situation called battered spouse syndrome. Our amendments on that did not succeed, but it was to introduce the subjective element, that the circumstances that are subjective is the person's preservation of person, the right to protect yourself in a reasonable manner. Now, that element means that it's possible that a person based on a history of domestic violence can reasonably perceive a greater threat of violence because it's being repeated by the same perpetrator. So we thought it was important to add that historical context to this particular bill. Unfortunately, it was not successful at committee because the government didn't see our side of the view.
Questions and comments? The honourable member for Saanich Gulf Highlands.
Thank you, Madam Speaker, and I thank my friend from Hamilton East for his speech on Bill C-26. As the House will know at this point, I think I'm the only member of Parliament feeling that I must vote against this bill because of my concerns for the expansion of citizen arrest powers. And I'd like to ask my friend from Hamilton East, I did try to obtain the opportunity to put forward an amendment that was drafted to delete the one section of the bill that was recommended by the Canadian Bar Association to be deleted, the section dealing with the expansion of citizen arrest powers. And I wonder if my friend from Hamilton East can explain why the official opposition wasn't willing to second my amendment. That would have at least given us a chance to fix the one section of the bill that gives people the most trouble.
The honourable member for Hamilton East, Stony Creek.
Well, Madam Speaker, I wasn't at committee. I'm not privy to the exact reason that our members of that committee chose not to support the amendment. Obviously, they gave it due consideration and felt that it didn't address the situation in a manner that was appropriate for the bill.
Comments?
The honourable member for Rimouski, Nejet, Témiscouata-les-Basques. Thank you, Madam Speaker. I also listened carefully to my colleague from Milton's speech. The NDP will support the bill. However, there are some concerns that have been mentioned by some groups, legitimate concerns that were responded to in part in the committee's work. And one of those concerns was the perception that this would encourage citizens groups to render justice, that is, be vigilantes, as they say in English. So I'd like to ask my colleague with regard to this perception, and if he considers that the bill increases this possibility of having vigilantes.
For Hamilton East Stony Creek.
Well, thank you. I'd like to thank the member for that. A very important question. In the situation that you saw in the United States where the young man was shot, an unarmed individual was shot, and there's legislation in that country called Stand Your Ground, which gives permission to people who feel under threat of physical harm to actually take a life. That is 100% different from what we're talking here. In that particular instance, the subjectiveness of deciding that person's threat to you. Now, obviously, if the person is armed or actually proceeds to strike you, but in that instance, that young man apparently was shot because of things that were said as opposed to things that were done. This bill does not provide for that to happen in Canada. So our committee members who looked at this were satisfied at the end of the day that it would not generate that kind of response.
Pardon. Resuming debate, the honourable member for British Columbia Southern Interior.
Merci, Madame la Présidente.
Thank you, Madam Speaker. I'd like to thank my colleague who had just spoken and also continue to explain what this bill is all about. As my colleague says, it's logical. It's a bill that is a bill that we can understand.
What this bill is saying, that a citizen is able to, even if there's a bit of a delay, to assist in the arrest of someone who commits a crime. And I think that makes a common sense. Donc, le projet de loi C26.
So, Bill C-26 amends Section 494(2) of the Criminal Code dealing with citizens' arrest to provide greater flexibility. The changes will permit citizens' arrests without a warrant within a reasonable period of time. And this is the key change, within a reasonable period, because currently Section 494(2) requires the citizen's arrest to occur while the offense is actually being committed. And this is a difference with the current legislation and this bill, which is being proposed. C-26 includes changes to the sections of the Criminal Code related to self-defense and defense of property, currently sections 35 to 42. These changes will bring much-needed reforms to simplify the complex criminal code provisions on self-defense and defense of property, which the courts are asking for. So what we want on this side of the House is, as I mentioned, and as a number of my colleagues have mentioned, we support this bill. Half of the bill proposes measures that the NDP had already called for through the member for Trinity-Spadina's private member's bill. This part of the bill amends Section 494(2) of the Criminal Code, which deals with citizens' arrest, to permit arrest without a warrant within a reasonable period of time. The other half of the bill seeks to clarify sections in the criminal code pertaining to self-defense and defense of property. After an in-depth examination of the bill and the hearing of expert witnesses during committee consideration, it was established that the amendments make the legislation clearer. Madam Speaker, with regard to the consideration of the bill, our priority was to ensure that it would not encourage citizens to act as vigilantes or to put their own safety in danger, even if concerns in this regard were raised with regard to citizens' arrest, self-defense, and defense of property. We have determined that the bill proposes acceptable amendments. We must highlight the fact that each of these three concepts already exist under the criminal code. Consequently, the amendments set out in the bill will only deal with aspects that are already contained within current legislation and will not introduce anything fundamentally new. So that is what happened in committee. A wide range of witnesses appeared before the Standing Committee on Justice, including representatives of the Quebec Bar Association, the Canadian Association of Corner Stores, the Canadian Association of Elizabeth Fry Societies, the Association of Professional Security Agencies, the Canadian Bar Association, and the Canadian Police Association, as well as academics and practicing lawyers. In other words, we can say the experts came and testified before the committee. Although we already support the principle of the bill, we had proposed, as usual, a number of amendments based on the recommendations made by the witnesses. This happened in committee. This is logical. That is that we listen to the witnesses who appear before the committee and we propose amendments. 2 of those amendments were passed and 7 of the amendments were rejected. I think, Madam Speaker, that it is important to mention in particular the rejection of the amendment seeking to integrate the subjective aspect into the bill concerning self-defense. This amendment would have allowed the inclusion of all of the actions taken for one's self-defense, which is commonly known as battered wife syndrome. For example, when we talk about taking into consideration the subjective nature, it means that it's possible for a person who is a victim of family violence to reasonably believe a greater threat or perceive a greater threat from the other person, and that in comparison to somebody who did not have the same history. In other words, it's important to take into consideration the subjective perception of the individual's circumstances rather than a purely objective perception of the situation. We believed that the terms with regard to the 2 parties passed weren't sufficiently set out in Bill C-26, and we wanted to make sure that a person who was acting reasonably in their opinion under the circumstances, and for this to be taken into consideration in this kind of situation. It was also the first time that Canadian legislators had the opportunity to integrate the subjective aspect directly into the criminal code, which has to date been based on jurisprudence. The Canadian Bar Association and the Canadian Association of Elizabeth Fry Societies both recommended that this amendment be made. Also, Madam Speaker, we did succeed in passing an amendment which would require the courts to take into consideration the relevant facts concerning the individual's personal situation as well as those of the other parties, as well as the relevant facts concerning what happened. Although those terms aren't as specific as the formula, quote, acted reasonably in his or her opinion under the circumstances, end of quote, the amendment that we did manage to pass will require the courts to take into greater consideration the past history or relationship between the individuals. We recognize that these sections of the Criminal Code must be updated, and even if most of our proposed amendments were rejected, we believe nonetheless that the bill will allow adequate updating of the legislation, and we support the bill. Madam Speaker, I would like to tell a bit of the history with regard to this bill. As you know, Madam Speaker, it was May 23rd, 2009 that David Chen, owner of the grocery store, the Lucky Moose Food Mart in Toronto, arrested a man who had stolen from his store. And we know the story, or everybody knows the story. Madam Speaker, all this to say that even if not all of the amendments were adopted on this side of the House, we support this bill. Thank you, Madam Speaker. Questions and comments?
The honourable member for Charlottetown.
Merci, Madame la Présidente.
Thank you, Madam Speaker. I want to thank the member for his speech. He expressed some concerns with regard to Section 2, which refers to the exceptions.
The member relates to the list of factors enumerated in the new bill or in the new law with respect to when self-defense is available, and in particular the list of factors at Clause 2F that allow for a court to consider the nature, duration, and history of the relationship between the parties. I did hear his comments with respect to that section. Our concerns with respect to that section is that it could cause problems two ways, in that self-defense may be available in circumstances where it now isn't, and the presence of the section could result in a claim of self-defense not being taken seriously simply because it's there. I would be interested in any further comments the honourable member has with respect to that factor being included in the self-defense provisions. Thank you, Madam Speaker.
The honourable member for British Columbia Southern Interior. Thank you, Madam Speaker.
For his questions. And I guess the way I read into this bill is that there is discretion. The bill allows the judge discretion to determine, when looking at self-defense or reasonable cause. And certainly I don't think it's the intent of the bill to allow unreasonable use of force as a means of self-defense. I understand that concept because I've spent the last 30 years studying martial arts and self-defense. I understand that it can be maybe go overboard. So I think that the way it stands is probably sufficient protection in the law to ensure that the judge or those that look at this and understand that there will not be an overuse of self-defense, and that the whole idea of reasonable cause and the background will be taken into consideration.
Comments? The honourable member for Saanich Gulf Islands.
Thank you, Madam Speaker, and I'd like to thank my friend, the honourable member for British Columbia Southern Interior. My question here is also a commentary on our procedure in Parliament and how we handle legislation. I raised this issue earlier with the member for Hamilton East and was slightly misunderstood. As a member in this place for the Green Party, I am not a member of committee, but I have the right to put forward amendments at report stage, which I think provides this House with an ideal opportunity to further improve legislation. That is indeed why there is the opportunity for amendments at report stage. But what increasingly happens is that when political parties as entities decide that they're satisfied with deals struck at committee, they're no longer willing to consider improvements that are even advocated by such a group as the Canadian Bar Association. And that's why not a single member of this Parliament was willing to second an amendment that would have improved the legislation. I'd like my honourable friend's thoughts on this problem that we face of groupthink within parties.
The honourable member for British Columbia Southern Interior.
Well, I'd like to thank my colleague from Saanich Gulf Islands for her question and to once again welcome her here. I'm always pleased and I enjoy hearing her take on matters in the House and her comments. I think all of us in political parties, the tendency is maybe when the political party gets bigger and that one day hopefully her party will also grow, there's a tendency to become very, to not allow discussion from outside of the party, and I think we have to be very vigilant of that. Even though we may have a majority and another party may have only 2 or 3 members, I think it's part of the democratic process in the House that we owe it to the Canadian public that we allow this democratic process to function. And I look at the debate on proportional representation. We talk about that, and I'm glad that my party, we support this concept. And I know that in the past other parties have supported it, but once they got into power, they forget about it because they don't, it's not needed for them. So I think we have to constantly be vigilant about the democratic debate and allowing all members to express their view and to have input into any legislation. Thank you, Madam Speaker.
Debate, the honourable member for Charlottetown.
Thank you, Madam Speaker, for the opportunity to speak to Bill C-26. This particular piece of legislation would amend the criminal code to allow an individual who owns or has lawful possession of property or persons authorized by them to arrest within a reasonable time a person whom they find committing a criminal offense. As well, the bill attempts to clarify in law the self-defense provisions. I do have some concerns with respect to these and will elaborate on them momentarily. However, I do want to say from the outset, Madam Speaker, that the Liberal Party will support this bill. We do have concerns about certain aspects of it. Currently, as you know, Madam Speaker, the Criminal Code allows Canadians the right to claim self-defense in the event they are assaulted without provocation. The Criminal Code also allows for Canadians to rely on the defense to property provisions in certain circumstances. So there is a Criminal Code defense of self-defense and defense of property. There is also a common law defense for each of them as well. The point that I wish to make, Madam Speaker, is that we're not here dealing with a legislative vacuum. There are laws with respect to self-defense and defense of property, both codified and under the common law. It is true that some aspects of the criminal code in this regard are outdated and in need of modernization. Indeed, the provisions of the criminal code with respect to defense of property span 5 sections, and with respect to self-defense span 4 sections, sections 34 to 37 of the criminal code. So while Liberals support the bill, I do wish to raise again that which has already been articulated by the honourable member from Mount Royal, a couple of areas of the bill, and there are more, but there are 2 areas that will be the focus of my remarks. The first concern relates to the property defense provisions of the bill. And I have some concerns with respect to the consequences of their new breadth. They've been expanded, and there are understandably consequences associated with that expansion. In particular, it's Clause 3 of the bill. That's the operative clause here. I would like for those Canadians watching and those who are unaware of the contents of Clause 3 just to quickly read into the record what exactly it says. Clause 3 of this bill amends Section 494 sub 2 of the Criminal Code with the following. The owner or a person in lawful possession of property or a person authorized by the owner, those words are important, authorized by the owner for reasons that I will come back to, or a person in lawful possession of property may arrest a person without a warrant if they find them committing a criminal offense or in relation to that property, and A, they make the arrest at that time, or B, they make that arrest, and these are the key words in this section, within a reasonable time after the offense is committed, and they believe on reasonable grounds that it is not feasible in the circumstances for a peace officer to make the arrest. One of my concerns with respect to this section relates to private security agents. So as I indicated, this section allows for persons authorized by the owner to make an arrest within a reasonable time after the conviction of an offense. Now, we all are aware of private security firms, private security officers. We see them at hockey games. They're often out in full force on the weekends watching over a particular business, or we find them providing security in a mall. The amendments contemplated in this bill prescribes new powers to private security agents, and in some cases provides them with powers incongruent with their training and experience as a private security agent. It needs to be borne in mind that private security officers are accountable to the property owners. They're accountable to their employers, as opposed to the accountability that peace officers have to their code of conduct. Obviously, we know that peace officers or police officers are duly authorized individuals that we entrust to enforce the criminal code and other statutes in this country. They exercise considerable power only after a process of extensive training. Peace officers in this country are well trained in police tactics, arrest procedures, and the criminal code. More importantly, among the list of requirements, these individuals are properly vetted for temperament and balance, and after that training, we entrust these individuals with a gun. And all that is well and good in this country. We need our police to protect us. I am concerned that through this particular clause of the bill, it may lead to serious difficulties, including vigilantism. Allow me, Madam Speaker, to provide what is now a very well-known example. We're all very well aware of the situation in Florida recently, where an individual acting as a neighborhood watch person now stands accused of committing second-degree murder. He's up on charges because, as we understand it, he's being accused of using excessive force. The facts in this matter are now very well publicized. A young man is now dead as a result of another individual who, while functioning as a neighborhood watch person and in possession of a weapon, acted in what he claims was a lawful manner because he was defending property. I share this example, Madam Speaker, only to point out that when laws are enacted in which we provide the individuals the right under the criminal code to act in the protection of their property or of their person, we are acting in the stead or are acting in the stead or at the behest of another in an employee-employer relationship, we must be very careful. There will be, I have no doubt, a time when we will face a situation perhaps not unlike what we see in Florida. So yes, Madam Speaker, I am concerned about this particular provision, and I hope the government might take another look at this provision in the bill as it proceeds to the Senate for legislative scrutiny. Certainly allowing for a piece of crime legislation to be amended at the Senate is not without precedent, even in this particular session of the House. Another source of concern for me can be found in Section 34, and this is the section that doesn't deal with defense of property, but with self-defense. Again, for the record of those who are not in possession of the bill, Section 34(1) states that a person is not guilty of an offence if A, they believe on reasonable grounds that force is being used against them or another person, or that a threat of force is being made against them or another person. Now, that's the new law that's been proposed. The current law, the current criminal code with respect to self-defense reads, and I quote, "Everyone who is unlawfully assaulted without having provoked the assault is justified in repelling force by force." The concerns that I have with respect to this section are two. First, the removal of provocation as a relevant consideration for self-defense, and secondly, the removal of the necessity of an unlawful assault, preferring instead the word force. The question becomes, how broad is the word force? The law used to say that you could rely on self-defense if you were being assaulted, which implies a violation of the person. The word force is broader than that and arguably could have an economic force element. So it broadens the situations in which a claim of self-defense may be made. So, Madam Speaker, I state again that I hope the government might take another look at this matter and perhaps be open to some further discussion. I want to conclude by suggesting that we are in general agreement with the thrust of this bill. As suggested by the member from Mount Royal, the bill does provide elements of clarity for prosecutors, judges, and juries, as well as those who may find themselves in a circumstance where they need to defend themselves or their property. Time and jurisprudence arising out of the application of these provisions in our courts will inform us if the amendments have gone too far. Thank you, Madam Speaker.
Comments? Questions and comments? L'honorable député de...
The honourable member for Rimouski-Témiscamingue. Yes, Madam Speaker, once again I listened carefully to my Charlottetown colleagues' comments. I would like to offer a third party's perspective on that. That has to do with concerns that may be legitimate about people who could decide to be vigilantes themselves. They may even do so in groups. They may walk around the neighborhood and patrol it together, as they say vigilantes in English. So could the honourable member comment about that type of concern on behalf of certain people as to the scope of the law?
Merci, Madame la Présidente.
Thank you, Madam Speaker. Of course. This is something that is important, and I did discuss that a little bit in my speech. I hope that we can be certain that judges and courts will do things properly when they are studying this legislation.
Is that with the expansion of the rights with respect to defense of property, there is always a concern with respect to vigilantism. I did focus in my comments with respect to the expanded rights for private security officers, but this also goes for private citizens. I think the bill itself does not promote vigilantism, but the problem that you have is the public perception of the expanded rights of citizens' arrest does raise that flag. And my colleague is right to be concerned about it. And I think it's important, it's impingent upon the judges in this country as they interpret the new provisions to make sure that there is a governor on that, and that the decisions, the jurisprudence around this, that they're reported by the media in such a way that the public awareness does not result in those unintended consequences. Thank you, Madam Speaker.
And comments? The honourable member for Saanich Gulf Islands.
Thank you, Madam Speaker. I want to thank my friend from Charlottetown for his comments. I think a lot of people, a lot of members of Parliament, as we approach Bill C-26, are mindful of the notion that hard cases can make bad law. You have a specific case of David Chen in the Lucky Moose, and you would have wished that the The police on the scene had exercised some common sense and discretion in not prosecuting the individual, and now we have a law where I think a lot of us are concerned that there could be an increase in injuries and even in deaths from people who try to take the law into their own hands, feeling empowered by what this House is doing on Bill C-26. And I asked my friend, since I'm the only person planning to vote against this legislation, its passage is a certain thing, whether he thinks there's any way that the House can send a message to Canadians that they should avoid taking the law into their own hands.
The honourable member for Charlottetown.
I thank my colleague for that question. And quite frankly, it's a difficult one because here we stand as legislators expanding the rights of citizens' arrest. And we as legislators debate the bill, express our concerns over it. But what enters the public psyche is what they read through the media. And we as legislators, I believe, can do so much, and I believe we're doing it here today. But it's hard, it's extremely difficult to control the message. And there will be elements of society who, as my colleague points out, feel empowered by these expanded notions. And as she indicated, hard cases make bad law. There will undoubtedly be cases going forward where the expanded right of self-defense or defense of property is used to justify inappropriate actions. And it is, I guess it's my hope and expectation that the coverage around those hard cases informs Canadian judgment. I think it's more likely that will impact public opinion than quite frankly, the debates that we have here as legislators, which by necessity are at times on the theoretical as opposed to the practical level. Thank you, Madam Speaker.
Resuming debate, reprise du débat, l'honorable député de Montmagny-Lillette.
The honourable member from Montmagny. Thank you, Madam Speaker. It gives me pleasure to stand here today in this House to comment the bill, Bill C-26, which in the end is about society, and all members in the House are interested. We're trying all together to create a civilized society. But we all came from chaos. The crime rates are much lower than 100 years ago, and even lower than the Middle Ages. But things are always in flux, and some situations may be more aggressive than others. And this bill addressed this very, very gray zone. Unfortunately, some citizens may have violent attitudes. And what do we do when faced with those attitudes? The NDP plans to support Bill C-26 because it is very similar to a bill that was put forth by my colleague from Trinity Spadina. Throughout my comments, I'm going to mention this very well-known case in which triggered this bill and this motion by my Trinity Spadina colleague. So this was the idea, the case of Mr. Chen, who was the owner of a grocery store. So David Chen, the owner of this grocery store, was accused of arbitrary detention for as well as assault and forcible confinement after having tied up a person who had stolen something from his store. It wasn't the first time this person had stolen from that business. There are two key words. He tied someone up. He did not beat the person. He did not kill the person. He tied up the person. And he was faced with someone who was committing a second or third offense. So we have a situation that applies perfectly to the issues before us today. This is not a simple situation. This is someone who tied up another person, who did not beat another person, and we're talking about a repeat offender. We're not talking about a situation where a store owner is suddenly being threatened by a person holding a machete. This was a very nuanced situation, and we can all understand our colleagues' response at the time for having said, well, could we ensure that legislation helps us to simplify contexts that are in themselves more complex? So simplify the repercussions for people who are going through a complex situation such as that one. I'll just come back to my notes. So these are notions that are very demanding. Many nuances. You need a great deal of context. So no one here, for example, would want a teenager who steals 2 cans of Pepsi be beaten with a baseball bat. And it's this type of message that this bill could send to a small portion of the population. And we would not to see that type of application of the law. So we keep finding notions in the bill such as reasonable. The word reasonable comes back, I think, 30 times, according to my count, in the amendments that are proposed for Bill C-26. Once again, it's a question of nuances and subtleties. Legitimate defense. We have to define or self-defense. What is it that renders something an act of self-defense? Once again, we're in a gray zone. Unprovoked attack, provoked attack. When is the assault serious enough that the store owner could be considered to be provoked? So once again, provoked, unprovoked, these are important nuances. There is a motion that was defended by several of my NDP colleagues and that deal with the subjective perception, which is to say, yes, we're talking about the an abused woman syndrome, but even if the assault was not, quote unquote, so serious, if this was an assault that followed many assaults upon herself, she has a severe reaction, and that could be understood, and she could be free of punishment. But now let's come back to Mr. Chen, the business owner's situation. If, for example, I own a business and I'm a victim of an assault by a person armed or unarmed, but my children are present and they're in the store with me.
I might take different action because I'm not just looking at someone who's brandishing a knife. If I'm behind my counter, I'd be protected. But if I know that my children are there, I might act differently. So then we'd be getting into that area where, a bit of a gray area, where the reaction might be more severe. And we'd have to look at the context, in fact, and the perception. What happened before the action was taken, before the assault, etc. So I think that we really need to take a look at the issue, and it's really unfortunate, and it angers me that the government never gives us enough time to study these issues. The government needs to allow the committee to examine all of those issues because they are huge. Now that would enable us to not abandon an important principle. We'd be abandoning our collective responsibilities for civil protection. The message can't be one where we are encouraging vigilante justice. No. Now, there's a fundamental difference here. We don't want to go back to the times of the Far West in the 1800s. No. We're much more civilized than that. We don't want to accept vigilantism, even for people who are in favor of taking a hard line on crime. That is something that is deeply unfair. If I'm in a store with my family tomorrow morning and a young person or someone who's is panicking and comes and steals some cereal and threatens me with a fist, and I'm behind the counter and this young guy is 125 pounds, well, if I could take vigilantism. But if it's my mother who's 76, who can't see very well, who's got knee problems, well, we're both citizens with the same rights, and we have the same quote-unquote ability or opportunity to defend ourselves. It's different. So we can't reach that point. We have to maintain the simple principle that the panic button under the counter works. It's got to work. That's the only collective aspect that remains. We have a collective problem. People need to be able to call for assistance. They need to receive the assistance and the aid they need from the police. And that's an aspect of the bill and the potential consequences of it that concerns me. Are we abandoning civil protection? If it's my mom who's behind the counter with who can't defend herself, or who can't defend herself as I could, or my colleague there who's done karate for 25 years, she deserves the same protection, and that should be the objective for this House. We can't simply hide behind principles that would take us back to a situation like the Far West. So I asked again, please, when the committee has an opportunity to examine the Act, please don't muzzle the committee. Allow the committee to look at all of these important aspects, because that will enable us to prepare a good document that will help people like Mr. Chen face fewer consequences in the situation like the one he faced. Now, I'd like to quickly go over another argument to, in fact, reinforce my request not to muzzle the committee. In this case, we're not facing any kind of urgency. Yes, there was a 6-month period for Mr. Chen where he had to defend himself and the people who worked with him, and then they were acquitted. Now let's hope that following the tabling of this legislation, the complications wouldn't last 6 months, but at the end of the day, they were acquitted. So we're not looking at the situation for hundreds of Canadians who are experiencing some kind of situation of injustice because they wanted to reasonably defend their businesses. We're not looking at a panic situation. And I hope that we won't see happen here what's happened with other bills, where, like at public safety, where if we question bills, all of a sudden they'll say, oh, we're in favor of robbers. No, we'll be supporting this bill, Mr. Speaker, but allow the committee, please allow the committee to examine all of the moral issues, all of the important issues raised. Thank you, Madam Speaker. Questions and comments?
L'honorable député d'Algoma.
The Honourable Member for Algoma, Manitoulin, Kapuskasing. Thank you very much, Madam Speaker. And I agree fully with our colleague from the NDP on the concerns raised. As we said from the outset, many members have talked about amendments tabled, but this is a bill that does go in the right direction, and it will reinforce the articles already in the Criminal Code. Now, perhaps my colleague could take some time to elaborate on the importance of discussing changes in order to further improve the bill, which could be made in the Senate and at the Senate committee. The Honourable Member for Montmagny, Kamouraska, Rivière-du-Loup. Thank you, Madam Speaker. My colleague is absolutely right. If we're talking about extremes, things are easy. If we were at a committee and, for example, what I would say is a young person who's stolen a can of Coke shouldn't be hit with a baseball bat, but someone else who was threatened with a machete, who's working in a store, should be different. Those are the two extremes. We need to have a balance. We must agree on that. But it's everything that's in between those two extremes that needs examining, and that will take some time. So I reiterate, I hope that the committee will be able to look at the 50% of the cases that are very much related to what triggered the situation, the person who's defending himself, all of those cases. Then we can come up with conclusions and legislation that will help people who've defended themselves in an equitable manner. Questions and comments?
Honourable Member for Hamilton East Stony Creek.
Well, thank you, Madam Speaker. And one of the things that's, that really has to be approached with caution by anybody who is considering making a citizen's arrest, because when you get into the situation of that other person opposing you from holding them, or the amount of force that you're legally allowed to use can only match what that other party is proposing on you. So in other words, if that other party had a small billy club and you had an iron bar, you've got an imbalance there. You've got a more destructive thing there, and you can't do that. And so when you get into discussing how and how far a person can go, it is a very problematic area. The other side of the situation, too, is the subjectiveness of making those decisions as to should I really intercede, should I really deal with the situation. And so to get that out into the common knowledge of the community is going to be very difficult. And on the other side, I think it's going to be very difficult for the courts to look at this and start balancing it off. And we could have went further with this bill.
The Honourable Member for Mamani, Kamouraska, Rivière-du-Loup. And I can state that that is consistent with the other aspect of what I was saying about this bill, that collectively we need to stay the course. Our collective objective is that we need to have a panic button that works. We need to have something like that to protect the 70-year-old corner store owner, so that that person doesn't have to get a baseball bat out, because that could lead to a great deal of trouble and serious consequences and problems. So, yes, let's support the bill on behalf of all store owners, corner store owners who often face that kind of situation, but let's ensure that we're putting forth legislation that has the nuances included in it, that takes the best interest of Canadians to heart, and if it takes more time, then so be it.
Prise du débat.
Resuming debate.
De Rimouski,
the Honourable Member for Rimouski, Nejet, Témiscouata, Basque. Thank you, Madam Speaker. I am pleased to rise in the House today to speak to Bill C-26. Many of my colleagues to date have raised some very interesting points, and I don't necessarily want to use my time to simply repeat what has been said, even though they are important remarks that have been made. There are some aspects, however, that need to be identified and highlighted, and I started to do so as in a question that I put earlier this morning. But one of the aspects that's very important about this bill is that it renews or updates some aspects of legislation that are dated and that don't take into account the modern-day situation. The aspects of the law that will deal with legitimate defense, self-defense, and these aspects need to be updated, and the bill will do that. Now, there are some concerns that have been raised. They're very legitimate, because when we create new legislation or amend legislation, we go into the area of the unknown. But there were amendments that were put forth at committee. We would have liked to have seen some of them adopted, as some were mentioned by my colleague from BC. However, the bill as it currently stands raises concerns. We raised these concerns initially relating to a very specific situation. My colleague for Trinity Spadina initially raised it, as did the member for Kamouraska Rivière-du-Loup regarding Mr. Chen. Now, there's a situation of people who defend themselves and defend their property. There's another case, I won't talk about Mr. Chen, but there is another case that attracted my attention, and Madam Speaker, bothered me a great deal. It was in a rural Ontario region where last August a man woke up in his home to realize that there were 3 people masked outside and had started to throw Molotov cocktails at his house. The individual took a weapon, took a gun, and shot a couple of shots into the air to protect himself. The police came and charged the man with the dangerous use of a weapon, among other things. So those are the kinds of situations where legislation currently isn't protecting people like Mr. Chen or this man in rural Ontario, whose case I mentioned. It doesn't enable them to protect themselves or their property. Now the question deals with the proportionality of the offense. And I think that the bill addresses that well. If a person, for example, commits a crime against a property, like theft in a corner store, you can't use deadly force against that person. The bill doesn't propose that. It, for very good reasons, is far away from that in its positioning. Now, this bill is balanced with respect to force, and it states that force must be proportionate to the threat perceived. But the other aspect that I underscored in my questioning dealt with the bill and the fact that it doesn't give additional power to vigilantes, who are groups, gangs who come together to protect area. That's not what the bill is proposing, and that's a good idea as well, because we know that that can lead to abuse. And what the bill does propose, and it's important to point this out, is the fact that an individual can protect himself or protect his property, or can delegate someone to do so. So, like the vigilante groups, you can't take action the way they would. I think it's also important to have a bill like this one in order to update cases for security guards, for example, in large stores. We saw, even if the charges were dropped, but the initial charging of Mr. Chen, we saw what happened there with him and with the gentleman in Ontario I mentioned earlier. But security guards in large stores have a role and a mandate to arrest people or hold people who have shoplifted something. Now, if somebody is shoplifting and they're stopped by a security guard, they will be taken to an office in order to wait for the police to come. Now, that's another kind of citizen's arrest, but these citizens are security officers, a security staff, and they have the mandate to monitor the store and to take that kind of action. Now, if we look at the cases that were raised, in the case of Mr. Chen and the other individual from Ontario, the legal vacuum that currently exists could have seen a security guard taking similar action being arrested. So it's important for this House to take a look at the issue as such and to avoid situations like that from occurring because of the way current legislation is. Now, there were some objections that have been duly noted, I believe. The NDP had, in fact, put forth a number of amendments. 7 were rejected, 2 were adopted, and as my colleague said, and I will reiterate, we would like to have had the issue of subjectivity included so that a court can take into account a broader context surrounding the issue that occurred. In the cases that were mentioned in the House, we talk often about crimes against property or the external threat. If an individual, for example, tries to affect you by throwing Molotov cocktails at you, those are 2 examples, but there are also grayer areas where spouses are abused in the home. In many cases, in an attempt to overcome it or escape, they have to resort to violence. and we have to take into account the past, and that's why the NDP, on the proposal of certain groups, attempted to introduce that amendment, but it was rejected. The NDP made another amendment, or proposed another amendment, which this time was adopted. It will require the courts to take into account relevant facts in the situation of people, as well as facts surrounding the action. This aspect will be integrated into the Act. We're happy with that. Now, we're not completely satisfied. It doesn't go as far as the subjectivity argument, but it doesn't do as much as the aspect of subjectivity would have done. However, we are happy that it was adopted. The Canadian Bar Association had proposed the idea of the subjectivity. Now, even if we're not satisfied 100% with the amendment, we can use that in order to build on the bill and to deal with spousal violence. So we're happy with that. I'm also happy to see that there's a great deal of agreement on the bill, for the bill in this House. We will be voting in favor of it at third reading. My colleague's concern, my colleague from Sandwich Gulf Island, is already included in the legislation. It's something that's been agreed to by the House. There may be some additional amendments, and like with any bill, this one could give rise to potential changes, to fix shortcomings, etc. And so that's why we're here, to debate the issue, to make the corrections necessary, and to propose some additional amendments that will, in fact, put an end to these problems.
So, once again, I'm very pleased to be able to support this bill. I want to reassure people that the bill doesn't go too far, that it doesn't allow groups to be able to act as vigilantes, and often we see that this leads to abuses, as we see the case in the U.S., in Florida at present. This bill has a good framework, and I'm pleased to vote in favor, and we are pleased to see consensus in the House. Questions and comments? The Honourable Member for Compton Stansted. Thank you, Madam Speaker. I want to congratulate my colleague from Rimouski for that excellent speech. However, I would like him to talk about one of the concerns that was raised in my own speech when I spoke last week with regard to the reasonable period of time, because in Quebec, given that in a number of rural regions, including the colleague who just spoke, his riding as well as other colleagues, the police forces are limited, given the fact that there are different agreements between the Sûreté du Québec and the other parties, the municipalities, and it's difficult to respond immediately. Sometimes it takes 30 minutes to an hour for the police to respond. The Honourable Member for Rimouski-Nejet-Témiscouata-Les Basques. Thank you, Madam Speaker. That's an important question. It's an important detail, and we'll have to deal with it on a case-by-case basis. I think it's quite relevant to talk about the reasonable period of time. In Mr. Chen's case, the thief in question stole property and then returned within a period of time of an hour. And I think, like Mr. Chen, at the time, knew that the person had committed the offense, the person had returned. There was a reasonable period of time. He looked for him for an hour, tried to run after him, and detained the individual finally when he returned until the police was able to arrive. And reasonable time or period of time is an important notion, because sometimes property owners or individuals can think that they have the right to intervene within a week, a month after, but really this is the police's responsibility to conduct an investigation. So the right to self-defense or defense of property is something that I think is fundamental. However, it has to be limited to cases involving an emergency, or the police cannot rapidly intervene. And in this particular instance mentioned by my colleague, this would cover what my colleague said Questions and comments?
Thank you, Madam Speaker. I'd like to thank the honourable member for his very thoughtful speech. I'd like to take the discussion in a slightly different direction. And I'm wondering, I wasn't part of this committee on the bill, and I don't know if the honourable member was or not, but we know that this law has come into effect, or this bill is come effect, the proposed law that will be in effect is in response to a specific incident and presumably to prevent the arrest and detention of people who are trying to protect their property, shopkeepers, for example. In the city of Edmonton, there has recently been recognition that in order to actually improve public safety and not to leave homeowners or shopkeepers victims of this violence, and what they're finding also is that the poor and the street people are in many cases the highest victims of violence. They're introducing programs to bring community agencies and business owners and so forth together to try to get a handle on who is committing these offenses. And I'm wondering if the honourable member thinks that it's also important when we're considering a law like this to look at it within a broader context of what are we doing as a federal government to try to support municipalities in ensuring public safety, and particularly including rural, small municipalities, farmers, counties, and so forth, other than just passing another law to allow people to potentially use some level of vigilantism.
The honourable member for Rimouski, Nejet, Témiscouata, Basque. Thank you very much. My colleague is quite right. I think that when we want to understand the elements that lead to the crime that is committed and protecting oneself, it's important to see what the underlying reasons are. Root causes in English, which leads to the commission of certain offenses, and with regard to prevention and communication within a community are essential in order to be able to ensure a decrease in crime through better intervention on the ground, perhaps with regard to poverty, with regard to community relations, in order to be able to help those individuals, because a number of offenses are committed not by people who seek to do wrong, but because they have things that involve their past, their background, their current situation that push them at times, and it's unfortunate that sometimes push them in their perception of their situation to commit an offense which, of course, endangers the lives of others as well as jeopardizes the property. So we have to ensure that people are protected, and we have to ensure the protection of property as well. This is essential, but I think that it's good for the safety of the community and for the community itself to deal with the underlying causes, economic difficulties, or the general difficulties being experienced by the individuals within a community in order to decrease crime.
For York West.
Thank you very much, Madam Speaker, and I'm pleased to have an opportunity to speak to C26 on citizens' arrest, an issue that a lot of us have an interest in. Most of us in this House are familiar with an Ontario man by the name of David Chen, as was referred to previously by one of my colleagues. Mr. Chen is a Toronto shopkeeper who faced criminal charges after he was subdued and held a shoplifter at his store in 2009. Mr. Chen held a repeat shoplifter after the man stole some plants and then had the nerve to return to the store. This defensive action caused Mr. Chen, unfortunately, to be charged with assault and forcible confinement. So there's a lot of confusion on this issue, which is why I welcome this bill to try to clarify and remove the ambiguity. So while Mr. Chen was eventually acquitted of all criminal charges in this matter, the nature of this case shocked many Canadians. Canadians had a hard time believing that defending one's property could potentially be criminal. But worse yet, while the notion of a citizen's arrest had been a common law tradition for several decades, this case raised serious concern amongst police and legal experts. Bill C-26 is the government's response to that surprise and concern. Now, I accept and believe that Canada's self-defense laws are complex and antiquated and clearly need to be brought into the 21st century. The Chen case has highlighted this fact for many of us, and it's time for Parliament to remove that ambiguity that's there. Now, I also believe that Bill C-26 will provide much greater clarity to prosecutors, judges, and juries as well as to private citizens who find themselves in a similar situation as Mr. Chen. But that said, I am concerned with many of the comments that have been made by others. Eric Gottardi, the Vice Chair of the Canadian Bar Association's National Criminal Justice Section, in reference to some of those who may use the provisions of this legislation. While referencing non-professional security personnel, Mr. Gottardi said that such personnel often lack the necessary range of equipment or adequate training to safely and lawfully make arrests in a manner proportionate to the circumstances. Well, the issue of proportionality in response is the key point. And these warnings need to be addressed along with C-26. But for the sake of clarity, it would be my intention to support the legislation and my party's position, but I continue to have concerns about the scope of the self-defense provisions of the bill. Tom Stamatakis, president of the Canadian Police Association, also has concerns about this bill. He indicated that Canadians should leave law enforcement to the professionals. Specifically, he warned that we should take care, and I'm quoting, we should take care that any changes made within this legislation do not have the unintended consequence of broadening the current mandate of private security. I think we need to ensure that political considerations do not override our primary responsibility here in the House of Commons, and that being the enactment of responsible and sound laws. And some of the crime legislation and so on that has been passed could be questionable upon whether that was really sound and responsible in some of the legislation that has gone through the House. On the matter of the property provisions, I think the right balance has been struck in that particular category. Now, let me tell you a bit of the reasons for some of my concerns, and I'm speaking today. I represent a riding that is inviting, friendly, and ethnically diverse. York West is a place that is home to countless different cultures and traditions, and I can say without hesitation that I believe it is the best riding in Canada. Despite this, like many places struggling with certain negative employment, education, economic factors, combating crime is a challenging for many at times. Recently, local media have reported some criminal occurrences within the neighborhood, something that has put many of our community members on edge. And of course, this heightens everybody's awareness, but also their edginess, and it becomes a concern for some. A citizen's arrest should never be made without careful consideration of certain factors, such as personal safety and the safety of others should be paramount in these discussions. Number 2, is reporting the matter to police for their response a better option? 3, is an actual crime occurring and has the suspect been correctly identified? Well, failure to look at all of these 3 factors can lead us down a path that can have very dangerous consequences for many people, including the overall community. I want to talk a little bit about a law that's in the U.S., in particular in Florida, the Stand Your Ground law. We're all quite familiar with the tragic Florida case where Trevin Martin was shot at close range by an individual named George Zimmerman. And I'm not passing judgment with respect to guilt or innocence. Either way, the loss of any young life is tragic, but it also quite possibly can ruin the life of Mr. Zimmerman as well. Mr. Zimmerman is a 28-year-old armed neighborhood watch volunteer, totally legal in the U.S., especially in the state of Florida. And he has admitted to pulling the trigger and killing the 17-year-old inside a gated community. And for those who hadn't followed the story, this was a young man who was going to visit his father. He was carrying a bag of Scuttles, some sort of a candy, and was talking on the phone to his girlfriend. He was unarmed, a good student, and a young man that his parents were very, very proud of, and not someone who was into crime and all of the rest of it, but he was wearing a hoodie. You know, these kids running around and they wear these little sweat things and they put these hoods on. Well, that right away alarmed the individual. So guilt or innocence aside, I believe this entire matter is the consequence of an emboldened volunteer with inadequate training, acting as though he was a law enforcement professional. Again, the proportionate response was not present. he was told to turn around and leave, that the police would be on their way, but he was emboldened. He was thinking that he could do far more than what he should have been doing. Now his life has been ruined, and it's also the loss of the life of a young 17-year-old. So my point on this is that tough on crime needs to be smart on crime. The two of them have to go together. Protecting one's home or business is important, but it has to be tempered with responsible action. The proportionality of any response to criminal behavior is essential. We don't need any more instances like Trevor Martin case, because too many young lives are already lost to crime. The police are there, and that's their job, to protect us. Not everyone can or should be a police officer. Police are psychologically tested and professionally trained in how to best protect and preserve life and property, and they should always be the first call in any case of suspected crime. Laws should give citizens the option to act in the most extreme of circumstances, and I am hopeful that Bill C-26 will strike that balance. I recall a few years ago when I was a city councillor, one of my constituents heard someone breaking into his house, and he was a hunter and had a rifle and went and got it and shot the intruder. The intruder was not seriously injured, but in the meantime, my constituent ended up being charged much as Mr. Chen was. Well, he was defending his own property. What ended up happening, of course, as with the case of Mr. Chen, my constituent ended up being charged and having to go through a court process, which then was dismissed. But that cost him a lot of money, a lot of aggravation, and certainly left him very fearful of some of the things that were ongoing. So when Bill C-26 is trying to remove the ambiguity, but must move very, very cautiously as you move forward on these issues. So we will be supporting C-26, and thank you very much, Madam Speaker.
Questions et commentaires?
Questions and comments?
The Honourable Member for Algoma, Manitoulin, Kapuskasing.
Thank you, Madam Speaker, and I appreciate my colleagues' comments on this, and obviously this is why there was some amendments put forward at committee, and unfortunately the committee didn't see fit to put forward all of those amendments, only 2 of them. However, this bill actually just reinforces what is currently in the legislation, but helps bring it a little bit closer to where we are today, because it is antiquity. I think that it's important to note that this was a bill that was the part of the bill is actually part of a bill that our colleague from Trinity Spadina had actually put forward. I think that we also have to be extremely careful that this bill here isn't something that people think that they can now take the law into their own hands. I think that we have to be extremely careful on that. And I don't think we're going to see a big influx of that. I think it's just trying to clear up so that people like Mr. Chen are not subject to being charged. But anyhow, what I would like to just ask my colleague is whether or not, and I know that she said that her party supports this, but whether or not she believes it is a step in the right direction, and whether or not she hopes that maybe there'll be some more amendments coming from the Senate on this, given the fact that we've had discussions both at committee and in the House now. Thank you very much, Madam Speaker.
Honourable Member for your request.
Well, I think any time that we can strengthen a piece of legislation by introducing some amendments and having full discussion on those amendments, if that gets done in the Senate, then the Senate will continue to do some very helpful and useful work for us there. The whole goal of this here is to make sure that we remove the ambiguity in those gray areas. I think we all know those gray areas can cause a lot of trouble for a lot of people in a variety of different ways. But the whole issue here is we do not want what happened in Florida, where people become emboldened, whether they have a gun on them or not, to think that they can take the law into their own hands. We have a fabulous police service here in Canada and throughout the country, starting with the RCMP. and it's imperative that we make sure that we have laws that are clear for the citizens to follow and for our law enforcement officials to follow to ensure the safety of Canadians, the safety of our communities. Thank you very much, Madam Speaker.
Questions et commentaires?
Questions and comments?
Honourable Member for Algoma, Manitoulin, Kapuskasing.
Thank you, Madam Speaker, and I couldn't help but get up again because my colleague has mentioned on a few occasions the fact that you know, there are people that will take the law into their own hands, and it's very unfortunate what happened to the constituent. However, I don't think that pulling a gun and shooting at somebody to try to defend yourself, unless, you know, I'm just trying to get some sense, because I just couldn't fathom that. I mean, you know, to have that under somebody's belt, especially if someone would have died. I think at the end of the day, this legislation here, again, is a step in the right direction in order to protect people who are defending their rights. And to a certain extent, I guess we would have to put that, because we certainly don't want to be encouraging people to take guns out and start shooting warning shots, as we've seen maybe some of the Conservatives think that that's what should start happening. But I think at the end of the day, we do need to move our legislation forward into this century. So again, maybe my colleague could just maybe elaborate a little bit more on some of the changes that we would like to see occur.
The Honourable Member for York West, there's 1 minute left.
Thank you, Madam Chair. Well, I'm quite disappointed that we no longer have the gun registry, and I think the less guns we have in the streets, the better, and I think most of us would agree to that. But if people have a gun in their home and they feel threatened, yes, they should call 911, but let's be honest about it. If your family is being threatened and you have something that you feel that can protect you, if that's what you're going to do, and that's what people will do because they're feeling threatened, and they don't want to wait for 911. If someone is there that's going to kill you or your family, you're going to do whatever you can to defend yourself. So as much as I would like to see far less guns in this country of ours, we have to deal with the reality. There are many people who are law-abiding citizens who carry guns and have them, and that's what happens when someone who thinks that they can take the law into their own hands. Thank you.
Reprise du débat, l'honorable.
Resuming debate. Thank you, Madam Speaker. I'm very pleased to be able to speak now to this bill as well, Bill C-26. For once, the Conservative Minister of Justice is presenting a balanced bill, which takes reality into account as well as certain recommendations made by the opposition parties. So we can all be delighted to have before us a bill that will probably be unanimously adopted. With respect to the bill, we plan to support this bill, Madam Speaker. In fact, this problem in the current legislation had been raised, and I think everyone gave the example of what took place in Toronto with this merchant, Mr. Chen, who proceeded to arrest someone who had stolen from him, to arrest him himself. And so when we saw that business person was accused of a criminal act himself, we saw that there was a problem in the legislation. Now, if it was a recurring problem that we'd often heard about with respect to what happened to Mr. Chen, but it really inflamed passions, and rightly so. So I think it was adequate to make the necessary changes to the legislation to ensure that that no longer happens, as it did for that business person. So the legislation already grants the citizen the right to defend themselves and even to arrest someone who they catch violating the law. But C-26 prolongs that period by allowing an arrest within a reasonable period following the infraction. That's the major difference, Madam Speaker. In the case of which we're speaking, since the beginning of this debate, Mr. Chen had proceeded to arrest the perpetrator 1 hour after the infraction was committed, which is to say that he noticed that the thief had come back into his store, which takes quite a lot of nerve, and we can all understand that this merchant decided to seize the person and tie them up and then to call the police. So he really did do what he should have done, but one must be prudent And we don't want to become a far west society, a wild west society, where vigilantism rules and becomes the rule of law. In protecting one's property, let's not forget that the police is first and foremost responsible for doing so. But this bill is going to correct that type of situation, allowing citizens to defend themselves and to even proceed to a citizen's arrest without being accused of anything whatsoever, as happened to Mr. Chen. But even though he was accused, the judge did the right thing by decreeing that there were no grounds for laying charges against Mr. Chen for anything whatsoever. So the system did its work, and the person ended up not being found guilty of having or even being properly charged with making the arrest, even though the arrest took place 1 hour after the crime had been committed. So we didn't leave things at that, and I think that's a good thing, since it was raised not only by the government but also by opposition parties who themselves presented their own bills and had recommendations and made comments to avoid such situations in the future. Bill C-26, in my opinion, corrects that type of injustice. The injustice that had taken place in accusing a person who was just defending their own property. So the right to defending yourself is important, but we do not want to become vigilantes ourselves, and we wouldn't want Canada to become the Wild West. But in clarifying things in this bill, I think that we have resolved a problem that may not have been very frequent, but once is already too many. So I view this bill with a favorable eye. But I do have certain questions as to the application that will come from the new provisions in that bill, including the one that has to do with the amount of time that can go by between the commission of the crime and the citizen's arrest that can be made. So, of course, people should be able to protect themselves and protect their property, but in a reasonable way without the use of excessive force. So all this comes under self-defense, legitimate self-defense. In a society where everyone is a vigilante, the Bloc Québécois wants a balanced approach where citizens are allowed to defend themselves, but of course we encourage them to turn towards the police and the forces of law. Bill C-26 does not seem to go against that principle. As I was saying earlier, it must be a last resort to proceed to a citizen's arrest ourselves or to act, because our own physical safety as well as that of people around us may be a problem if we decide to all become vigilantes. But under certain circumstances, Madam Speaker, we do not have a choice. And so we have to ensure that the person who's either attacking our property or attacking people around us or ourselves can be stopped. I have already been faced with 3 people who broke into my parents' house, and I was there alone with my girlfriend at the time. I mean, I was young too. We were both young, and at that time, Madam Speaker, I was frightened. I was quite frightened, not only for my own personal safety, but also for the personal safety of the person that was with me that evening. And I had the sense that there were more than one. That there was more than one person in the house. I could hear them walking and speaking to each other. So I knew that, all by myself, unarmed, I would probably have a serious problem if I tried to confront several people like that and lose the fight if there were to be a fight. So fear motivated me, but I decided to not necessarily confront them, but at least let them know that someone was at home. By let them know that I was armed, I told them that I was going to deal with them if they didn't run away. In the end, of course, I wasn't armed, but they didn't take the chance and they ran off. So that was perhaps the best way to do. But what if those people had ended up going throughout the whole house and I hadn't said anything? They would have ended up finding me in my room. And we all fear that the person who's with us will be attacked as well by such people. So I could have become much more violent, and I would have done everything in my power to defend the person that was with me. And I think under those circumstances, it's quite normal to behave in that manner. I did not have access to a phone. I couldn't phone the police, and I don't know if we had cell phones at the time, but I didn't have one at that time anyhow. I was just a teenager. So that's how we can view things. Everything depends on the circumstances of each case. So the current legislation wasn't necessarily being used inappropriately. There was Mr. Chen's case, but we didn't hear about many other cases of that sort with respect to legitimate self-defense. Especially if there was a delay, because according to legislation, you could make a citizen's arrest, you could intervene if the person, if you caught the person in the act of committing a crime. But in the case of Mr. Chen, it happened later. But what about if 24 hours later you see someone who's robbed you? Well, then I think that the justice system will have to ensure that there's some type of reasonable balance achieved as to what constitutes a reasonable delay following the commission of a crime. And here's another example to justify that measure. And this is about a Toronto merchant who was accused of arbitrary detention and assault. The citizen was acquitted. And as I said, the judge did do his work properly, but I think we do need to clarify through this bill legislation. That's what C-26 does. Now, with respect to changes being made to C-26, I'm not going to go through the whole list, but I do think there's some major changes that should be mentioned here in the House. They're completely modifying the criminal code with respect to self-defense and the protection of one's personal property. So we're talking about 34 to 42. So that's not a bad thing. It's replaced with language that is simpler. We're also talking about the right to a citizen to make a citizen's arrest. And what I retained is that C-26 no longer makes the distinction between various sections, the difference between the attitude of the person who's confronting them, or whether or not the attack was provoked, or if this was an attack against the person who is invoking the defense of self-defense. In one single section, Section 34, which has a general rule, it creates a general rule in the end. They're saying the person is not culpable in infraction if they have reasonable grounds to believe that force will be used against them or feels threatened by another person, and as well as if the act committed was in response to use or threat of force or protecting another person. And finally, did they act in a reasonable manner given the circumstances? I believe that this is an important clarification. It's important to clarify those changes. They are adequate, and this is why the Bloc Québécois is going to support Bill C-26. Any comments? The Honourable Member from Compton-Stansted. Thank you, Madam Speaker. I'd like to congratulate my colleague for his excellent comments. My question is yes, because all of the opposition parties have mentioned that they plan to support the bill, but my colleague did raise certain issues that we could have, certain portions that we could have improved further, and we'd like to know if the party in power is going to be open to discussions during committee when the bill will be studied. Honourable Member for Richmond-Tabascal. Thank you. I'd like to thank my colleague for his question. Of course, I can't speak for the Conservative Party. They are fairly intransigent, generally speaking, not only in committee, but here in the House as well. But as I was saying, in the context of that bill, this is a balanced bill. There's always room for improvement, of course, but this has to do with reasonable delay. What is a reasonable delay and what is not reasonable? In the case of Mr. Chen, we're talking about a 1-hour delay after the commission of the crime. So I think it was quite justifiable to intervene. But if we're starting to talk about a week later or 2 weeks after the crime was committed, I know someone who even went to the door of someone because he believed that that person had robbed them, but that's not the thing to do. He could have placed himself in physical harm, physical danger, and I think what he should have done is call the police and saying, I suspect that this person has robbed me, rather than going yourself to confront that person. But I think judges also are able to make sense of what has occurred. And as my colleague was saying, each case will have to be judged on its own merit. I don't think people should be playing private detective and saying, well, I'm protected by the law now, I'm now allowed to intervene and react. I don't think that should happen within a delay that is not reasonable, within a time frame that is not reasonable. One must not attempt to replace the police. Honourable member from Algoma-Manitoulin. Thank you, Madam Speaker. I do appreciate the fact that my colleague has spoken about this bill. We can see that this is a bill that all the provinces, certainly all provinces, have had cases in their own communities that had similar circumstances. I'm wondering if the honourable member could tell us a bit more about the need for this bill. Would he agree that this bill makes the necessary changes to improve the existing legislation? I'm certain that, as he said in his comments, this bill was not advanced to change something in order to encourage people to defend themselves more. It's only if the need should arise. But I firmly believe that this is not a bill that's going to encourage people to take the law into their own hands. The honourable member for Richmond-Tabasca. Well, I'd like to thank my colleague for her questions and her comment. That's right. The Bloc Québécois would not support such a bill if the goal was to encourage people to become vigilantes and to begin to run around in the streets with weapons and arresting thieves. That's not the question. I think this bill was necessary to correct a problem. And as I said, the problem arose in 2009. I don't think that such a bill would have surfaced if there hadn't been if an honest merchant hadn't been accused of a criminal act himself. Luckily, things ended up well for that. So this person arrests a person, ties them up, and calls the police, and then that person, the merchant, is accused of a criminal act himself. So I just think that Bill C-26 clears up what constitutes a reasonable time frame. Just because an hour has gone by and then you see the same thief having the nerve to come back to your store, and you don't know what he's going. Is he going to keep robbing you? Is he going to keep stealing from you? Is he going to even become violent and attack you or someone else? So I really don't think that person, that the business owner should have been charged with anything whatsoever. So I think in the future, this bill would allow us to avoid accusing such people who are rightfully defending their property and themselves and protecting them.
Thank you, Madam Speaker. And I, too, am rising to speak on this bill, C-26. The origin, of course, is the Lucky Moose case, and that was the case of a shopkeeper who, believing that the same accused was continuing to shoplift in his shop and frustrated that he was not getting action in apprehending this person, chose to detain and essentially arrest and confine this person. And the shop owner was arrested and charged and, in fact, convicted. But there was a lot of controversy around this case, and the case was appealed, and in turn, the conviction was overturned. And it is my understanding that it was the court in the appeal level that raised certain concerns with the current provisions in law specific to property protection. And the court found them inconsistent and meriting clarity. And so from this standpoint, I would like to congratulate the government and commend them for actually responding to the courts. It's a refreshing change. There have been a number of rulings by the court where the government has frankly stubbed their nose at the judiciary. One clear example was the case of the Wheat Board, and another has been a series of cases where the Minister of Environment has refused to exercise his authorities properly to consider impacts to Aboriginal peoples, their lands and waters, and to consider that in exercising his powers. So I commend the government that they have listened to the courts and they are trying to move in the direction of improving the law. This bill that was brought forward, of course, was triggered by the actions of my colleague, the member for Trinity Spadina, and of course everyone in the House congratulates her in her initiative in bringing forward a private member's bill in the last Parliament, and the government is to be commended again for responding to a private member's bill, because of course that's one of the powers of all the members in this House to bring forward activities in a private member's bill. You may or may not have your bill go through the entire parliamentary process and have it accepted and adopted, but by simply tabling it, you can trigger to the government that this may be an action you want to pursue, and in this case the government has responded and they're to be commended for that. It is, however, Mr. Speaker, important when we're making amendments to the criminal code that we avoid one-offs. And there has been a propensity by this government to be doing that, particularly in the area of public safety. And so some of the members in the House have been raising concerns. Well, does the bill go too far? Does it not go far enough? Why has the House not accepted amendments brought forward by people such as the Canadian Bar Association, who of course and by and large represent our Defence Council, or to Elizabeth Fry Society? So in some cases, the members of the committee and the House have considered those proposals for change, and some have been made, in other cases not. And we would hope that if this law should pass, and then go on to the Senate and pass and be law, that the authorities that oversee this amendment to the criminal code, including the courts, including the Canadian Bar, including Defence Council and prosecutors, including parliamentarians and the committee, give consideration to reviewing how this law is actually being applied in the field. And was it a good idea to amend? Has it gone far enough? Should it be reined in? We, of course, sought some amendments to the bill to improve it. We always try to take a proactive, constructive approach. Some of the amendments were accepted, some weren't. We had, I'm advised, recommended a change to Section 34 to add an additional criteria for consideration of whether or not the use of force was reasonable, is to consider the state of mind or the circumstances as perceived by the person, an example being the battered spouse syndrome. So, for example, if a person has been continually battered, on this particular instance, they may perceive that they're going to be harmed seriously in some way and may react in a very serious way, and that should be considered. Unfortunately, that amendment was not accepted. I would like to suggest, Mr. Speaker, that while efforts have been made to clarify this law at the request of the courts and the public, it still remains highly subjective. And as a lawyer myself, I always like to look to the law to see, are we providing actual clarity so that people know what the law says and what their rights are and their obligations, and so the courts, when the case comes before them, can make a fair ruling. And one of the examples I would give is the proposal for Section Amendment to 494, subsection 2, that the use of force or to detain somebody in the case of their property being impacted, the owner may arrest if they find the person is committing a criminal offense. And I would suggest, Mr. Speaker, that is a highly subjective matter, and it may be very difficult for a shop owner or a property owner to determine whether or not this is simply a simple trespass or if this actually amounts to a criminal offense. So these are the kinds of provisions that I think merit a closer look, and we will await what the determination of the courts are. So the intent, Mr. Speaker, of the government is very sound. They want to provide clarity around the reasonable protection, actions that people take and reasonably to protect their person or property. But we're hearing from the members in the House, so long as the intent is not to go in the direction that some laws have taken in the United States, and those are the stand your ground and the shoot first laws. So we've heard in the debate some concern, particularly in the use of force against others or in what kind of action is reasonable in protecting your property. Hopefully we are not going in the direction of shoot first. It's very important, Mr. Speaker, that we put boundaries around citizen enforcement. Some entities, such as the Police Association, some cases the Canadian Bar, are raising concerns about potential greater citizen vigilante and the potential for people taking the law into their own hands. And I would like to suggest, Mr. Speaker, that there's going to perhaps be need for training and for guidance. Perhaps this kind of training could be provided through business associations. Perhaps the police officers or members of the bench could come in and explain what are the boundaries of these provisions. In the cases where there has been a repeat incidence of shopkeepers being robbed or being attacked at gunpoint, a good example could probably be bank branches, where in some occasions, certainly in my city, there have been repeat robberies at particular branches. So it may well be important, and I always, as a former environmental enforcer, like to encourage the government when they bring forward new laws that they also table or bring forward at the same time a new enforcement and compliance policy and strategy. And so if the public is going to presume that this law gives them greater powers to detain and to arrest and detain, or perhaps use greater force when they feel they're being assaulted or their property is being impacted, I think that we need to be providing some guidance, and I think that perhaps the committee could review this and make some recommendation back to the police forces, back to community associations. I would like to commend my own city of Edmonton, who have implemented a new program called REACH. And what they're doing is recognizing that the police can't be everywhere. There have been pleas from every municipality across the country and smaller centres that they need more money from the federal government for policing. And so in the interim, there may be more, interventions because of this law change where people will take matters into their own hands. It's very important that we stand back and assess, okay, who are committing these kinds of offenses? If they're property offenses, if they're shoplifting, why is this occurring? In my own riding, we have a number of centres who struggle to get the funding to get kids off the street, kids who are abandoned by their families, give them a safe place to stay and a hot meal so that they don't shoplift, so that they don't break and enter and so forth. So I think it's very important that our government give equal consideration in a strategy for public safety, not just to after-the-fact actions, but to preventing these kinds of circumstances. And so I would encourage the Government of Canada to be observing the new programs by the City of Edmonton and to give due consideration to also giving assistance to implementing community crime prevention programs. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The Honourable Member for Algoma, Manitoulin, Kapuskasing.
Thank you, Mr. Speaker, and I greatly appreciate the comments and the speech from the member from Edmonton Strathcona, and we know that she is a very dedicated person, not only in her community, but I've worked with her on committee here, and I know that of all the passion that she puts when she takes something on. So on this particular bill, I think it's important to recognize the fact that at committee there was some legal experts there, and they did put their comments forward. Unfortunately, the government, the Conservative representatives didn't see fit to make some of the other necessary amendments to the bill that would actually enhance it even more. But I know that we will be supporting this bill. However, we would like to see maybe a little bit more amendments put forward in order to really substantiate the need for change to this century. So on this note, I'm just wondering if my colleague could maybe elaborate a little bit more on why these changes should occur, and how great it is to be able to update bills such as this one. Thank you, Mr. Speaker.
Honourable Member for Edmonton Strathcona.
Thank you, Mr. Speaker. I'd like to thank the honourable member who also I have had the great pleasure of working with. And if anybody's dedicated in this House, and to her constituents, she deserves an award of merit for that. To elaborate on that would take far more than the response, and I will leave that to my colleagues who are the justice critics. But, Mr. Speaker, I would like to respond in a slightly different way. There was one case that my fellow Alberta members of Parliament will recall that occurred in Alberta that I think should cause us to reconsider this bill from another way around. In the case of the Lucky Moose case, the shop owner was eventually acquitted and saying use reasonable force. In Alberta, there was a case where a young woman in a group of youth joyriding on a farmer's property, the famous case with Weeble Ludwig property, Weibo, who's now deceased. And it was the other way around, where a gun was shot off and a young woman who was joyriding was killed. So we need to keep in mind that there's two sides to all of these cases, and we need to make sure that people are only using reasonable force when they're protecting their property.
Questions and comments? The honourable member for Hamilton East, Stony Creek.
Well, thank you, Mr. Speaker. And I think the speech after speech in here today have got a thread running through it of concern about whether or not we're opening the door for more vigilante violence or at least an escalation in the type of violence used to try to detain people. And from the standpoint of the courts, of course, a law often is subjective as opposed to prescriptive as to what will happen. Do you see shortcomings in this particular bill in that area?
The honourable member for Edmonton Strathcona.
Thank you, Mr. Speaker, and I'd like to thank the honourable member. Again, I had mentioned that the bill still contains very subjective language. And that particular provision stood out to me where a person finds somebody committing a criminal offense, because in the area of environmental law, you can actually file a complaint to the government if you believe on reasonable grounds that somebody is violating an environmental law. That's a far less serious action, simply filing a request to investigate to the government, than in this case allowing people to intervene. And it causes me some concern about whether or not people really understand what the boundaries are of what people can do to them and what they can do in response. And so I think that it'll be very important to monitor the application of this law, how people respond to it, and what kind of cases come before the court.
We have time for a short question and response. Questions and comments? Questions and comments? The honourable member for Algoma, Manitoulin, Kapuskasing.
Thank you, Mr. Speaker. And as we move forward on this bill, I think that it's, again, important to reiterate that this part of this bill is actually an NDP initiative by the member from Trinity Spadina, who actually had indicated or had brought forward David Chen's story. So again, I greatly appreciate the comments that that the member from Edmonton Strathcona put forward, and I'm sure that she will be very glad to elaborate on the fact that this is not a bill that would actually encourage people to go out there for vigilante purposes, or to go out there and we'll see an increase of people being charged for protecting their rights. It's just to protect the rights of those when certain circumstances like this happen. Thanks.
For Edmonton Strathcona, a short response, please.
Thank you very much. I'd again like to thank the honourable member for her question. We have heard from some of the members in the House, Mr. Speaker, where particularly if your riding is in a large city, there may be a variety of mixtures of youth, there may be people of different racial backgrounds, and there may be some level of prejudice. And so we have to take care that, that these suspicions against certain groups of people don't go to the extent where people use vigilantism. And I would like to just share with the House an expression after the Trayvon Martin case of somebody in California saying they're shocked to learn a private citizen in Florida can essentially serve as cop, judge, and jury and impose death penalty on a fellow citizen. So we do have to be careful that we are not transferring over to our citizens the power of arrest, detention, to determining when somebody is committing a criminal offense or not.
Resuming debate. Reprise de débat. Reprise de débat.
Resuming debate.
For the question. The question is as follows. Mr. Nicholson, seconded by Mr. O'Connor, moved that Bill C-26, an act to amend the Criminal Code, citizens' arrest, and the defences of property and persons, be now read a third time and do pass. Is it the pleasure of the House to adopt the motion? Yes? I declare the motion carried.
Third reading of this bill, troisième lecture de ce projet de loi.
Orders of the day. Ordre du jour.
Orders Orders of the day, Government Orders, Government Bill Senate, consideration at report stage of Bill S4, the Safer Railways Act.
There being no motions at report stage, the House will now proceed without debate to the putting of the question on the motion to concur in the bill at report stage. Mr. O'Connor for Mr. LaBelle, seconded by Mr. Gosal, moves that Bill S4, an act to amend the Railway Safety Act and to make consequential amendments to the Canada Transportation Act, be concurred in at report stage. Is it the pleasure of the House to adopt the motion? Yes? I declare the motion carried. When shall the bill be read a third time? Now. Mr. O'Connor for Mr. LaBelle, seconded by Mr. Gosal, moves that Bill S4, an act to amend the Railway Safety Act and to make consequential amendments to the Canada Transportation Act, be now read a third time and do pass. Debate. The Honourable Parliamentary Secretary to the Minister of Transport.
Thank you very much, Mr. Speaker. I'm pleased to rise in the House in the third reading of Bill S4, the Safer Railways Act. Before I begin, allow me to congratulate my colleagues across the entire chamber for the successful manner in which this bill has been discussed, debated, analyzed, and moved to this point. I thank the honourable member for his applause, and I want him to feel free to interrupt my comments with his applause at any time. But I'm not sure. I hope that he will join me in applauding our Minister of Transport, Infrastructure and Communities, who has proven himself to be a quiet, diligent builder in the true Canadian sense. We see the success that he has had in moving forward with a plan to build a new bridge over in replacement of the Champlain Bridge over the St. Lawrence. And that bridge is going to be at a minimal cost to taxpayers, at higher quality for the residents in Montreal and for the many people who pass through that corridor from right across Canada. He is succeeding in building linkages with our friends south of the border in the hopes that we will have a Detroit-Windsor bridge. He has moved this bill on railway safety quietly but quickly through the House of Commons, and he has also worked with municipal partners towards the eventual development of a replacement for the Building Canada Fund, which will expire in just a few years. So we all have a lot to celebrate when we look at the record of this Minister of Transport and Infrastructure. The bill in front of us, Mr. Speaker, deals with one of the few legitimate roles of government, and that is to protect the safety and security of the person. Canada has one of the strongest rail safety regimes in the entire world. Last year, we saw reductions in accidents on the railroad by 23%, and derailments dropped by 26%. Obviously, there's a lot more work to do. Until such time as there are no accidents whatsoever, we must continue to work with industry in partnership with government to have the strongest and the best laws to ensure safety. Mr. Speaker, it gives me great pleasure to say that committee members have thoroughly re-examined this bill and have given their unanimous approval for the second time, exactly as it was received, with no further changes. It has been a long journey, but our final destination is in view. This important piece of legislation reflects our desire to ensure that our national railway system remains one of the safest in the world, for the long-term benefit of our economy, our communities, and our environment. The safety and prosperity of Canadians is always a priority for our government. Before going further, I'd like to remind you both the origin and the intent of this bill. In late 2006, the Minister of Transport appointed an independent panel to review the Railway Safety Act and make recommendations for improving both the Act and railway safety in general. Through 2007, this panel traveled from the Atlantic to Pacific, gathering input from a very broad spectrum of stakeholders, including the railway companies, their associations, the railway unions, shippers, suppliers, municipalities, other national organizations, levels of government, and the public. The end result of these extensive national consultations was a final report with more than 50 recommendations for improving safety in the rail industry. While the Rail Safety Review was in progress, the Standing Committee on Transport, Infrastructure and Communities undertook a complementary study of railway safety in Canada. After hearing extensive comments from municipalities, industry, and labour, the committee accepted 56 recommendations of the Railway Safety Act panel and tabled its own report with 14 recommendations, many of which are now included in the Railway Safety Act review. Many of which were built on those in the Railway Safety Act review. Some of those amendments proposed in the bill before you today are a direct result of the Standing Committee's extensive work in this regard, and I heartily thank them for their dedicated efforts. In short, Bill S4 is our Conservative government's detailed response to those two national reviews. The amendments it proposes will significantly modernize the current Act to reflect changes in the industry and ultimately to increase the level of safety for the benefit of our generation and those to come. First and foremost, Bill S4 will provide stronger oversight and enforcement capacity to Transport Canada through the introduction of railway operating certificates and monetary fines for safety violations, as well as an increase in existing judicial penalties to reflect the levels found in other modes of transportation. Throughout all our stakeholder consultations, committee examinations of these amendments, we heard strong support for the implementation of safety-based operating certificates for all railways that run on federal tracks. These certificates, which will significantly strengthen Transport Canada's oversight capacity, will ensure that companies have to have an effective safety management system in place before beginning operations. Companies that are already in operation will be granted a 2-year grace period to meet the requirements of the certificate. This includes all federally regulated railways, as well as several of our largest national transit systems that use hundreds of miles of federal track and carry millions of Canadians to and from work daily. Increased safety for these travelers will be a significant benefit for businesses, communities, and families. Many stakeholders also expressed the strong support for the introduction of monetary penalties and an increase in the judicial fines for serious contraventions of safety regulations. Monetary penalties already exist in other modes of transportation. They serve as a complementary enforcement tool, Mr. Speaker, and provide additional leverage on companies that continue to persist in safety violations. This is consistent with the principles of minimizing regulatory burden for Canadians, while at the same time promoting compliance. In that sense, Mr. Speaker, we want to streamline and focus our rules so that they cause a minimal encumbrance to the passenger and the business, while punishing violations with serious monetary fines to discourage noncompliance. In the interest of fairness for all, the proposed penalty scheme will allow for a review of the regulator's penalty decisions by the Transportation Appeal Tribunal of Canada. It will also include provisions related to the minister's decision to impose a penalty, the due process to be followed, the review of decisions by the appeal tribunal, and the level of fines to be paid for non-compliance and infractions. The maximum levels of these penalties would be $50,000 for an individual and $250,000 for a corporation, which is consistent with similar schemes for other modes of transportation. The proposed increase in judicial fines, which were originally established 20 years ago, will also strengthen Transport Canada's enforcement options and bring those fines to a level currently found in the other modes of transportation, as I mentioned earlier. Maximum judicial fines for convictions on indictment for a contravention of the Act would increase from $200,000 to $1 million for corporations and from $10,000 to $50,000 for individuals. Maximum fines on summary conviction for contravention of the Act would increase from $100,000 to $500,000 for business and $5,000 to $25,000 for the individual. These amounts are consistent with those established in the federal air, marine, and transportation of dangerous goods, and those modes of transportation, Mr. Speaker, are comparable enough to ensure that they would work in this mode of rail transportation. We believe that they are large enough to effectively deter contraventions. This bill also provides for a significantly stronger focus on the importance of railway accountabilities and safety management systems, which both industry and labor applaud and support. With these amendments in place, railways companies will be required to appoint a designated executive responsible for all safety matters. They will also be required to provide whistleblower protection for employees who raise safety concerns. Besides increasing our level of protection from accidents and oversights, these amendments will ensure the growth of a strong and lasting culture of safety in the railway industry. On the administrative side, this bill will effectively close the gaps in the existing Act by clarifying ministers' authority on matters of railway safety. It will expand regulation-making authorities, which will enable Transport Canada to require annual environmental management plans from the railways, as well as a requirement for railway to provide emissions labeling on equipment and on emissions data for review. This is what the Safety Railways Bill is all about: better oversight, improved enforcement tools, enhanced safety management systems, and better environmental protection. These are the things we need. These are the things we applaud. And I think my honourable colleagues will agree that these are the things we can all support. In sum, these proposed amendments in the Rail Safety Act will improve rail safety in Canada for the long term. They are the culmination of two important studies and extensive consultations. They provide increased safety for Canadians and Canadian communities, economic benefits to the industry by increasing the likelihood of, by decreasing the likelihood of costly accidents and delays, and are a variety of benefits to external stakeholders, including provinces, municipalities, shippers, and the traveling public. Last but not least, these amendments will provide additional support for a stronger economy and a modern infrastructure and a cleaner environment for all Canadians, Mr. Speaker. With your support for these amendments, with the support of this House, the government's ability to effectively regulate companies in an environment of continued growth, free enterprise competition, and increased complexity will be enhanced. We will have the ability to ensure the safety of not only the passenger, but the motorist and the pedestrian, the communities through which these trains travel. Improvements to Transport Canada's regulatory oversight and enforcement programs would be limited, and the pursuit of new safety initiatives with respect to the management systems and environmental management would be badly constrained without these changes. Without the support of this House, the legislative framework for railways would also remain inconsistent with other transportation modes which have a broader range of enforcement tools, and regulation-making authorities could not be expanded to allow for the creation of safety-based operating certificates. Without the support of the House, we would ultimately be looking at greater long-term costs to Canadians due to continuing fatalities, serious injuries, and damage to valuable property and the environment. Happily, it appears that we do have the support of the House. And I think that all members of the House would agree that because of this cross-party consensus and the passage of this bill into law imminently, the Canadian public will be safer and the industry and its workers will be stronger. Mr. Speaker, consider a country such as Canada, one of the most dispersed populations in the world, the second biggest country on earth. Our railways have 73,000 kilometers of track stretching from coast to coast, more than 3,000 locomotives, and they handle more than 4 million carloads yearly. They operate more than 700 trains per day, moving nearly 70 million passengers and 75% of all surface freight in this country. Railways have been the backbone of our economy since the days of John A. Macdonald and Confederation. They were the foundation of our national growth in the past, and they remain integral to our prosperity in the future. It is timely and forward-looking legislative amendments such as these that will ensure our rail industry remains a safe, secure, and dependable component of our national infrastructure and global economy for many years to come. In 2009, our Conservative government affirmed its commitment to safe, reliable transportation systems by investing in rail safety systems and passing the right kinds of rules into place. These amendments to the Rail Safety Act that we have before us today are the fruit of that commitment. Since the launch of the Rail Safety Act review in 2006, our government has worked continuously with stakeholders through the Advisory Council on Railway Safety, joint technical working groups, and individual consultations across the country to ensure that this bill meets the needs of all the parties engaged in this industry. The net result is a strong, forward-looking bill that updates existing regulatory authorities, brings railway legislation in line with other modes, and significantly improves the safety of our railway system for the benefit of all. And allow me to recognize some of the leaders who played a role in the early stages of this process. I think of then Minister Chuck Straw or Lawrence Cannon, two members who have now moved on to other career pursuits, but who served as ministers of transportation. I think of the honourable member for Ottawa West Nepean, now our Foreign Affairs Minister, who himself served in the capacity of Transportation Minister. I think of our current minister, who, as I highlighted earlier, has a record of quiet, diligent results that he has achieved in this and many other areas. This bill demonstrates the ability of our majority Conservative government to get things done, to continue to preserve our free enterprise economy while protecting the security of the person as one of the fundamental responsibilities of government. Together, as we focus on the next phase of Canada's Economic Action Plan, which is a plan for jobs, growth, and long-term prosperity, and as we build upon the free market foundations that made this country what it is today, I encourage all members to support these common-sense changes to improve rail safety and keep commerce moving across our tracks for the future and for all of us. Thank you very much.
Questions and comments? The honourable member for Winnipeg Centre.
Thank you, Mr. Speaker, and thank you to my colleague for what might be a case study or even a lesson for some of us on how to be a parliamentary secretary, because he spent a full 5 minutes of his speech and opening remarks complimenting his minister, more or less he would more or less have people believe we should be erecting a statue to the Minister of Transport, never mind supporting this particular bill. It would be under the category of infrastructure, surely. I would like my colleague's opinion and view on one glaring thing that jumps off the page to me as we begin the debate on this bill, and that is the fact that it's called Bill S4, not Bill C4. In other words, it has its origins in the unelected, undemocratic Senate. Now, the last time I checked, members of Parliament don't work for senators. I was elected by my constituents to represent them, and it's this, by Constitution, it is this body that comes together to amend legislation or create new laws, etc. It offends the sensibilities of anyone, surely, who calls themselves a Democrat, in our case, New Democrats, to have to tie up the time of the House of Commons with a bill that finds its origins in the other place. I don't understand it. It seems to be a trend. It seems to be a burgeoning pattern, and it's almost becoming one of the hallmarks of this particular government that they use and abuse what I think is abusing parliamentary procedure. No one elected senators to make legislation. They were appointed by the Prime Minister, usually because of their membership in a certain political party in their back pocket. They were either failed candidates, and that's the operative word, failed candidates. We are successful candidates. It's we.
Order. The period of time for questions and comments is limited. I'm sure there are other honourable members that may wish to pose questions. The Honourable Parliamentary Secretary to the Minister of Transport.
My honourable colleague is upset that the bill is called S4 and not C4. He's upset that the bill originated in the Senate and not in the House. The reality is that this is a bill that has consensus across both chambers and all parties. At times, government introduces bills at the Senate level because that chamber might be under capacity while this one is over capacity. And in order to get that legislation passed quickly, we start it there and we end it here. Either way, it has to go to both places. So I conclude by saying S4, C4, what the heck are you fighting for?
Questions and comments? The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. Mr. Speaker, I think that the member has one thing right, and that is in the sense that there is a high sense of recognition in terms of how important railway safety is to all Canadians. We understand and we appreciate the needs that are there to ensure that this vital industry, the railway industry, which is arguably the backbone in terms of the modes of transporting commodities, whether it's from British Columbia through our prairie provinces to Ontario, Quebec, and to our Atlantic provinces. See, we in the Liberal Party have acknowledged how vital that industry really and truly is. And that's one of the reasons why, Mr. Speaker, we recognize the importance of railway safety and therefore, in principle, are supporting and encouraging to see this bill passed today. But my question to the member is in regards to when we make reference to the backbone of our economy. I want the member to reflect on his role that his government has played in terms of the potential threat to railway in the province of Manitoba, in particular from Winnipeg to Churchill, from a decision in regards to the wheat board. You've got to look at the railway as an industry, Mr. Speaker, that provides life to many rural communities, not only in Manitoba, but in Quebec, in Ontario, and throughout our country. And maybe ask him to provide comment as to why this government doesn't see, as Liberals see, as that the railway can provide wonderful economic opportunities for all Canadian communities.
Parliamentary Secretary.
Mr. Speaker, I represent an Ontario riding. We have grains and oilseeds producers in this province. They all sell their grains on the open market without being compelled to participate in a central monopoly. And guess what? There is a successful rail line industry that operates in Ontario. I encourage him to call CN or one of the other railways and ask for a little ride, but he can see how well our system functions right here in Ontario without the presence of the Canadian Wheat Board monopoly. Mr. Speaker, one of the best decisions that any government has made in transportation policy was made when both Conservatives and Liberals supported the privatization of the industry. And because of that privatization, we now have profit-generating businesses that employ people, pay into pension funds, create jobs, support communities, and move goods from where they are to where they need to go. That is the proof of the power of the free market economy. It works in railways. It also works in agriculture.
Questions and comments? The Honourable Parliamentary Secretary for Multiculturalism.
Thank you, Mr. Speaker. Mr. Speaker, this bill obviously represents a lot of hard work on both sides of the House, and especially on our side, to put forward a bill that represents railroad safety. But we need to look a little bit more beyond that, and actually at the pan-railroad economy of Canada. The railroad system in Canada embodies perhaps the soul of Canada in linking us from east and the west. My forefathers are the ethnic Chinese who came here over 150 years ago to help build this railroad represents our contribution to the building of this economy. In the last 20 years or so, I have also been involved with the Railroad Canada in areas of innovation, such as the development of the steerable bogie and the double deck of the GO Transit, and also the long-haul trains that make it so efficient for us to move containers from the west coast to the east coast at a fraction of the cost of what it goes around the Panama Canal. So these are the contributions that the railroad bring to us. The safety for Canadians, the innovation and contribution to our economy, and today for a better and cleaner environment. I'd like to know from the opposition what suggestions they have to improve on this. Thank you.
The Honourable Parliamentary Secretary to the Minister of Transport.
I'm sure they wouldn't mind me answering on their behalf. But I would rather start by thanking the Honourable Member whose expertise in the area of railway transportation has been sought by governments and businesses all around the world. And this House could learn a lot from that expertise. Mr. Speaker, he mentioned the importance of container shipping. And it's interesting that in the late 1950s, international trade as a percentage of the global economy was in decline. In other words, there was something called reverse globalization. That changed with the invention and the mass application of the container shipping box, which effectively allowed massive quantities of goods to move through ports with minimum handling costs. And as a result, you can have a container filled in Beijing, transported to Vancouver, lifted off, put on a railway, transported to a warehouse in Calgary, and then delivered to a retail outlet without even being opened a single time, and at an extremely low cost. That has made it possible for Canadians and others to have access to lower cost goods, to raise our standard of living, and also to get our goods to hungry foreign markets with minimal transportation costs. We need to build upon this wonderful free enterprise creation that has improved the quality of life of so many people around the world. Thank you.
Resuming debate, the Honourable Member for Trinity Spadina.
Thank you, Mr. Speaker. Having a safe and reliable rail network is central to Canada's mobility and economy. 70% of all service goods are shipped by train. Passenger and commuter trains transport more than 70 million people a year. Our railways also have an environmental edge over roadbound traffic, as they only contribute 3% of Canada's transportation-related greenhouse gas emissions. By choosing rail, passengers and shippers also choose one of the safest modes of transport in Canada. Modest gains have been made in reducing accidents over the past few years. But we're not where we want to be in terms of rail safety. The tragic Via Rail collisions in Burlington in February of this year and the recent derailment in Alberta show that more needs to be done. This legislation, the Safer Railway Act S4, is a step in the right direction. And of course, Mr. Speaker, you know, this bill has been in front of the House of Commons several times. In fact, the history of it is quite extensive. It started in February 2007 with the department telling the Minister of Transport that there should be a full review of the operation and efficiency of the Railway Traffic Safety Act. An advisory panel was established, and then the panel came out with a final report called Stronger Ties, a Shared Commitment to Railway Safety. That was published in November 2007. That's 5 years ago. That include 56 recommendations for improvement of rail safety, some of which are some of the legislative change that is in front of us today. And then, unfortunately, through these 5 years, this bill came in front of the House in many forms. The first one, it was on the Standing Committee, actually, in May of 2008, tabled 14 recommendations after they studied the Rail Safety Act. And in June 2010, Bill C-33 was introduced by the government in the House of Commons. And then, unfortunately, it did not pass this House, so we now have S4 in front of us. But this bill is really only a step, not a leap. Depending on who you talk to, some people even think of it as more of a baby step, something long overdue, but certainly not universal in addressing ongoing rail safety challenges. Rail accidents have decreased over the last 5 years, but only in a very limited way. The Transportation Safety Board, an independent government agency responsible for advancing transportation safety through investigations and recommendations, has some insightful statistics. If you bear with me, let me talk about them. The number of railway accidents went down by a meager 5% from 2010 to 2011. We still have more than 1,000 train accidents a year. That's almost 3 a day. Slightly more than 100 train collisions and derailments happen on the main tracks, not tucked away in some slow-moving marshalling yard. Off the main tracks, the Transportation Safety Board reported 573 collisions and derailments. There were 33 accidents in which the culprit was not the human error or the rolling stock, but because the rails themselves were unsafe. Every other week, somewhere in this country, there is a rail accident that involves fire or an explosion. Now, with Via Rail, unfortunately, it does not own its own rails. It's leased to them by CNCP. So it makes it quite hard for them to have much control over the rail themselves. So needless to say, a rail accident's harmful potential is compounded when dangerous groups are involved. In 2011, we had 118 accidents involving toxic cargo, most of them derailments. In 3 of those accidents, harmful contents were spilled, damaging the environment and threatening residents' and workers' health. So even without collisions, there is there's an incident in which dangerous goods are leaked once a week somewhere in Canada. Once a week, Mr. Speaker. The Transportation Safety Board reported 51 incidents in which harmful and toxic substances were inadvertently released into the environment. And things are not looking much better this year. From January to March, we had 16 of those dangerous goods leakage. During the same time frame last year, we had 11. So we actually had more incidents where dangerous goods are leaking out to the environment than last year. 5 more incidents. While the number of overall accidents has slightly decreased, 5%, as I said, the number of serious accidents, those that have to be reported to the Transportation Safety Board, has actually increased by a dramatic 27% from 2010 to 2011. The number of mandatory reported rail incidents rose from 160 to 204. That means we are on par with the numbers again in 2005. 2004 rail incidents. That's a big number. That makes you wonder how significant and sustainable the safety gains are that were supposedly achieved under this Conservative government. In 2011, there were 68 accidents alone that involved passenger trains. But just to keep the record straight, Mr. Speaker, traveling by rail is still several times safer than taking the cars. It is a safe way to travel. But having said that, we do have 68 accidents that involve passenger trains this year, last year. In addition to the potential damage to passengers and working crews, passenger train accidents have a corrosive effect on the public perception. Right after the Burlington accident, Rio Rail suffered from a slump in passenger numbers. Of course, the solution is not talk about it, but really tackle our rail safety deficit head-on. So it's really timely that we have this bill in front of us at third reading, that hopefully in a few days it will become law. In February 26th of this year, in Burlington and in Montreal a few years ago, rail accidents not only impact the workers and passengers that are hurt or fatally injured, the damage and grief goes beyond those immediately affected and includes the local communities, both residents and businesses. Whenever these accidents happen, emergency personnel and local residents show valor and compassion that goes beyond the ordinary. The 5 heroes that were honored by the Burlington City Council yesterday are a prime example of just that. But tragic accidents also leave deep scars in the local communities. Almost 2 years after the fatal accident in Montreal, the parents of 3 killed teenagers are still looking for answers why their children were run over in the dark by a train with dimmed headlights. The Transportation Safety Board has investigated more than 170 rail accidents in recent years. Based on the insights from its investigation, the Transportation Safety Board has made a whole host of demands for improving rail safety. For the particularly urgent and important ones, it files a formal recommendation with Transport Canada and tracks the ministry response and action. Since 2005, the Transportation Safety Board has issued more than 50 of those formal recommendations. Unfortunately, under the Conservative leadership, Transport Canada has not been very proactive or eager to follow those recommendations. Less than 60%, that's 6 out of 10, of the Transportation Safety Board's filed demands have been completely addressed in the eyes of the independent agency. We must ask why. Why aren't 100% of these demands, these recommendations from the Safety Board been addressed, implemented? 15% of the experts' recommendations were partially addressed. A quarter of the Transportation Safety Board's recommendations were essentially left unaddressed with no meaningful action taken. And I'll take some time later on to go through them. The TSB, in its very charming wording, called it satisfactory intent. There's intent, but no action has been taken. In some of these cases, the ministry has been sitting on their hands for 7 years, so it's very subtle to call that intent. Number one of them is the voice recorders. As you recall, in both the in all of these accidents, whether it's the one in Quebec or the ones that are still under investigation from Burlington, the investigators are not able to get to the bottom of the accidents because there are no voice recorders in the locomotive cabs. So unlike planes, we do not know precisely what was happening in the locomotive cab because there's no voice recorder. And since 2007, well, even before then, close to 10 years, the Safety Board have been saying that the Transport Canada must mandate these voice recorders to be installed in these locomotive cabs. So for 6 years, nothing happened. And recently we heard from the minister that some discussion is taking place. There's some negotiation with the unions. I heard from the unions, and the unions said they are not opposed to them. So there is absolutely no reason why it's not mandated. Apparently, there are more discussions. There's a lot of talk. But at the end of the day, there's still no voice recorders in locomotive cabs. And, Mr. Speaker, that's just not acceptable. The second areas that the Transportation Safety Board have talked about is say that there needs to be alternative mechanism to slow down the trains if the trains are going too fast. And in these times of modern technologies, certainly the switches and the tracks can be connected with the braking system. Such technology exists. It's called positive train control system. And it's a system that are being installed across the states. Amtrak, for example, have them now. They are, by 2005, it's supposed to be mandatory. It's mandatory that every train in the U.S. would have such a control system, so that in the case of Burlington, the train will automatically slow down to the appropriate speed and not jump the track because it was going too fast. The other areas that we need to look at occasionally is drivers' fatigue. What happens is that a person would report to work, let's say at 8 a.m., but if the train is late in coming or for some reason there's a breakdown of mechanical problems, what happens is that that driver wait and wait and wait and then start their work. By the time they start to work, if they've waited for a long period of time, many hours, some of them are in fact very tired. So that is an area that needs to be looked at. Another areas that needs to be looked at in future is the whole area of rail crossing. We did not make any amendments to that extent because rail crossing is fairly complex, and that with a lot of developments, there are now condominiums, shopping malls that are built around railway tracks. And what some of the railway companies are saying that, look, if municipalities want to go ahead and build such a development in an area that's served by trains, then at least we should be advised. Now, local municipalities, again, is a local government, it's a provincial matter, so in many ways it does not necessarily belong to the federal jurisdiction, but it's an area that we need to look at, because sometimes what you don't want is a developer building a series of high-rises, an entire neighborhood in one side of the track, and then you build a school on the other side of the track, or the shopping mall on the other side of the track. What then happens is that people are tempted to cross the track, even though there might be barriers. They might take the shortcuts and putting themselves in danger from time to time. That there should be, in terms of planning, urban planning, that it needs to put safety as the very important issue, rail safety. Increasingly in European countries and in Asia, these railway crossings are actually separated by grade. It either go in under as a tunnel, or it goes up on a bridge, so that the pedestrian can walk across directly. There's not a shortcut. It can go across as a bridge to cross that railway tracks. It's costs a bit more money, but it's infinitely a lot safer than asking people to go around the railway tracks and not take a shortcut. Those are the areas that I know the railway associations are quite concerned about. But given how long this S4, the Railway Safety, the Safer Railway Act have been in front of the House, the committee and other members of Parliament and the NDP did not want to slow down this bill, which is why we fast-tracked it through the committee, which is why I did not move any amendments, both on voice recorders, positive train control, or rail crossing, because those are, or driver fatigue, because those issues, important that they are, needs to be investigated, needs to be considered in a future study, maybe in future recommendations. I was assured by the minister, from the minister, that the voice recorders are coming soon. After all these years of waiting, it will come, and that we do not need to mandate it. So I don't quite believe it until I see it, but let's see what happens. But I just wanted to turn the rest of the few minutes that I have to talk quickly about the rest of the Transportation Safety Board's recommendations that were left unaddressed by Transport Canada. Let me list some of them. One of them is the Department of Transport, in conjunction with the railway industry and other North American regulators, established a protocol for reporting and analyzing tank car stop-sill failures so that unsafe cars are repaired or removed from service. Another recommendation that no action has been taken is for Transport Canada to work with the provincial government to expedite the implementation of a national standard for low ground clearance advanced warning signs at railway crossings. Railway crossings are very important. We need advanced warning signs. That CN take effective action to identify and mitigate risk to safety as required by a safety management system, and that we require CN to do so, not just asking politely. And that the Transport Canada implement standards to improve the visibility of emergency contact signage at railway crossings. Again, it's about railway crossing. And then conduct assessments of level crossings on the high-speed passengers rail from the Quebec-Windsor corridor, and ensure that the fences are adequate to mitigate the risk of truck-trains collisions. There are many more recommendations, Mr. Speaker, that I want to go into, but I'm running out of time. I know that when we work together, we can get the job done and make the trains services in Canada even more safer than it is today. Thank you.
Questions and comments? Questions et commentaires? The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. Mr. Speaker, I appreciate the comments from the member, and a couple of thoughts came to mind. And when we take a look at the railway industry, one of the things that we have seen is this this growing need for rapid transit in our urban centres. And I think that this is something that quite often might be overlooked in terms of its importance in today and when we talk about rail line safety, because more and more we're looking at different forms of rapid transit for our urban centres. And I'm wondering if the member might want to provide some comment on that. The other thing that I would be interested in knowing is, does the New Democratic Party have a recent position in regards to the whole nationalization issue? Are they still in favor of nationalizing a rail line? If you can just provide comment on that, I'd appreciate that too. Thank you.
Honourable member for Trinity Spadina.
Well, Mr. Speaker, I think the Liberal member of reminding me that CN was privatized by the Liberal government in the 90s, and that as a result, large number of tracks and services, passenger services, were eliminated and ripped up. The tracks were ripped up, and as a result, through the years, both the Conservative and Liberal government, we lost 10,000 kilometres of railway tracks in Canada. Now, 10,000 kilometres, that's a huge number. Think of all the cities and towns that are left without rail services. And think about the freight delivery services. There are many trucks that don't need to be on the highway. They could be shipped. Any number of goods can be shipped by trains, and it's that much better for the environment and that much safer. So I wish that did not occur, Mr. Speaker.
Questions and comments? The honourable member for Edmonton Strathcona.
Thank the member for Trinity Spadina. She does an absolutely phenomenal job on this portfolio, and I know that all of my constituents appreciate her important work. As I mentioned in the House previously, I actually was a direct victim of a major derailment on the CN line and the largest freshwater spill into freshwater bunker sea oil in the history of North America into Lake Wabamun. The Transportation Safety Board did a report. I'm seeing some changes coming forward, but I've got deep concern that one of the recommendations was inadequate emergency response planning. And yet, in just this past budget, the government has removed all emergency response capabilities of the federal government. And yet, we've had, the largest spill in history. We're still having incidents occur in Alberta, very serious. We've got a lot of movement of petroleum and chemicals, including right into the center of my riding. And I'm wondering if the member could speak to the issue of, unfortunately, these rail companies own a lot of real estate in our country. And we've had the case where we've got major chemical cars coming into the riding, and the city can't do anything about it because they simply hold the lands. We have these lines running along all of our major riverways in the country. Can she speak to the matter of whether or not the federal government should step up to the plate and start dealing with this issue and maybe help municipalities and other areas to buy up these areas?
Honourable member for Trinity Spadina.
Well, actually, the Transportation Safety Board were quite concerned about what my friend said, and that they recommended that the Department of Transport extend the safety provisions of construction standards applicable to 286,000-pound cars to all new non-pressurized tank cars carrying dangerous goods. Okay? It also asks that conduct in-depth studies on the behavior of saturated organic materials under silica loading. It talks about ensuring that maintenance standards and practices address the level of risk in heavy tonnage other than in the main tracks. It also said that the Department of Transport need to make sure that an assessment is made of the suitability of current Canadian rail operating rules and railway instructions concerning the immediate reporting of operating delays to all concerned when there is a safety risk. And lastly, that the Department of Transport establish minimum standards for the type, location, and requirement for fencing along railway right-of-way, approaching railway bridges, and any other areas where frequent pedestrian incursions are known. So you can tell from these recommendations that the Transportation Safety Board wants to make sure that Transport Canada and local municipalities and the railway companies work together to keep everything safe.
Questions and comments? The Honourable Member for Winnipeg Centre.
Thank you, Mr. Speaker. And just very briefly, I want to thank my colleague from Trinity Spadina for invoking for me the memory of the Honourable Reverend Bill Blakey, the former member for Elmwood Transcona, for his regular and frequent reminders to this House of Commons that we need to get the freight off of the trucks and back onto the rail where it belongs. That should be our #1 job for the environment, for rail safety, for any number of compelling reasons. So the one thing I'd like my colleague to comment on, we're dealing with the Rail Safety Act today. There's been a call for a rail service review, and there's been a further call for a rail costing review. Prairie farmers are being gouged as badly as they were being gouged in the 1930s because nobody has reviewed whether or not the cost they're being charged to move their grain is in any way related to the actual cost of moving that grain. Will she comment on the need for a rail costing review as the next initiative for this chamber? Thank you.
Member for Trinity Spadina.
Mr. Speaker, the prairie farmers have waited for years and years for regulations that would govern the CN and CP's service standards. Right now, there's no service standards. So what happened is that, yes, there was a review. The review recommended mediation and regulations. What actually occurred, and the Conservative government, during the last election, promised, actually even before the last election, in March, promised regulations. Right? And that CNCP would be regulated so that they have to have performance standards, they have to have a service standards. So it's not right now. It's completely unfair. All the power lies in CNCP and none to the prairie farmers, be it soy or whether they go soy or grain or lentils. They just don't have the power, and they are not giving adequate notice. They're not given any information. So they've been waiting. We have not seen regulations at all, which is quite unfortunate, because if CNCP are regulated, then we know that there would be much higher service standards and much safer transport, and we certainly hope that their service will expand even more because the farmers will feel secure in delivering their grains to ports through trains, and that they would not look at other alternatives like trucks.
We have time for one more, a brief question and answer. Questions and comments?
Honourable Member for Winnipeg Centre.
Well, I thank my colleague for that answer, and just once again, more specifically, we've heard about rail safety review and even this legislation. We've heard about a rail service review and the promised regulations, but the rail costing review is what I want further information on. It seems the robber barons, once again, are gouging prairie farmers with impunity. The last time we did a rail costing review was 15 years ago, and the Canadian Wheat Board estimates they're paying 30% more than a reasonable cost of transporting their grain should be. Does this House not have an obligation to do a rail costing review to make sure that prairie farmers aren't being gouged by robber barons?
Member for Trinity Spadina, a short response, please.
I agree. Yes, we do need a rail costing review. CN is doing very well. Their profit went up by 13%. I saw it 2 days ago.
For what?
So billions are being made, while prairie farmers are not getting the service they need and are being gouged and are losing millions of dollars because their grains are not showing up to the port on time.
Let's have a costing review.
Resuming debate, the Honourable Member for Bourassa. Well, thank you very much, Mr. Speaker. I'd like to start by saying that I'll be sharing my time with the Honourable Member for Winnipeg North. We like to work as a family, and I know that my colleague is working very hard on these issues in the Prairie region because we know just how important rail safety is, as it is elsewhere in Canada. Now, I'm not going to bring out a host of statistics here today, Mr. Speaker, because we've heard a lot of talk about statistics.
I realize the Honourable Member for Bourassa indicated that he may wish to split his time. This being the third round, I wonder if the member is probably seeking unanimous consent, perhaps, to split his time in this particular slot. Is there unanimous consent for the member to split his time? Yes? Yes? Accordingly, the member may proceed and will split his time. The Honourable Member for Bourassa.
The Honourable Member for Bourassa. Well, it's a debate, Mr. Speaker, that has everyone so interested in it. It's one thing that we all agree on. It's amazing. The Honourable Member for Beauce was opposed to it earlier, but he changed his mind, so sometimes he too sees the light. Well, he sent me some signals to that effect, at any rate. Mr. Speaker, I was proud at the last committee meeting to move to accelerate the process and to proceed without amendment so that the bill could be brought back to the House. It's an issue that we all agree on, and I think it's because the health and safety isn't an issue where partisanship comes into play. Everyone worked very well together on this issue. It's something that should have been adopted with C-32, which unfortunately died on the order paper. We know that it started, in fact, in the other place as S4, and I'd like to thank my colleague, Senator Mercer, who did an admirable job there. Now, what's interesting about the bill is that there are a series of amendments that were put forth with C-32, which were agreed to almost unanimously, and that's thanks to the tireless work of the Honourable Member for Markham-Unionville, who worked on this. Now, we could talk about what more could be done. There are other things that could be done because safety is an important issue. We wanted to work because we wanted to have similar systems like the other modes of transportation have, and we know that in the airlines they have safety regulations, etc., and we wanted to complete that here. I'd like to thank members on both sides of the House. For example, the Minister, who answered my questions. They said he was a quiet builder earlier. He did use his voice to answer all of the questions that I put to him, and I thank him for that. As a former minister, I have always agreed with the idea of having authority to protect the quality of life for people. And I think that's what is at the heart of this bill, giving the minister the ability to intervene. Now, this is an authority that can be delegated, but instead of getting bogged down in administrative details, in bureaucracy, the representative of the people through the minister in a democratic society needs to have that ability and authority to step in, because prevention can save lives and it's essential. Now, it's clear that the bill, in summary, will improve oversight for Transport Canada. It will increase Transport Canada's abilities to enforce the Act in a punitive way by providing for fines, but it's not always sufficient, but that is important. It's also necessary to have someone who is responsible for safety. Another important aspect to my mind is the ability or the capacity to have a whistleblower, men and women who can comment without being victims of intimidation. Information is power. We often say that, be it in the private sector or in the public sector. So we need to have the ability politically, with a capital P, to step in. Now, we've gone through a process. There is certification involved, and to my mind, this is vital. It's a step in the right direction. Actually, in fact, several steps in the right direction. We've shown that we also had the ear of the government. But what worries me, Mr. Speaker, now, this isn't a panacea. We put forth amendments, they were adopted. However, we need to take things a little bit farther, a step farther, because there's the reality of urban areas and rural regions. And one of the questions I put to the minister was the issue of the responsible nature of parents, people who have a role to play in monitoring. We could build 12-foot high fences. We could build all kinds of things to prevent people from crossing the tracks, but people do cross anyways. Even in light of the urban environment and in certain rural areas as well, we'll need to redefine a pact, if you will, once this bill has been adopted, so that we can move on to a next stage, so that we can agree, so that all of the stakeholders can agree on safety. My colleague for Trinity Spadina earlier mentioned some of the aspects that could be added in order to improve and enhance safety and protection for passengers and workers. Today is May 1st, so I think it would be a good opportunity to point out that this is the International Day of Workers, and we need to think about railway workers today. And they do an admirable job. But it's also important, because we can't simply turn this into a jurisdictional squabble, say that's another sector, we won't get involved. It's provincial, it's a municipal issue. No, when we talk about safety, rail safety, when we talk about protection, it will be important to proceed with an agreement with which all members agree, the Federation of Municipalities, the large urban centers, so that where there are level crossings, Mr. Speaker, we can put in place the additional tools we need to protect people who often attempt to cross. Now, there is an additional tool that has been added that will cover off prevention. Rail is the safest means of transportation. Someone earlier mentioned the derailing in Burlington. Could we have prevented that situation?
Able to prevent those kind of incidents, it's important to provide all the tools to make sure that those individuals will be secure. So, Mr. Speaker, I believe that we had a fast track, and I propose a fast track at committee, because I think that we've been talking from both sides, not only this time, but even before the last legislature. It's a long process since 2006, but it's not the first time, of course, that we're talking about security and prevention. So this is why the Liberal Party of Canada will take their responsibility and will support that bill. What I believe, though, that's very important to mention, is that if everybody wants to work together, majority government or not, this is a great thing for democracy, because we were sending a true message that we all equal as representative and we have a role to play here. And the fact that we can put forward some amendments, that from the two chambers we can talk together and work for the sake of our communities, I think that's a good news today. And it is a model, it is a lesson learned. I think that we should take note of that process. And it's like the movie Field of Dreams. If you build it, they will come. So I think it's a wonderful process. I am very pleased with the answers that Transport Canada and the Minister provide to us on that issue. The Minister and I don't agree on everything, but I have to recognize that in that process that he delivered. We are looking forward to provide some new alternatives afterwards, because there's some other issue regarding alternatives for security. What's important, though, it's a living paper. We will have to see what will happen in the future, but I think that we have a framework here that that address some of the issues that we want. The fact that the stakeholders, like the unions, that everybody are at the same page. Of course, nothing is perfect, but I believe that we better have an imperfection realized than the perfection en attente, like we say. So thank you, Mr. Speaker. We will support Bill S4.
Questions and comments? Question commentaire.
Questions and comments.
Well, member for Algoma, Manitoulin, Kapuskasing.
I would just like to mention, as I start, that a railway is a very important part of Canada. And in my riding of Algoma, Manitoulin, Kapuskasing, I've been working fairly close with a group called CAPT from Sault Ste. Marie in order to try to bring passenger rail back to Northern Ontario. And I think with this piece of legislation, we see it as a move forward, really, to protect the railway system and to protect those who use it. And I think that it's actually a really, really important part of it. The issue here is that it's taken very long to get to the House here. And as you know, it was a bill that was actually tabled in the previous Parliament and was very close to being brought forward. So I just wanted to ask my colleague if he can talk maybe a little bit about the need and the expediency in moving this bill forward. Thank you.
Député de Bourassa.
The Honourable Member for Bourassa.
Now, well, let's do it. I don't have any problem. I fast-tracked it already in committee, so we can do it. I think that for the sake of that question, though, truly I believe that S4 is a matter of culture. And if we are pushing more forward those kind of process that we can achieve together, I think that, we all focusing on the same thing. We want to have a better quality of life, and I believe in the chemin de fer, in the railways, and this country has been built on that. So it is the link between all the regions. So I believe that if we're pushing forward those kind of policies and change the culture, I think that in every region we will be able to push forward.
Questions and comments? The Honourable Member for New Westminster, Coquitlam.
Thank you, Mr. Speaker, and I appreciate my colleagues' comments on this important issue. I wonder if he could comment about the current safety situation. I know in British Columbia we've had in the past number of years a number of rail derailments and accidents that have caused spills into waterways and have caused concern for communities. And wondering if he could comment on this important bill and how that perhaps could affect spills in the future. And as well, could he also comment about the, yes, we need to improve safety of rail transport in the country, but also there's the noise issue at crossings around residents, and if he could comment about how this bill might address some of those concerns that residents face. Thank you.
Honourable Member for Bourassa. Thank you, Mr. Speaker. Obviously,
there's two questions in what you're pushing forward. First of all, it's about maybe alternatives technology regarding the noises and all that. But through S4, I believe that it's also a matter of prevention. I think that railways are secure. Of course, we have derailments. I think we have sad accident, and we have all the time to make sure that it's open and transparent to understand what truly happened. But at the same time, I believe that that tool through S4, we better prevent than cure. of course, we have to address when there's a situation. But through that prevention tool, I really believe that through the certification process and the fact that we'll have all the whistleblowers or the people will be able to bring back all the intelligence that we need to understand what's going on that particular company or on the situation on the rail, that it will be a real good thing to do, and it will prevent maybe some incident. But we have to be focused and we have to be vigilant.
Resuming debate, the honourable member for Winnipeg North.
Mr. Speaker, and I thank my colleague, the member from Bourassa, for splitting his time with me. I do know that as our Liberal Party critic, the member from Bourassa has done an outstanding job in terms of just ensuring that there is this sense of urgency to see this particular bill pass through the system. And it's great to see, Mr. Speaker. It wasn't that long ago where we had it here before a second reading, and now we have it again today in third reading. And I suspect that we would love to be able to see it pass here today, and ultimately to continue on going through the system. It's important to note that this particular bill, Mr. Speaker, was in a different form prior to the last election, better known as Bill C-33, which then had its origins starting here in the House, because I know that there was some concern in regards to why it would have started off in the Senate. But, Mr. Speaker, I do think that there's a sense that this particular bill does need to be fast-tracked, primarily because we recognize just how critically important it is to the railway industry as a whole to make sure that we do what we can to improve rail line services throughout the country, Mr. Speaker. It's been a long time since there was an actual significant change to the Railway Safety Act. My understanding of that, Mr. Speaker, is that you'd have to go back to the 90s. I think it was 99 under the Chrétien government, where there was other amendments that were made of significance. And, I think a lot has happened over that period of time. And that is one of the reasons why we have the bill here today, is in recognition of the changes and a number of things that have been brought to the government's attention by a wide variety of stakeholders, Mr. Speaker. And I think it's worthy of noting that the stakeholders come from a fairly wide spectrum of individuals and groups that have actually been able to contribute to what we have here today. And it was interesting when I had opportunity to read through the bill and some of the notes that my colleague from Bourassa had provided me on this issue. One of the things that really came to mind, Mr. Speaker, is the whole whistleblower content, and how important it is to recognize that if you're working somewhere from within the industry or along with a train company, that you have the ability to be able to say, look, I'm concerned about the safety of X, whatever that X might be, and not be in fear of losing his or her job, Mr. Speaker. And to me, that is something that is good to see in legislation. I can recall when we had supported similar legislation with regards to whistleblower legislation in the province of Manitoba, and how well that was received, Mr. Speaker. I would suggest to you that the same principle applies here. And this way there will be reasonable issues that will be brought up because individuals that are working within the industry will now feel comfortable in knowing that if they have a concern that's related to safety, that they can actually bring it up, and they don't have to be in fear, Mr. Speaker, of ultimately being fired because of raising an issue that's related to safety. Well, that's just one aspect, Mr. Speaker, of the bill that we have before us, and why it is so important that we actually see this bill ultimately pass. Because at the end of the day, I believe all members here in the House, and we've seen that demonstrated through comments in regards to this bill, whether it was in committee stage, in second reading, or now in third reading, recognizing that this bill will, in fact, improve the overall safety of our rail lines. So I see that as a positive thing. It's also important, and I've already made quick reference to it, Mr. Speaker, to recognize that there are advisory committees that are out there. There are members from within our unions and others who have had the opportunity to provide input. I know we as a Liberal Party have had that opportunity and appreciate that that the government on this particular piece of legislation seems to have listened and responded in kind. And it's somewhat noteworthy, and I kind of put it tongue-in-cheek here, Mr. Speaker, and that is that the government does not require time allocation in order to pass this particular bill, which tells me that that's another good reason to believe that we're seeing more of an all-party approach at recognizing this as a good idea. And, Mr. Speaker, as well, we should, because the consequences of rail accidents, whether it's in our rural communities or our urban centres, is quite significant, both on the macro scale, where a derailment can cause a complete and total evacuation of communities, to the micro scale, where you have someone that's been hit by a train, Mr. Speaker, and causing fatalities, both of which happen far too often, Mr. Speaker. And at the end of the day, this is what it is that we're hoping to be able to deal with by passing Bill S4 today, Mr. Speaker. I want to emphasize the importance that this is not something in which it is just up to the federal government to pass this legislation, that there is a need to have cooperation amongst the different stakeholders, and the stakeholders I'm referring to here, Mr. Speaker, would be in regards to the municipal governments. I would suggest to you, Mr. Speaker, municipal governments, some of our rural communities all have a role to play. They're, in essence, the groupings that ultimately decide in many communities where there will be a flashing railway signs to railway arms that are lifted to accommodate the flow of traffic versus train traffic, Mr. Speaker. Provincial governments need to also step up to the plate. A lot of the monitoring that is done in terms of our highways is done through our provincial governments, Mr. Speaker, and they too also need to step up to the plate to try to deal with what they can in regards to their responsibilities. Obviously, Mr. Speaker, it goes without saying that our rail lines, thinking companies like CN, CP, Via Rail, and other rail lines that we do have that are operating on our tracks, obviously have the most significant role at playing in ensuring that whether it's the quality of the line, the quality of the vehicles in which they're using to transport goods is of a high standard, so that we can minimize any sort of damage, as I say, whether it's to the individual or it's to the community as a whole. Mr. Speaker, I have talked in the past about how the rail industry has played a critical role to the development of the city of Winnipeg and to many communities. And I'm not just saying Winnipeg, but I want to focus a bit of attention on the city of Winnipeg. I have had history with the rail lines in one form or another, primarily indirectly, Mr. Speaker, with the impact of the railway industry and how it's had that direct impact not only on my ancestry, I can talk about my grandfather, to what it is today in terms of how it divides communities, in geographical regions. The last time I had the opportunity to speak, Mr. Speaker, I talked about whether it was the Main Street, Salter Street, McPhillips, Arlington, in between those other two, and Keewatin and Route 90. All of those have either underpass or overpass which cross over the CP tracks. There are tens of thousands of people that live right around the CP yards, Mr. Speaker. So you can rest assured that the constituents that I represent have a vested interest in terms of this legislation and how important it is that this legislation passes, because it is all about rail safety. And I see that my time has expired, Mr. Speaker. In one of the questions I posed about the expansion of rapid transit and where rail lines could play an active role in that, and that's something maybe in the future I'll be able to talk about. Thank you, Mr. Speaker.
Questions and comments? Questions
and comments?
For Winnipeg Centre.
Thank you, Mr. Speaker. Mr. Speaker, there's a host of good reasons for relocating the CPR marshalling yards from the heart of the city that I represent to Winnipeg Centre. There's a desperate need for more green space, for more recreational opportunities, for inner-city affordable housing. But one of the most compelling reasons, and in the context of this bill we're dealing with today, is that since 1882, there's been a host of spills, collisions, and even explosions in the CPR marshalling yards, which are, in fact, the very heart and core of the city of Winnipeg. Now, it's been essentially the reason we have the tale of two cities, this great divide between South Winnipeg and the north end of Winnipeg, is in fact because in 1882 they decided to put these marshalling yards exactly where they are. Now, there's a Rail Relocation Act that if a municipality applies to the federal government, to the Minister of Transportation specifically, then for the reasons of safety or any other urban development and urban planning reasons, the federal government can and has paid for up to 50% of the removal of these inner-city rail lines so that the urban development can take place and the safety of those people living surrounding the rail yards can be protected. Would he agree that this Minister of Transportation should entertain an application from the City of Winnipeg to remove the CPR marshalling yards from where they currently exist out to the new inland port of Centreport so we can have an intermodal tripartite shipping and transportation hub called Centreport?
The honourable member for Winnipeg North.
Well, Mr. Speaker, the member from Winnipeg Centre and I share that as a common boundary. I'm on the north side of the tracks. He's on the south side of the tracks. And I think that the idea that he is talking about does merit further discussion and dialogue. What the member is talking about, no doubt, would have a very serious impact on the economics of not only Winnipeg's north end, but indeed the entire province of Manitoba, and it would have ripple effects, in fact, on the country. The amount of money that the member would be referring to would be likely in excess of a couple of $1 billion. We don't necessarily know in terms of, for example, where you would take the CP trucking industries or the CP trucking terminal to the other trucking firms that are located in the north ends who hook up to the trains, to just the size. You're talking about hundreds and hundreds of acres of land. It is an idea of exploring. I myself would definitely be open to it, the concept, and would welcome any sort of apolitical discussion as to where the City of Winnipeg, in cooperation with the provincial government, might be able to move in order to see if, in fact, it is feasible. And if it is feasible, I think it would be wonderful to see the federal government, especially if you think about Centreport and the potential of an economic generation this could be for hundreds, if not thousands, of Manitobans well into the future. Thank you, Mr. Speaker.
Questions and comments? We have time for a short question and response. The honourable member for Winnipeg Centre.
Well, my colleague from Winnipeg North's numbers are way out of line. I mean, when Lloyd Axworthy, the last time that Manitoba had a good senior political minister was, in fact, under Lloyd Axworthy. Well, that's not true. Reg Alcock as well pitched this idea. At that time, it was $80 million to be shared jointly to relocate the tracks. The vice president of the CPR said it would take us 12 years to tear up those tracks. Tim Sale at a meeting stood up and challenged the vice president of the CPR, saying, it took you 3 years to build the entire Canadian Pacific Railway from Thunder Bay to Victoria in 1880, blasting through the mountains with nothing but mules and pickaxes. How can you tell us it's going to take us 12 years to tear up a few tracks in the inner city of Winnipeg when you're tearing up tracks all over the whole prairie region at a mile a minute? It would take a matter of months.
Honourable member for Winnipeg North.
Yes. Mr. Speaker, I think that it's important to note, and I'm not going to necessarily question what it is that the member from Winnipeg Centre is saying. Winnipeg had the good fortune of having a brand new air terminal put in, several hundreds of millions of dollars, Mr. Speaker. I think that it's worthy in terms of us looking at what the actual cost would be. I agree with the member, Lloyd Axworthy, Reg Alcock, high-caliber Liberal members of Parliament, and I suspect that their numbers would have been very accurate for that time, and it would be something in which I would be most interested in pursuing. I look forward to future discussions with the member from Winnipeg Centre. Thank you, Mr. Speaker.
Before I call on the honourable member for York South Weston in resuming debate, I'll just let him know I'll need to interrupt him at the top of the hour, as we'll need to start statements by members. The honourable member for York South Weston.
Thank you, Mr. Speaker, and it's my pleasure to speak again on Bill S4, the Railway Safety Act, at third reading and report stage today. This is a bill, as others have mentioned, that originates from a previous Parliament, and the good member from Trinity Spadina had a lot to do with putting forward this bill in the first place, and I want to congratulate her and others who have worked on this, and congratulate those in the industry, in the unions, and in the safety agencies who have contributed to what will be a great improvement to this bill. Unfortunately, it's taken us 6 years from the commencement of the study, whether or not this bill needed to be improved, until hopefully today, when this bill will pass this House. And it's way too long. When we're talking about safety, 6 years is way too long for something as critical to Canadians as the safety of the railroads, as has been mentioned by several here. These railroads travel through dense urban areas. And so in order to ensure the safety not just of the railway workers and not just of the patrons of the railway, but of the people who live around these railroads, there needs to be a regimen in Canada that provides for the safe operation of these railroads, which this bill goes a long way to providing. Now, it doesn't go all the way, and I'll get into that in a few minutes. Every school child knows that railways built this country and that railways play an important role in transporting goods and people from coast to coast. We believe that railways should actually provide a much greater role in transporting people in this country and perhaps in transporting goods. Railways are a more efficient way of transporting people than cars. Railways are a more efficient way of transporting goods than trucks, and would take some of the pressure off our highways and cities if we were to move more goods safely using rail. However, I emphasize the word safely, and that's what this bill is in part going to do. There's 73,000 kilometers of track, and as the member from Trinity Spadina noted, the track has been removed. We've lost 10,000 kilometers of track as the railroads have moved out of transporting. The most recent loss of a railroad was between Ottawa, here in the nation's capital, and North Bay, the CP secondary line. So that now, and one of the reasons for removing that track was they wanted the steel. Not because it was an uneconomical piece of railroad, but because they needed the steel for replacing rails in other places. And it is a shame that that rail bed couldn't be used for public transit, continued to be used for the transportation of goods, because generally speaking, that rail line from here to North Bay goes through no cities. It doesn't go past any individuals' homes or businesses that would be endangered by a railway spill. Last year, railways moved some 72 million passengers and carried 66% of all the surface freight in Canada. So it's a very, very important part of the infrastructure of this country. However, there are some places where we're actually still building railroads. And we're building railroads in my riding in large numbers. We are expanding the capacity of a rail corridor between that runs through my riding from 40 trains a day to 464 trains a day. And that is one of the reasons that I'm anxious for this bill to pass, because I want to ensure that this government has some power to make sure that railroad is operated in a safe manner. Some of that railroad may, in fact, be exempt from this legislation, because some of that railroad the government will decide is not a federally regulated railway for whatever reason. I want to ensure that all of the railroads in Canada, whether they are passenger rail, freight rail, or, and we're talking heavy rail here, not little light rail streetcar systems in some cities, but the heavy rail systems in Canada are all run in a safe and efficient manner. According to the Transportation Safety Board, in 2009 there were 1,081 rail accidents, including 68 main track derailments. If rail traffic continues to grow as anticipated, and the rail companies tell us that they will grow at roughly the same rate as inflation, so 3% a year, so in 10 years it'll be 40% more rail traffic than today, the potential for accidents will increase. Now, the rail industry believes that the way to prevent accidents at rail crossings, in particular, is to remove the rail crossings. And their idea is just close roads. That's the easiest way to prevent rail crossings. We won't have any cars crossing our tracks. Our tracks will reign supreme. That doesn't work in many urban centers in this country. And there is some money, a very little amount of money, about $12 million a year, according to the parliamentary secretary for the Prime Minister, that is set aside by this government to remove rail crossings in this country. And I assume that means by putting in grade-separated rail crossings so that the roads go either under or above the rail corridor, or the rail corridor is dipped below or above the road. The trouble is, $12 million might pay for half of one of those. And there are hundreds and hundreds, probably thousands, I don't have the number in front of me, of railroad crossings in this country, each of which has the potential for a fatal accident. In fact, there was a fatal accident on the railroads in Toronto just 2 weeks ago, where a pedestrian was killed on a rail bed in Toronto. We don't need any more of those. And that's for sure. Keeping people and trains apart should be an important part of what this Minister of Transportation strives to do in the implementation of this Act. One of the new key points in this legislation is the requirement for railways to obtain a certificate for operation that must include a safety management system acceptable to Transport Canada. That is a key element of this legislation, that safety certificate, that safety management system is acceptable to Transport Canada, that Transport Canada actually understands and accepts that whatever railroad is applying for a certificate to operate has in place measures that will prevent accidents, that will prevent the overwork of their employees, and that's why the unions are in support of this, that will prevent trains from colliding with one another. Now, we recently had such a collision involving a passenger train in Burlington, Ontario, in which no one's really certain yet of all the causes, but speed was definitely a factor. This train went way too fast through a switch. The switch was rated for 15 kilometers an hour, and the train went through at about 60. And it derailed, and there was loss of life, and there were injuries. What will prevent, in large measure, many of these kinds of accidents is something called positive train control, where the speed of the train is not just controlled by a person watching lights, because that's how it works today, the same way it worked 160 years ago. A person runs a train by watching lights to know when they should go slower and when they can go faster. A positive train control, which is widespread in all of the world except in North America, and is already in place in some parts of the United States, but is not present in Canada, is a system whereby the train's speed is controlled externally. That if the switch is closed and the train should slow down, the train speed is controlled automatically if the train operator doesn't do it him or herself.
Makes sense.
Makes all kinds of sense, but it's not a system that this government is prepared to impose on the railroads yet. Why? We would immediately start preventing accidents. Yes, it would be an expense to the railroads, but it's part of the cost of doing business. Those railroads that operate in the United States will already have to comply with that positive train control system in the U.S. So they have to build their infrastructure already to deal with positive train control. Both CN and CP and Via Rail, which travel both across our border, will have to do this. Yet, for some reason, this government isn't prepared to impose that in Canada. And I wonder why we always wait. Why we always wait for the accident or for the problem to occur before we act, when most people can see this would be, Mr. Speaker, a good addition to the rail safety system in this country. There were a number of problems identified with rail safety, not having to do directly with this bill, but instead having to do with the oversight that Transport Canada applies to rail safety in this country. And the Federal Commissioner of the Environment and Sustainable Development in 2011 report identified serious deficiencies in the transport of dangerous products. Now, it's up to the minister to ensure that his officials in Transport Canada are actually enforcing the laws that they already have, having to do with safety. And if they're not, there's something wrong with the system. And what this commissioner stated, that there were 53% of the files that he examined had instances of non-compliance. And of those files, an astonishing 73%, nearly three-quarters, there was little or no corrective action taken. So we have a law that says, here's how you transport dangerous goods. We have a system in which Transport Canada is to actually monitor and enforce that law. We have a commissioner who looked at it and said, whoa, they're not enforcing it. And we have silence from this government. We don't seem to care or don't seem to know how to enforce the laws we already have. Bill S4 contains a lot of very generous provisions towards the minister who will make decisions about how this law is to be implemented. And the minister needs to take the most protective and most precautionary stance possible with his officials in Transport Canada and with the safety of Canadians, because to do otherwise would be to be derelict in his duties. And that's what we're saying about the Transportation of Dangerous Goods Act, which is already in force, is that if it's not being enforced by the officials that need to enforce it, by the minister and his staff, then could S4 have the same fate? We can't sit here pass laws that nobody enforces. The Conservatives believe that laws are to be enforced and to be enforced to the letter of the law. We heard that yesterday from the Minister of Foreign Affairs, that it's no matter where Canadian companies operate, they are to abide by the laws. The same should be true in Canada, but it's up to the government to enforce those laws.
That's right.
Now, this law, this new S4, has quite serious penalties for failing to comply with the legislation. Those penalties are now administrative penalties. The minister does not have to take a company to court. They can impose a penalty without actually having to file suit against the individual for failing to an individual company or an individual for failing to comply. We would hope that the ministry will actually impose those sanctions when they find violations. It's no good to have a bunch of sanctions in a law if you don't apply them when there are violations. And we hope that corrective action is only necessary very, very rarely. But we want that corrective action to be taken when it's necessary. We don't want a situation in which the government, as they apparently have done with the transportation of dangerous goods, ignores the law or ignores the enforcement of the law. The other portion of this law that deals with the emissions of pollutants into the air. And this is of great interest to the residents in Toronto who, when faced with a rail corridor that will have 464 trains per day, or a train every 90 seconds, a diesel engine going past that's 4,000 to 5,000 horsepower diesel, emitting huge clouds of black smoke, people want to know that something will be done to limit that pollution. This law provides mechanisms whereby the minister can, in fact, demand that these emissions be reduced, and he can demand that those emissions be curtailed, and he can demand that those emissions be regulated and monitored. And it will be up to the minister to actually impose those regulations and to actually enforce them. And the people of the City of Toronto are watching this with some great interest, because one of the issues that has raised a huge storm is the issue of the amount of pollution that comes from railroad engines. When people looked at it, because they didn't look at it until somebody said we're going to have 460 of them, they discovered that there are carcinogens in that exhaust, that there are nitrous oxides in that exhaust, that there are particulate matters in that exhaust which cause grave harm to individuals. And to increase it by tenfold without also putting in some kind of limits has got people in my riding and in the other ridings in the City of Toronto demanding that trains be made electric. In 1908, in the City of New York, the use of fossil fuel burning trains was banned. And I see my time has run out. So I'll continue that thought when I come back.
You're the best, Mike.
The honourable member for York South Weston will have 5 minutes remaining for his speech when the House next resumes debate on the question, and of course the usual 10 minutes for questions and comments. Statements by members. Déclaration de député. The honourable member for Mississauga East Cooksville.
Mr. Speaker, this weekend I had the pleasure of attending the 50th anniversary of Florida Public School, an elementary school in the riding I'm proud to represent, Mississauga East Cooksville. The school's gymnasium was packed full of students, parents, staff, alumni, and former staff. I was privileged to see performances by some of the school's many very talented students, all of whose parents must be very proud. Floridale is located near the heart of Cooksville, one of the most diverse parts of Mississauga, and its motto is "Diversity, our strength," which sets a great example to its students and to us all, and embodies the spirit of Canadian multiculturalism. I'm happy and proud to offer my congratulations to Caroline Saucy Grant, the principal, and to all her staff on this milestone anniversary, and I look forward to seeing many more classes of Floridale students move on from strength to strength and work toward a brighter future.
The honourable member for Montmagny-Lillet, Kamouraska, Rivière-du-Loup. Mr. Speaker, thank you. 100 years ago, a group of sisters from France came to Sept-Îles, Rivière-au-Tonnerre, Havre, Saint-Pierre, and Natashquan. This is when the community of the Sisters of l'Enfant Jésus de Chauffaille started to work in education in Quebec. A few years later, they went to Rivière-du-Loup, where they participated in the establishment of many health and educational institutions. They were present in Saint-Antonin and La Pocatière in my riding. We owe to them the creation of the Notre-Dame de Fatima Hospital in La Pocatière and Collège Notre-Dame de Rivière-du-Loup, an institution they still support. They are active in Cambodia, Japan, Chad, and France. They are always attentive to the material and spiritual needs of all without distinction of race or religion. They are known for their compassion and solidarity. I'd like to take this solemn moment to thank the nuns of the Sœurs de Saint-Jésus de Chauffaille for their 100-year commitment to Quebec, and I am a spokesperson for all the communities that benefited from their dedication and wish them a happy 100th anniversary.
Mr. Speaker, according to the Canadian Mental Health Association, 20% of the population will experience a mental disorder at some time in their lives. This means that every family in Canada will in some way be affected. The good news is that people with mental illness can and do get better. The vast majority recover. Mr. Speaker, next week is Mental Health Week, and I wish to take this opportunity to thank all the professionals and volunteers across this great country, including our local CMHA branch in Clonal Lake Country, Sheila Turner and her team, who work tirelessly to help our communities achieve better mental health for all. Mental health is everyone's challenge. It is important for each of us to reach out and share our personal stories with those who may not believe things can get better. Mr. Speaker, they can, and with our support, they will. Thank you.
The honourable member for Vancouver, Quadra.
May is Asian Heritage Month, recognizing the rich history of Asian Canadians and their important contributions to the settlement, development, and character of Canada. Canadians with Asian roots are a critical gateway for Canada's connection and trade with fast-growing Asian economies. La diversité culturelle.
Canada's cultural diversity feeds our social, political, and economic wealth. The Asian Heritage Month is an ideal opportunity to celebrate various Asian cultures as well as their contribution to the growth and prosperity of our country.
Riding of Vancouver Quadra, Canadians experience and learn about the history and contributions of Asian Canadians through dozens of celebrations, including the annual Explore Asian Festival and a variety of cultural, culinary, and sport exhibitions. I encourage all Canadians to participate in celebratory events and join me in appreciating our country's vibrant Asian Canadian community.
The honourable member for Vancouver South.
Mr. Speaker, Budget 2012 marked the beginning of an invigorated and deeper relationship between Canada and the Asia-Pacific region. In the past few years, our government has been strategically expanding cultural and trade agreements with countries in this region to create jobs and economic growth. The opportunities for Canada in this dynamic region are impressive. Asia-Pacific markets have an economic growth rate that is 2 to 3 times the global average. Canada is maximizing opportunities for entrepreneurs through innovative trade, investment, air transport, and science and technology agreements. This is important for all Canadians, but especially the people of British Columbia and the residents of Vancouver South. We are the gateway to the Asia-Pacific. Our country's commitment to one project, one review, and our engagement in ongoing free trade discussions will provide the foundation needed to build Canada's future through economic growth and job creation. Thank you, Mr. Speaker.
The honourable member for Thunder Bay, Rainy River.
Mr. Speaker, I'd like to take this opportunity to invite MPs and constituents in Thunder Bay, Rainy River to join me in a 48-hour trip around the world. The Thunder Bay Multicultural Association is hosting the 39th Annual Folklore Festival this weekend at Fort Williams Gardens, and it promises to be one of the most colourful and entertaining events of the year. Each year, the association gathers people from diverse backgrounds and cultures to share their collective experiences and give our community a taste of life from around the world. Music, dancing, food, arts and crafts from more than 20 regions of the world are represented by no less than 40 different ethno-cultural groups. Please join me in thanking Janetti Juma and the more than 1,000 volunteers who assist in the planning, performing, preparing of site decorations, and who offer our wonderful community such a rich and vibrant experience each year. I hope to see everyone there. Thank you, Mr. Speaker.
The honourable member for Fundy Royal.
Thank you, Mr. Speaker. Our government is committed to supporting victims of crime. Last week, our government introduced a bill to amend the criminal code that would see convicted offenders held more accountable to victims of crime by doubling the victim surcharge that they must pay following their crime. By doing so, our government is helping to provide the support victims of crime need. We also introduced the federal income support for parents of murdered or missing children to help families cope with the death or disappearance of a child. With the introduction of this support benefit, parents can take off the time that they need following such a tragic event. The support is a benefit of up to 35 weeks to help ease the financial difficulty that these parents are coping with. Our government will stand with victims of crime and all Canadians through our commitment to ensuring that our streets and our communities are safer. We will continue to take significant steps towards holding criminals accountable and delivering justice for victims. We were elected on that commitment, and we will continue to deliver.
The honourable member for Calgary West.
Mr. Speaker, in 1998, just 1 year after I was first elected, Canada ranked 27th on the Index of Economic Freedom. Now in 2012, Canada ranks 6th for economic freedom, so says the Wall Street Journal. Now, I should share credit with my Conservative colleagues, though, for I needed their votes to cut taxes and support free trade agreements. These fine Conservatives reduced the GST from 7% to 5% and just repealed the gun registry. But I'm not done yet. I sense my Conservative colleagues like the taste of freedom, and so we shall do more. I hope for more free trade agreements coming to the floor of this House. Budget belt tightening has only just begun. Just imagine what us Conservatives can do with several more years to go before the next federal election. We intend to streamline environmental regulations so the jurisdictions don't overlap. Just think of all the jobs we can create, removing people from unemployment. So much done, yet so much to do. You gotta love economic freedom, Mr. Speaker.
The Honourable Member for Chicoutimi-Le-Fjord. Mr. Speaker, I rise today to welcome 7 students who are participating in the first annual Rainbow Day on Parliament Hill. This is a nonpartisan event organized by the NDP LGBT caucus in partnership with Jurors Vision. It's an excellent way for students in the LGBT community to witness the excellent work done by gays and lesbians on the Hill.
Their lives have been touched and shaped by the scourge of both homophobia and bullying. Despite this, and maybe because of it, they have the inner strength to stand up for what they believe in. I look forward to the day when one of them joins me as an MP here on the Hill. The LGBT
people represent Canadians at all levels of government. With our allies, we fought for same-sex marriage and for the inclusion of sexual orientation in the Charter of Rights and Criminal Code. Today, there are many battles still to wage, but we can improve things.
The Honourable Member for Pickering, Ajax Pickering.
Thank you, Mr. Speaker. For 6 long years, the Royal Canadian Navy, as you know, the Canadian Merchant Navy and the Royal Canadian Air Force were key participants in what came to be known as the Battle of the Atlantic. Through the efforts of these brave Canadians, ships carrying troops and essential supplies were able to reach Britain and our other allies. As war raged in Europe, Canadians risked their lives to bring convoys across the Atlantic battling extreme weather and navigation conditions, as well as U-boat attacks, to provide a lifeline to Allied forces in Europe. Monsieur le Président, la victoire...
Mr. Speaker, the victory for this battle had a price. Over 4,600 Canadians and Newfoundlanders lost their lives. Today, we're paying tribute to the courage, sacrifice, and exploits of these Canadians who fought and died during the Battle of the Atlantic in order to bring us peace and freedom.
Committee, we heard about the recent exploits of the North Atlantic Treaty Organization, the most successful alliance in the history of humanity. We owe its success in many ways to the sacrifice of those who participated in the Battle of the Atlantic. Thank you, Mr. Speaker.
The Honourable Member for Parkdale High Park.
Mr. Speaker, this year marks a significant milestone for an organization that has enriched the lives of Ukrainian youth the world over, including in my riding of Parkdale High Park. This year, the Ukrainian youth organization PLAST celebrates the 100th anniversary of its founding. Taking inspiration from the scouting movement founded by Robert Baden-Powell, Alexander Tisovsky saw that Ukrainian youth could only benefit from an organization that would help them learn the value of teamwork, honesty, community building, and good works. For the last 100 years, the Ukrainian community has seen the benefits of the teachings and experiences gained through PLAST, with active chapters in 8 countries, including 6 cities throughout Canada. I'm proud to represent a riding in the city of Toronto, which is home to PLAST's largest Canadian chapter. I stand united with my New Democrat colleagues in wishing PLAST members, past and present, heartfelt congratulations. Silno, Krasno, Obereshno, Bistro.
The Honourable Member for Wetaskiwin. Prince Edward Hastings.
Thank you, Mr. Speaker. Regrettably, when it comes to helping seniors, the NDP are all talk and no action. Since 2006, we have taken concrete action to ensure that retirement income is sustainable and is there when Canadians need it, including introducing the pension income splitting, introducing the age credit, eliminating federal income tax for 38,000 lower-income seniors, increasing the GIS earning exemption, introducing the PRPP, enhancing the CPP, providing the largest GIS top-up in 25 years by introducing automatic renewal of the GIS. Unfortunately, the NDP voted against all of these important measures. Having taken action to assist seniors today, we need to ensure future generations can count on their retirement benefits when they need them the most. Our government is taking action to ensure sustainability of old age security for future generations. Clearly, the NDP's lack of a plan for old age security is a threat to future Canadians' retirement savings.
The honourable member for Westmount Ville Marie.
Mr. Speaker, I rise today to express my sincere condolences to the family of Jean-Guy Moreau following his death. A member of the Order of Canada, Mr. Moreau profoundly marked our culture, especially by imitating people from Georges Brassens to Gilles Vigneault, Jean Drapeau, and René Lévesque. A multidisciplinarian, Jean-Guy Moreau innovated and developed a style of entertainment that never went out of style. We remember when he had shows with Robert Charlebois in the Boîte à Chansons in the 60s. What a path since then. His remarkable talent gave a large audience a glimpse into the people that he imitated. I wish to rise today to recognize his contribution to the arts and following up on what his children said, that is, if he's leaving us, it's for a bigger show. And I salute his contribution that will be an inspiration to future generations. Thank you.
The honourable member for Prince Albert.
Mr. Speaker, yesterday big union bosses at Canada's largest public sector unions imposed hikes on their members with new levies to fund direct political action and support NDP tax and spend policies. We know this additional levy will be used for partisan purposes, including political ads, multi-million-dollar strike funds, pension bonus for the big union bosses. These big union bosses and the NDP are still being investigated by Elections Canada for their illegal campaign donations. Our government does not think that these big union bosses and their friends in the NDP should be forcing public servants to pay more money to fund their partisan political campaigns, which are only meant to serve the big union bosses and the NDP. Unlike the NDP and their big union bosses' friends, our government will ensure that Canada's economy continues to be where it belongs, at the front of the pack.
The honourable member for Outremont. Mr. Speaker, today we're underscoring International Workers' Day. This is an opportunity to celebrate the immense contribution of all workers who work untiringly to make our society a better place to live. But over the past year, we didn't have much opportunity to rejoice. This is a year during which this government imposed a lockout on postal workers and then a back-to-work legislation. What a great example of bad faith.
This government has declared open season on workers' rights. They've trampled on collective bargaining rights, mismanaged the EI fund, rolled back the clock on pay equity, and missed every opportunity to help protect workers' pensions. New Democrats take a different approach, from people working on construction projects to harnessing our natural resources. From store clerks to the public servants, workers are the backbone of our economy, yet many feel under threat.
Today, we're taking a moment to underline this contribution and to reiterate our commitment to making Canada a more prosperous country for everyone.
The honourable member for Mississauga-Brampton South.
Mr. Speaker, yesterday the NDP House Leader expressed the need for more decorum in the House of Commons. Our government welcomes any initiative to improve decorum in the House, but before criticizing others, he should take a look at his own party. Virtually every day, the NDP makes over-the-top characterizations of government policy, unwarranted personal attacks, and exaggerated claims. From name-calling to profane language, we have seen it all from the NDP in this Parliament. In fact, many NDP MPs have had to stand up and apologize for inappropriate statements in the House. If the NDP are so committed to decorum in the House of Commons, surely these opposition MPs could find a better manner in which to conduct themselves, a manner that does not result in name-calling, profane language, and baseless smears. We will genuinely continue to ensure decorum within our own party. Will the NDP truly commit to doing the same?
Oral questions. Questions orales. The Honourable Leader of the Opposition.
Mr. Speaker, when scandal breaks, the first question needing an answer is, who knew and when did they know it? On the F-35s, the Minister of National Defence has provided an answer. He said that the whole Cabinet knew about the full costs of the F-35 and knew about the two sets of books, one for internal use and another for the public. The Prime Minister is head of Cabinet. Why did the Prime Minister allow his ministers to present figures to Parliament that they knew were wrong by over $10 billion?
The Right Honourable Prime Minister.
Once again, Mr. Speaker, the Leader of the NDP is simply mixing apples and oranges. The figures that he's quoting are figures, of course, that have to do with the acquisition and sustainment. The operating costs are a different figure. But, Mr. Speaker, there, of course, are not two sets of books. The Auditor General, no one else has said so. The Minister has not said so, and no such thing is true.
The Honourable Leader of the Opposition.
Budget officer used. Le ministre de la Défense a admis.
The Defence Minister admitted that Cabinet was indeed aware of the F-35 costs. He said that a Cabinet had approved this approach, an approach that has been criticised both by the Parliamentary Budget Officer and by the Auditor General himself. Instead of insisting on defending a minister who has lost control and a process that is out of control, why doesn't the Prime Minister act like a good public administrator for once by relaunching the entire CF-18 replacement process according to the rules this time? The Right Honourable Prime Minister. Mr. Speaker, what the Minister said is that it is the Cabinet that determined the budget for the procurement of these aircraft, and the government is clear that it will respect this budget to ensure a better surveillance and transparency of the process. We responded to the recommendations of the Auditor General, and the Department of Public Works has also already announced measures in that regard.
There has to come a time when common sense prevails over stubbornness on the F-35. The plane is years late. Billions over budget, doesn't meet Canada's requirements. The Auditor General said there was no due diligence. Years have already been wasted on a rigged process. Responsible civil servants are now reportedly recommending a reset of the entire process, something the NDP has been suggesting all along. The Conservatives have accepted to change the name of the F-35 Secretariat, and it's a start. But will the Prime Minister also confirm that the F-35 is not the only option to replace the CF-18?
The Right Honourable Prime Minister.
Well, once again, Mr. Speaker, the Leader of the NDP asserts a whole bunch of statements in his preamble and attributes these to the Auditor General, which were things the Auditor General never said. What the government has said is responding specifically to the recommendation of the Auditor General. The government is going beyond those recommendations and ensuring that we re-examine all aspects of this to ensure that before we spend any budget, because we have not yet spent any budget on acquisition, before we do that, we make sure we have all the answers that the Cabinet requires.
The Honourable Member for St. John's East.
Thank you, Mr. Speaker. Of course, the Auditor General also said that they made a decision in 2008 on the F-35 without any supporting documentation. Mr. Speaker, having one set of books for internal use and another for Parliament is simply not acceptable. Now, I know the Minister of Defence is having a tough time under fire for his role in the F-35 fiasco. He testified yesterday that it was Cabinet that approved the misleading cost estimates. My question for the Minister of Defence is as follows. Does he stand by his comments that all of his Cabinet colleagues were aware of the misleading statements about the costs of the F-35?
The Honourable Minister of Defence. Mr. Speaker, as is the case with the Leader of the Opposition, the preamble is all wrong. All of those premises are wrong. What I was responding to was questions about process, which is exactly what I answered. The process is such that it flows through Cabinet. Now, we have taken decisive action. We have put in place a comprehensive plan to review future procurement. As the Prime Minister has stated, there's been no money spent on acquisition. And, Mr. Speaker, we will continue, under the guidance of Public Works, to look at this project for the replacement of the aging CF-18s. The Honourable Member for St. John's East.
Mr. Speaker, this minister has a poor track record when it comes to giving clear answers. He told the House that no money was spent on the F-35, yet $335 million has been spent, and somehow or other there's a freeze on this non-existent spending. He told Parliament that the F-35s would cost $75 million per plane, and his own officials testified at committee today that these planes will actually cost a lot more. DND says they're full speed ahead on F-35 procurement, but Public Works is renaming the Secretariat. What's really going on here, Mr. Speaker?
That's a good question. The Honourable Minister of National Defence.
Well, once again, Mr. Speaker, as is so often the case with this member, a fact-free question. And, Mr. Speaker, what I have just said is that we will continue to move forward with the guidance of Public Works in a comprehensive review of this important procurement. There is a process now in place that will inject greater transparency, greater communications with Parliament and the public, Mr. Speaker, independent oversight, and this Secretariat will provide the answers that are needed by Canada, by the country, to ensure we have the right aircraft at the right price for our country.
The Honourable Member for Toronto Centre.
Mr. Speaker, another amazing contradiction was revealed today in the Public Accounts Committee when the Deputy Minister of National Defence said, and I quote, the Auditor General, quote, got it wrong when the Auditor General discussed budgetary matters in front of the committee last week. I'd like to ask the Prime Minister, we're now in an extraordinary situation. The government says they accept the report of the Auditor General, and they accept the conclusions of the Auditor General as well as the recommendations. Great. Mr. Fonberg, the Deputy Minister of National Defence, says he rejects the findings of the Auditor General. Who speaks for the Government of Canada with respect to the findings of the Auditor General?
The Right Honourable Prime Minister.
Well, once again, Mr. Speaker, that's a complete miscategorization of the Deputy Minister's remarks. The government has been very clear that it accepts the report. In fact, as the Minister of Public Works has made clear, the government has proceeded with an oversight committee and a multi-step process to ensure that before we spend any money on acquisition, that we have all the questions answered that need to be answered.
The Honourable Member for Toronto Centre.
Mr. Speaker, this is not a trivial matter because it has to do with the overall position of the Government of Canada with respect to what the Auditor General said. The Auditor General said not all costs have been fully divulged. He said that to compare the training costs on the F-35 with the training costs and the maintenance costs on the CF-18 was completely unrealistic. He said there was no accounting for the question of attrition and the number of jets that would be lost over the life cycle. He said that life cycle accounting had to be done. We now have the Deputy Minister of National Defence saying to the people of Canada that the Auditor General is wrong. Who speaks for Canada? That's the question we're asking with respect to this matter.
The Right Honourable Prime Minister.
Of course, once again, Mr. Speaker, that is simply not an accurate representation of what the Deputy Minister of National Defence said. Mr. Speaker, the government has accepted the recommendations of the Auditor General. In particular, his core recommendation that the government take a re-examination of all of the costing and reassess that. We're going to do that and other things to ensure we have full transparency and facts before proceeding.
Honourable Member for St. Laurent-Cartierville. Mr. Speaker, not only does the Conservative Senate reform, not only would it result in the same parliamentary impasse as in the United States, not only would it be unjust, whereas Alberta and BC, which would be underrepresented in this elected Senate, but in addition, C7 is unconstitutional because changing the character of the Senate would call for the agreement of all provinces, which Quebec would go to court for. Why does the government not abandon this ill-conceived reform and thus avoid useless and costly constitutional disputes?
The Right Honourable
Mr. Speaker, the Alberta government has just held public consultations for future Senate reform. This is a decision of the Alberta government, and our government will respect the will of the Alberta public by appointing these senators to the positions when we have the opportunity.
Member for Parkdale, High Park.
Mr. Speaker, the Conservatives' budget choices are frightening. Billions of dollars for the F-35 fiasco, whereas the Conservatives are cutting food inspection, border security, and the surveillance of water quality. All essential programs for Canadian safety. These irresponsible cuts have nothing to do with the budget. So when will the Conservatives clearly tell us what the price will be to pay? Honourable President of the Treasury Board. Mr. Speaker, the 2012 Economic Action Plan focuses on growth and economic prosperity. It maintains a low tax plan by focusing on a balanced budget. We will use fair means to find savings and reduce the deficit by reducing the size of the federal public service by 4% over 3 years.
To chop OAS. They never said a word about chopping food inspection or border services. Conservatives are now moving forward with billions in cuts, but keeping Canadians in the dark about exactly which services they will now have to do without. When did the Conservatives become so afraid of accountability?
Hear, hear.
The Honourable President of the Treasury Board.
Let me correct the record on several fronts, Mr. Speaker. 70% of the savings that we have found and have been identified are operational efficiencies, Mr. Speaker. And we are using the accepted practice. The honourable members opposite seem to care about collective bargaining agreements. So do we. And so we are informing the employees in a reasonable manner before we in fact, that's the first thing we do. And then of course, we inform the public. That's what we do in our estimates and in our quarterly reports. So all of that information is public, and of course, it is good for the country to have a leaner, more affordable government.
The honourable member for Halifax.
Mr. Speaker, let's talk about the consequences of these cuts because the Conservatives refuse to do so. Not satisfied with gutting the environmental review process, the Conservatives are now targeting national parks. Over 1,600 jobs will be cut at Parks Canada. That means shorter seasons and limited access to the parks and historic sites. The indirect consequences of these cuts will be that the tourism industry will lose major income. Why are the Conservatives attacking the most beautiful natural sites in our country? The Honourable Minister of the Environment.
Mr. Speaker, this government is committed to our national park system. In fact, no other government has done as much to protect our natural spaces as this government. At the same time, Mr. Speaker, Parks Canada is doing its part to address deficit reduction. While Parks Canada is making changes, Mr. Speaker, those changes are to ensure that we have appropriate staff numbers when the tourists and visitors attend.
The honourable member for Halifax.
The minister is ignoring his own findings because last year the minister released a report showing that Parks Canada contributes more than $3 billion a year to our economy, and most of that is to small and local businesses. Canada's national parks bring Canadians together and they draw tourists from around the world. And yet first, Conservatives are gutting the environmental assessment process, and now employee jobs are on the chopping block at Parks Canada. Has the government calculated the impact of their reckless cuts on the tourism industry for Canada?
The Honourable Minister of the Environment.
Well, Mr. Speaker, I compliment my colleague for her accurate quotation of my remarks last year, and in fact, we do cherish the contribution that our national parks and other protected spaces do make to the GDP every year, indirectly and indirectly more than $3 billion. And because of that, Mr. Speaker, we are also committed to increasing the total square kilometres of protected space in Canada. Since 2006, our government has added an area roughly equivalent to the size of Germany.
The honourable member for Dartmouth Old Harbour.
Thank you, Mr. Speaker. Well, it's clear this government just doesn't seem to get it that cuts to parks, cuts to environmental protection hurt local economies.
Hear, hear.
Many coastal communities depend on the fisheries, and they depend on the laws that protect fish habitats. But the fisheries minister is shirking his responsibility. He's abandoning our fishing industry while giving the oil industry greater leeway to pollute and destroy fish habitats. Why is the minister putting our oceans, our lakes and rivers and our fishing communities at risk?
The Honourable Minister of Fisheries and Oceans.
The member opposite is totally wrong in his questioning. Mr. Speaker, what we are doing, we're refocusing our efforts away from farmers' fields and focusing on fish and fish habitat protection. As I said yesterday, Mr. Speaker, this has the support of many people. I might like to mention one quote from the Saskatchewan Association of Rural Municipalities, who says municipalities have been paying inflated costs to accommodate the provisions of this Act for over 10 years. We thank the federal government for these changes. Thank you, Mr. Speaker.
The honourable member for Dartmouth-Cole Harbour.
Thank you, Mr. Speaker. You know, this is not about farmers' fields and drainage ditches. Nobody's buying that line, not even farmers, Mr. Speaker. If that were the government's aim, they could have introduced minor changes to the Act in order to deal with that problem. But instead, they've written amendments that, by the minister's own admission, will throw the doors open to major industrial projects at the expense of our fisheries. When will the minister stop trying to hide his attack on fish protection behind law-abiding farmers?
The Honourable Minister of Fisheries Nation.
Mr. Speaker, and of course, Canadians are concerned about the way that DFO operates in certain jurisdictions, and certainly farmers, fields, cottage owners, municipalities are all important, Mr. Speaker, and we're listening to them. I might give another quote from the Federation of Canadian Municipalities, who said, municipal leaders have consistently called for common sense reforms in Ottawa that deliver better results for Canadians. The federal government has pledged to give the Fisheries Act more teeth by introducing enforcement provisions where none have existed before and giving regulatory new tools to keep invasive species from entering Canada. Thank you.
The honourable member for La Salle-et-Mort. Both the industry and communities that depend on the fishery will pay for the Conservatives' insistence on attacking the Fisheries Act. Mr. Speaker, more cuts, more problems. The decision to slash StatsCan's budget by 8% is troubling. In addition to budget cuts, the agency must deal with a budget reduction of other departments that fund its studies. We need statistics to understand, for example, how economic cycles evolve. How can the government do without statistical data that is so important for our economy? The Honourable Minister of Industry. Mr. Speaker, Canadians gave us a strong economic mandate, and our job is to ensure that Canadians' taxpayers is spent as effectively as possible. Mr. Speaker, Statistics Canada has identified savings in order to function more effectively while continuing to offer statistics and high-quality services for Canada. That's what the Canadians want us to do. The honourable member. They don't realize that Statistics Canada won't even have enough money to buy newspapers. For 3 years, StatsCan's budget has been frozen. These cuts will cause them to lose $54 million in operating budget, and thus the chief statistician said that a year of sacrifice is to be expected. The Conservatives like to control figures. We saw this with the F-35s, but they cannot control what comes out of a neutral study. That's why they want to reduce the budget of Statistics Canada to better control the message. The Honourable Minister of Industry. On the contrary, Mr. Speaker, on May 2nd, we received a very strong economic mandate, and what Canadians are expecting is a responsible management of public funds. And Statistics Canada, like other federal departments, identified potential savings. And thus our duty, Mr. Speaker, is to ensure that those efficiencies are applied while offering high-quality services to Canadians. And, Mr. Speaker, the majority of the public is with us on that.
Honourable member for Scarborough.
Well, Mr. Speaker, I know the Conservatives don't like using evidence in decision-making, but chopping StatsCan won't make the inconvenient facts go away. Yet, Mr. Speaker, the government's reckless cuts are marching on. The Conservatives are now shutting down the Joint Emergency Preparedness Program and have cut all funding for training courses at the Canadian Emergency Management College. This will leave many local emergency workers without the training and critical equipment they need to respond to everything from earthquakes to chemical spills. Why are the Conservatives making cuts that could spell disaster for small communities that rely on these programs to train their emergency preparedness workers?
And the Honourable Minister of Public Safety.
Mr. Speaker, most emergencies in Canada are local in nature and are managed by municipalities at the provincial or territorial level. Public Safety Canada works with all of the local organizations in order to coordinate that. We are not putting Canadian safety at risk. Indeed, we continue to enhance it in various ways.
The honourable member for King's Hants.
Mr. Speaker, yesterday we asked the government how much money it would save further to the changes made to old age security. The government refused to give us that information. It is saying that the chief actuary will provide this information to members only after the Budget Implementation Act has been adopted, not before. Why is the government hiding this information on old age security? Canadians have the right to know. The Honourable Minister of Human Resources. Mr. Speaker, the fact is, it is our government who is ensuring that there will be an old age security system for future generations. That is exactly what we're doing. It is very important to understand, Mr. Speaker, that the Canadians want us to act now. There are now 4 people who are supporting retirement, who are supporting those who are retired, and now there are only 2 people. That's why we need to make the changes.
Mr. Speaker, that's still no answer. Under the law, the government must tell MPs how much a bill will cost before a vote. Last year, the Conservatives were found in contempt of Parliament because they failed to do that. Now they're doing it again. Canadians know how much the changes in OAS will cost them personally. Why won't the Conservatives say how much the OAS changes will save the Treasury? Is it because the numbers show that the experts are right, that there is no sustainability problem with OAS as it stands now, and we do not have to increase the age to 67?
The Honourable Minister of Human Resources.
Mr. Speaker, the Honourable Member asked how much it would cost individuals. Mr. Speaker, anyone who is currently collecting old age security benefits, anyone who's near retirement, it won't cost them a cent. There will not be any change for them. But if we want to make sure that future generations have access to any OAS at all, we do need to make changes. And that's exactly what we're going to do. And, Mr. Speaker, the Chief Actuary agrees with us, and even the PBO agreed with us several months ago.
The Honourable Member for Ottawa-Vanier.
Monsieur le Président, selon le commissaire aux langues officielles, le processus de dotation du poste de vérificateur général l'an dernier n'a pas tenu compte des exigences de la loi. Les candidats identifiés sur la liste...
Alors, je pense qu'il y a...
I think there's a problem with the interpretation. Does the interpretation work now? Can the Honourable Member start again? I think that proves my point, Mr. Speaker, in a very eloquent fashion. According to the Commissioner of Official Languages, the staffing process for the Auditor General last year did not take into account the requirements of the Act. The shortlisted candidates and the candidate who was ultimately recommended were supposed to comply with a criterion that was deemed essential, that is, to be bilingual, English and French, at the time of assuming their duties, not afterwards. Will the Conservative government restart the process and this time honour the requirements of the law? The Honourable Minister of Canadian Heritage. Obviously, Mr. Speaker, we intend to protect the French fact in Canada, respect the Official Languages Act, and always choose the best candidates for the position. And in this case, we're talking about the Auditor General. I am sure that the opposition is pleased with the quality of the work he has done to date, and I am sure that the opposition will continue with the process that we are using to hire a qualified and bilingual candidates in this process.
The Honourable Member for Bruxelles-Laprairie. Mr. Speaker, new charges have been laid against 3 individuals, including a former manager of a division at the Canada Revenue Agency in connections with allegations of extortion from restaurant owners. With the Conservatives, the problems are just accumulating at Revenue Canada. For years, the RCMP now has been investigating allegations of corruption and bribes. It's starting to be a bit much. Is the government again going to say that it isn't responsible? The Honourable Minister of National Revenue.
We are responsible, and that's why charges have been laid. This is a very serious issue,
and we will not tolerate this type of misconduct. This investigation, as the entire House knows, has been ongoing for some time, and yes, charges have now been laid. As the member opposite should know, it would not be appropriate to comment on an RCMP investigation that's ongoing or on the court proceedings. But what I can assure this House is that the integrity of our tax system will be upheld by this government.
The Honourable Member for Brussels-Laprairie.
This government has been asleep at the wheel. The Canada Revenue Agency now has hundreds of cases of serious misconduct, everything from destruction of documents to corruption. And today we learned that the 3 former CRA employees have been charged with extortion, threatening restaurant owners. Now that charges have been laid, can the Minister explain how she let this happen under her government?
That's right.
The Honourable Minister of National Revenue.
Thank you, Mr. Speaker. Well, this issue goes back more than a decade. I can assure this House that the government does take all these allegations very seriously. CRA employees are in a position of public trust, and we do demand professional and ethical conduct. Mr. Speaker, this is why our government has increased our budget for internal investigations by 127%, and we've nearly doubled the number of internal investigators.
The Honourable Member for Timmins, James Bay.
Speaker, the Minister of International Cooperation has still not explained if she understands the difference between appropriate and inappropriate behavior. For example, when she racked up $17,000 in limo bills, she tried to hide $8,000, which would suggest she knew that was inappropriate. Same when she blew $5,000 at the Junos and was forced to pay back thousands. You'd think she'd learned the lesson then. So the question is, will she explain why she only pays the money back when she gets caught?
The Honourable Government House Leader.
Mr. Speaker, our government has been clear. Our objective is to reduce expenditures to taxpayers. Ministers have done that by 15% compared with our predecessors. That's why, in the case that we're discussing here, the minister has repaid the expenses and apologized to this House.
The Honourable Member for Timmins, James Bay.
But, Mr. Speaker, she's not explained why the Prime Minister has allowed her such a loosey-goosey interpretation of the ethics, and why should she be trusted at this point? The question here is, instead of playing this cat-and-mouse game, why doesn't she just stand up and tell us what other lavish spending she's hidden away from the taxpayer, or is she simply practicing her apology until the next time?
The Honourable Government House Leader.
Mr. Speaker, again, our objective is to respect taxpayers' dollars. Our government came with a mandate to increase accountability, to restore accountability, to reduce taxpayers' expenditures, and as a result, we've reduced the expenditures of ministers' offices, including the components of travel, reduced by 15%. In the particular case, the minister has repaid the inappropriate expenses.
The Honourable Member for Brampton-Springdale.
Mr. Speaker, Canadians are concerned about crime. They gave our government a strong mandate to keep our streets and communities safe. Gang activity and recruitment is a growing problem. Youth are often targeted by criminal organizations to join their ranks. This is one reason why I introduced Bill C-394, Criminal Organization Recruitment Act. This legislation will send a strong signal that seeking to recruit youth into organized crime gangs is a serious offence that deserves tough sentences. Can the Minister of Justice please inform this House about the government position on my legislation?
Great question.
The Honourable Minister of Justice.
First of all, I want to thank the Honourable Member for Brampton-Springdale for introducing this legislation and all that he does on behalf of his constituents. We too are concerned about those who would actively attempt to recruit youth into gangs and other criminal organizations, and this is why I'm pleased to announce to the House that we completely support the member's efforts to crack down on those who would recruit people into criminal gangs, Mr. Speaker. This is consistent with our efforts to crack down on criminals and to stand up for law-abiding Canadians, Mr. Speaker. We're getting the job done, and I thank the honourable member.
The Honourable Member for Trois-Rivières. Mr. Speaker, tonight thousands of Avios workers and their supporters will be marching in the streets of Montreal. They will not be asking for special treatment or a check from the government. They will simply be asking Ottawa to enforce the law and stop making phony excuses to avoid doing so. They want to be treated with dignity and respect by this government. Mr. Speaker, will the government show some humanity and act, or will it continue to ignore its own legislation? Parliamentary Secretary. Mr. Speaker, let's be honest about what the New Democrats are saying. They think that taxpayers should fund a bailout for a business that has already wasted $1 billion, that was not prepared to come before a parliamentary committee, and that has no prospects for success. We are not going to spend Canadians' and taxpayers' money on this kind of bailout. Instead, we are going to continue to build a strong economy that will have jobs for everyone. Honourable Member for Rosemont-La Petite Patrie. Mr. Speaker, the government needs to enforce the law and save jobs. The government is claiming they are reforming employment insurance, but they are actually launching a frontal attack against workers across the country. They want to force the unemployed to take any kind of job at all. Even if you're not qualified and you don't want to leave your children behind for weeks, too bad, we're going to cut you off. It's a lack of respect and a slap in the face. The government thinks that they can play police and condemn everyone to cheap labor. The Honourable Minister of Human Resources. Mr. Speaker, it is very simple. He is quite wrong. What we are going to do is to ensure that everyone who wants to work will have access to information about jobs that are available so that they can apply. But, Mr. Speaker, everyone should do better by working rather than by not working. And we want to make sure that those who can work and want to work will be able to do so. Honourable Leader of the Opposition.
Member for Trinity Spadina and I last year asked why Gary Freeman, who lived in this country peaceably for 40 years and had several children, was not being allowed back in the country. The answer was an event that happened in Chicago in the 60s, and he had served a short jail time. They said because he's not a Canadian, he was not allowed back in. We just learned that the British criminal Conrad Black is going to be allowed in despite serving a second term in federal American penitentiary. Why the double standard?
The Honourable Minister of Citizenship and Immigration.
Well, Mr. Speaker, thank you for the question. Matters such as this are a matter of personal privacy. I cannot comment on specific cases without a privacy waiver. Having said that, I can advise the House that with respect to this individual, I indicated to my department that I would not have any involvement in an application from that individual, and that his application will be treated by highly trained, independent members of our public service. But in terms of the individual that he raises, I understand that member has made interventions on behalf of a convicted police murderer in the United States, seeking his entry into Canada. Mr. Speaker, we believe decisions on admissibility should be made by public servants, not by politicians.
The Honourable Leader of the Opposition.
Facts are simply wrong. Gary Freeman lived in Canada for 40 years, has several children here. We met the press with Natursa Cello, his wife. It's a clear case of a double standard. One for an American black man from Chicago, another for a British white man coming out of federal penitentiary in Chicago. Deux poids, deux mesures. Ça, c'est la honte.
This is a double standard, and shame on the Conservatives.
Order. The Honourable Minister of Citizenship and Immigration.
Outrageous.
That statement says a lot more about the Leader of the Opposition than it does about Canada's fair...
Shame on you, Thomas. Pathetic. Shame on you. Shame on you. Smearing the public service.
Order. The Honourable Minister has the floor.
Decisions on admissibility are made by highly trained, independent members of Canada's professional public service. They are not made by politicians. They should not be made by politicians. I know that member and his party like to politicize these matters. They want to make a former Vice President of the United States inadmissible to Canada, but they want us to welcome convicted cop killers. Mr. Speaker, we think that the law should be consistently applied by independent, highly trained public servants, not by political demagogues.
Hear, hear. Order. The honourable member for Vancouver Quadra.
Speaker, apparently this government just doesn't like facts. First, it cut the long-form census and compromised years of data collection. Now it's slashing half of the jobs at Statistics Canada. But StatsCan provides unbiased demographic data that's essential for small businesses, for new Canadian success, for public services that benefit all Canadians. Why does this government make decisions based on belief and ideology rather than evidence? And will the government stop its war on information and reverse the StatsCan cuts?
The Honourable Minister of Industry.
Mr. Speaker, Canadians gave us a strong economic mandate, and I must remind the member of the third party that this means ensuring that taxpayer dollars are spent as wisely and efficiently as possible in all government departments, and this is including StatsCan. StatsCan, Mr. Speaker, developed these savings in order to operate more efficiently while continuing to offer high-quality statistics and services to Canadians. This is what Canadians are expecting for.
Honourable member for Vancouver Centre.
Mr. Speaker, the Minister of Health refuses to answer questions on her draconian cuts to Aboriginal health, questions she calls unacceptable. What is unacceptable is her disregard for the concerns of Aboriginal leaders themselves. National Inuit leader Mary Simon calls her cuts unconscionable. The president of Paktutit, the Inuit Women's Association of Canada, says Inuit women will suffer a direct and negative impact as a result. Does the minister also think that it's unacceptable for these organizations to criticize her cuts?
Right. The Honourable Minister of Health.
Mr. Speaker, I take no lessons from that party in terms of how they handle health care in this country. Mr. Speaker, the answer is very simple when it comes to the National Aboriginal Health Organization. Through the annual general meeting of the AFN, there was a resolution put forward by those memberships to dissolve NAHO. At the same time, I received a letter from the 3 elected leaders of NAHO asking me to dissolve the NAHO organization because it was dysfunctional. Mr. Speaker, we listened. Why can't those members listen to the elected Aboriginal leaders of this country? Thank you.
The Honourable Member for Châteauguay-Saint-Constant. Mr. Speaker, this government continues to tell Canadian veterans who have defended their country with courage that they will have to fend for themselves. The decision to close 9 Department of Veteran Affairs offices will just add to the distress of too many veterans and their families who need help. Meanwhile, we have learned that the number of suicides among military personnel has increased in 2011. How can the government tell veterans to find help on the Internet instead of talking to a real person? The Honourable Minister, I would like to congratulate my colleague on his appointment as the critic for Veterans Affairs, which is very important. We are going to be protecting and defending veterans across the country and add services where they are needed. We need to help veterans, and they can do so by supporting this budget. We are cutting red tape, and the opposition should help veterans by supporting this budget.
Nonsense. He's now telling veterans on Prince Edward Island and that of Cape Breton, in order to see someone, you have to go all the way to Halifax to meet someone. And now what's even worse, Mr. Speaker, they're cutting down offices where they're to the point now where when you call 1-866-522-2122, the veterans number, they will get a private company called Quantum. This private company gets over $600,000 of tax money to say Veterans Affairs Canada. Why is this government allowing a private company to disguise itself as Veterans Affairs Canada? And why are they so ignorant towards the needs of our heroes of this country?
The Honourable Minister of Veterans Affairs.
Well, it's good to have two critics, Mr. Speaker, because I can answer more clearly the question, Mr. Speaker. We are proud to work with Service Canada, who have employees here in this country, Mr. Speaker, actually in the Atlantic, serving the Canadian for general information. And of course, excuse me, the kindergarten, I'm speaking. Okay.
The Honourable Minister has the floor.
Thank you, Mr. Speaker. I just want to add that any veterans, Mr. Speaker.
Order. Order. The Honourable Minister of Veterans Affairs has the floor.
Thank you, Mr. Speaker.
Order.
Any veterans who's receiving
Affairs has the floor.
Our department will be served by our great expert at the department, Mr. Speaker. Support budget 2012. We are maintaining benefits. We are cutting into red tape, Mr. Speaker, and we will continue to do so. Thank you.
The Honourable Member for Don Valley West.
Mr. Speaker, Canadians were troubled when they heard the story of David Chen, an immigrant restaurant owner who was charged for defending his property. This has captured the attention of many, especially new Canadians. Thankfully, our government is committed to clarifying the laws regarding self-defense and has taken action by introducing citizens' arrest legislation. Can the Minister of Immigration please update this House on the progress we have been making with regards to this important piece of legislation?
The Honourable Minister of Citizenship and Immigration.
Thank the member for his question, Mr. Speaker. This is a serious matter. Mr. David Chen is a hard-working grocer in downtown Toronto who I'm honored to call a friend. He loses up to $70,000 a year in his hard-earned property to shoplifters. And once, Mr. Speaker, he detained a repeat shoplifter, and Mr. Chen, the victim of the crime, was charged. And, Mr. Speaker, this brought about a recognition that we needed to modify the law to clarify that shop owners have a right to use appropriate authority to protect their property. I'm pleased to see that the Lucky Moose Bill passed through the House of Commons today and shortly will be law, so that shop owners can use reasonable and appropriate authority to protect their property.
The Honourable Member for Charlottetown.
Mr. Speaker, today the federal court ruled in favour of Dennis Manouge and other veterans who have been waging a court battle with the Conservatives over pension clawbacks. The government was wrong to litigate in the first instance, and now the court has ruled. Will the Minister of Justice commit today to not appeal this ruling and leave these veterans alone?
The Honourable Minister of National Defence.
Well, Mr. Speaker, I believe the member opposite is a lawyer. He would know that this decision has just been rendered today by federal court. The Department of Justice, the Department of National Defence will review this case, Mr. Speaker, and until such time it would be inappropriate to comment further.
Honourable Member for Acadie Bathurst. Mr. Speaker, the Official Languages Act is in the crosshairs of the Conservatives. In his report on the appointment of the Auditor General, the Official Languages Commissioner concluded that the government should never have hired a unilingual candidate. Such a person would be unable to provide equal service in both official languages. Mr. Speaker, why is the government not complying with its own hiring criteria, and why is the government not complying with its own legislation that was passed here in this House? The Honourable Minister. As I have just said in response to a Liberal Party member, the government is certainly going to protect French and English across the country, and the French and English Fact across Canada. We will continue to make the appointments that are needed for Canada.
Mr. Speaker, while the NDP joins big union bosses and their fellow socialist comrades today to rally for a return to reckless, unsustainable, big government deficit spending, including higher punishing taxes, our Conservative government is focused on helping Canadians by promoting jobs, the economy, and protecting taxpayers with prudent and responsible spending. While our plan is positive and forward-looking, the NDP would take Canada back to an era of protectionism and restrictive trade practices. Can the Minister of State for Finance please explain how Economic Action Plan 2012 will support Canada's
The Honourable Minister of State for Finance.
Thank you, Mr. Speaker, and I thank the member for Etobicoke Centre for that question. Mr. Speaker, our Conservative government remains focused on what matters to Canadians. That's jobs, growth and long-term prosperity. Although nearly 700,000 more Canadians have jobs, Mr. Speaker, the global economy remains fragile. That's why in Budget 2012 we've taken action to enhance trade and investment relationships with fast-growing economies, Mr. Speaker. Not only that, we're reducing red tape that will generate savings for our manufacturers by providing a single window of business opportunity.
The Honourable Member for Thunder Bay, Rainy River.
Thank you, Mr. Speaker. We know in Northern Ontario that the economy is suffering under this government's watch. But in the March budget, this government chose to cut money that's used for what? Economic development in Northern Ontario. They've taken $1 billion from the forestry sector, millions more in tourism and marketing grants that went to small towns like Dryden, Atikokan, Gore Bay, Red Rock, Terrace Bay, and many others. Now, where's the common sense, Mr. Speaker, in cutting economic development money for a struggling region during a fragile economic recovery?
The Honourable President of the Treasury Board.
Let me thank the honourable member for the question and welcome him to his new critic responsibilities. Indeed, right after the budget, he was claiming over Northern Ontario airwaves that we had actually eliminated the Federal Economic Development Initiative for Northern Ontario. He had to backtrack on that, so I'm glad he's learning his portfolio now. I would say to the honourable member that since April 2006, FedNor has invested over $263 million in support of over 1,200 projects throughout Northern Ontario. FedNor continues to do that, looking for great projects that will grow jobs, grow economic opportunity for Northern Ontario. That's what our regional economic development agencies do across the country, and the honourable member should be proud of that. I know he was proud when we announced the cyclone.
The honourable member for Haute-Gaspésie et La Madeleine. Mr. Speaker, today is May 1st, International Workers' Day, and I would like to call our attention to those who have lost their jobs and who have been affected by the downturn in the economy. They are going through a difficult period, and the government should listen to their concerns. The government is doing nothing to improve access to employment insurance, despite the many requests made to that effect. It is refusing to make any improvements to the program, and it seems to consider the program a burden. Why is the government not doing the right thing and transferring employment insurance to Quebec, as has been called for by the Quebec Unemployed Council and the Parti Québécois? The Honourable Minister. Mr. Speaker, there are many workers that don't have the qualifications they need, and that is why it is important to make sure that they get the training they require. We have invested a great deal of money over the past 6 years to help those who are unemployed to get new jobs and to develop the skills that they need today and tomorrow.
Question period for today. Je voudrais signaler aux députés la présence à la tribune.
I'd like to point out the presence in the gallery of the Honourable Madeleine Dubé, Minister of Health of New Brunswick.
The Honourable Member for Toronto Centre is rising on a point of order.
Point of order. Mr. Speaker, in light of the answer given by the Prime Minister today to my questions with respect to the testimony in the Public Accounts Committee, I wonder if I could have unanimous consent to read the relevant section of the testimony in that committee into the record, Mr. Speaker.
Does the Honourable Member for Toronto Centre have the unanimous consent of the... There doesn't seem to be consent at this time. Orders of the day, order du jour.
Senate orders, government bills, Senate, resuming debate and third reading of Bill S4, an act to amend the Railway Safety Act.
Resuming debate, there are 5 minutes left for the honourable member for York South Weston, and I am sure that he would appreciate all his colleagues leaving the chamber if they need to carry on conversations with their other colleagues, so that the House can hear what he has to say. The honourable member for York South Weston.
Thank you, Mr. Speaker, and I appreciate this opportunity to continue my discourse on Bill S4. As I suggested earlier, the new S4 contains some amendments to the environmental protection portion of the bill, which gives some more power to the minister to enforce environmental protection. And as I started to say earlier, one of the things that has residents in urban areas, and in particular in Toronto, significant worry is the exhaust from diesel trains. And I started to say earlier that New York City was, in fact, 104 years ahead of Canada, because in New York City they banned fossil fuel burning vehicles, trains, from Manhattan Island in 1908. And since that time, only electric vehicles have been permitted to operate in Manhattan, electric vehicles on trains, to the point where they actually have to change engines on the way in. That results in a much cleaner and more manageable environment in the city of Manhattan. The citizens of Toronto would like the same courtesy, and as such have determined that they are pushing very hard that GO Transit in particular, but ultimately all the other train operators, CN and CP and VIA, use electric vehicles wherever possible. I note that the environmental regulations are stronger currently in the United States than they are here, and I hope that the minister will in fact make the Canadian railroads adopt Tier 4 at least for all of their engines in 2015, as is the case in the United States. The other piece of safety worry for residents in the city of Toronto, of course, is derailments. And derailments, one only has to witness the kinds of destruction that take place when there are derailments in the area adjacent to those areas. In the city of Toronto, those rail corridors traverse significant residential populations, and the rail industry, in fact, requested that this bill be amended to allow them to have some say over how close houses are built to the rail corridor. But what in fact is happening in Toronto is that the rail corridor is being moved closer to the homes by the rail company themselves. So it beggars belief that they would actually do this, but that's what's happening. In fact, in one case, CP Rail actually expropriated the backyards of several homes in order to move their rails 20 feet closer to the homes. If a derailment occurs in that piece of my riding, the devastation will be unimaginable. So what does the rail company do? The rail company now is building a crash barrier wall to protect, but it's not going to protect the homes. The crash barrier wall will be between two sets of rail corridors, so that if a crash happens, the CP freights won't damage the CN and VIA rails. But there's nothing being built to protect the homes, Mr. Speaker, and I think this is the kind of thing that this bill should give the minister the power to look into. Why are we protecting against the crash if the crash is towards a rail corridor rather than towards the homes? There is a school that is right on that rail corridor. The play yard is literally 5 feet from the rails. Now, when that was criticized, the answer we got from the rail company was people shouldn't build schools so close to a rail corridor. The trouble was the school was there first, and they just didn't know that. Finally, Mr. Speaker, one cannot talk about rail safety without saying something about the deteriorating infrastructure of our railway system. My colleagues in the NDP from coast to coast are seeing rail service being closed for safety reasons and as a result of deteriorating track and lack of adequate maintenance. Clearly, track maintenance is an issue in rail safety, and there clearly needs to be significant investment in rail infrastructure across Canada, not only to improve rail safety, but to continue to provide and hopefully expand rail service, both in terms of passenger service as well as freight service. In particular, in the Gaspé and on Vancouver Island, there are passenger and freight services which have been closed very recently as a result of deteriorating rail infrastructure. These services were handed to local authorities by the big rail companies in what was almost an unfit state, and these local authorities do not have the funds to keep them up the way the rail companies did, and therefore we need federal action to create rail safety on these and other such rail corridors. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. L'honorable député de Gaspésie et de la Madeleine.
The honourable member for Gaspésie et de la Madeleine. Thank you, Mr. Speaker. I do appreciate the intervention by my colleague, especially when he closed his remarks and talked about something that is very concerning to people in my riding, the fact that the railway is degraded to the point where service is simply not offered. There's no more train in the Gaspé, and that's of great concern to us. The federal government is not coming forward to provide the assistance necessary for the improvements needed to restore service. So my question for my colleague is this: what could the federal government do? How could the bill before us be improved to have greater improvement and repair of the degradation of railways throughout Canada?
Weston.
Thank you for the question. The Rail Safety Act on its own would merely determine that a railroad became unsafe, but having thus determined it, I think it is incumbent upon the federal government to determine the best mechanism for reinvigorating or making that section of rail useful again to the public. In the case of the Gaspé and in the case of the Vancouver Island passenger rail service, both of those corridors are now owned by small local community groups. They're not owned by the big, powerful rail companies who kind of handed them off knowing that they were in a deteriorating state. And I think the federal government needs to assist with the maintenance of these rail corridors financially. I'm not suggesting that they need to pay all of it, but there needs to be a share. When a rail corridor is owned by small local municipalities, there needs to be a sharing of that responsibility both federally, provincially, and locally. And there needs to be some recognition by this government that those infrastructure improvements are for the good of Canada and for the good of those communities.
Yeah. Questions and comments? The honourable member for Sudbury.
Thank you, Mr. Speaker, and I'd also like to thank my honourable colleague for his intervention in his speech today. In Northern Ontario, many of the communities in my riding, well, the riding of Sudbury was actually, the city of Sudbury was created when the rail line was coming through back in the 1800s. So rail has actually been an important economic link for most Canadian communities right across the country from coast to coast to coast. It linked coast to coast to coast for many of us. And now what we've seen is this government not investing in the infrastructure to support rail, and what we've seen is the safety of rail and rail service decrease. We've lost rail in Northern Ontario, which could be the life hub for many to get from community to community. Passenger service has stopped because the rail has become so unsafe. There's not enough infrastructure in place. I know my honourable colleague has spoke to that. I'd like to hear his comments and to hear what can we do to continue to make rail safe and get people using the trains once again. Thank you, Mr. Speaker.
The honourable member for York South Weston.
It's a very good question, and it's a very good point that this the rail actually built this country in a large measure and opened up cities like Sudbury and the community that I come from, Weston. owes in large measure its size and diversity to the fact that the rail corridor was encouraged to come through the town back in 1852 with the building of a huge trestle over the Humber River. That trestle is still in existence. The original bricks, the original pillars at the bottom of that trestle are still there exactly as they were put in 1852. They just don't build them like they used to. But your point is that what does this government need to do to encourage the use of passenger and freight rail as the medium of choice for travelers? For passenger rail, the service has to be frequent, it has to be convenient, and it has to be on time and reliable. And that currently is not always the case, certainly in a place like Northern Ontario, where it's difficult to get around by any other means. The rail is essential. But in the case of freight rail, what we have to realize is that's the way we have to move. We have an undertaking to reduce our greenhouse gas emissions by 75% by 2050. That's not going to happen unless we move an awful lot of our goods transport away from trucks and onto trains. And the only way we're going to manage all of that is if this government is part of the investment into our rail system in Canada.
Questions and comments. The Honourable Member for Winnipeg North.
Thank you, Mr. Speaker. My question to the member is he made reference a great deal in terms of the communities. And there is no doubt that one of the most significant vested interest groups that is there is the communities that are built around these rail lines because of many potential things that could happen as a direct result. We would argue ultimately that one of the things that needs to happen is you have to ensure that all of the different stakeholders are involved, the different levels of government, the industry as a whole, and so forth, in order to protect those industries. Do you see anything in future legislation of this nature that would enable some sort of a structured system that would allow for that consultation in the name of protecting our communities?
The Honourable Member for York South Weston.
I think in the discussions leading up to this amendment to the Railway Safety Act, there were a lot of consultations with a lot of stakeholders, including community groups and transport activists and unions and other interested stakeholders, including the railroads. And that's a good sign. That's a good sign that this government and that in the minority parliament that preceded this one, there was a sense of collaboration that was necessary in order to make this bill into the best bill it could be at the time. Now, these bills generally get reviewed every 5 years, and it's now been 6 since this review was started. So we really should be starting the review last year of this bill. But I don't know when they're going to start a review. But there are always improvements that can be made to safety. There is a need for voice recorders in the cockpits or in the cabs of all the locomotives. There is a need for positive train control, and those things should be a part of this government's agenda. They're not currently, but we can certainly hope that we will put enough pressure and that the kinds of communities that we're talking about will put enough pressure on this government to make this a real part of its agenda going forward.
Any comments? Questions and commentaires. The Honourable Member for Nickel Belt.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for his speech on the railways. In Ontario, with the short-sighted vision of Northern Ontario of the Liberal Party in Ontario, they are cutting back the Ontario Northland, which connects a lot of Northern Ontario regions to Southern Ontario. They're going to dismantle that railway and sell it off. Put more buses on the road, put more transport on the road. Can you tell me how this is going to affect not only the communities, but also the people that are using the highways in Northern Ontario?
The Honourable Member for York South Weston.
The demise of the Ontario Northland is something that should be prevented. The Ontario Northland is a vital part of the North's transportation infrastructure. Northern Ontario is subject to bad weather for, 9 months of the year, perhaps, maybe 10, and highways are just not safe. They are not the safe way to get around in Northern Ontario, and by moving the Ontario Northland out by getting rid of it, we are removing a safe option for the transportation of people and potentially of goods. That should not close. This government, the Conservative government here, should be looking at rescuing the Ontario Northland from the ravages of the Ontario Liberal government.
Resuming debate, may please the débat, the honourable member for Welland.
Thank you, Mr. Speaker. Now I will be splitting my time with the fabulous member from Vaudreuil-Soulanges. Mr. Speaker, I'm happy to participate in this debate on S4. And first of all, I'd like to congratulate a couple of my colleagues. My colleague from Western Arctic, who always referred to be called the member from the Northwest Territories rather than Western Arctic, but is indeed, his riding is the Western Arctic. And of course, the member from Trinity Spadina, who's been working on this transport file for quite some time, along with that member from the Northwest Territories, who in the last Parliament was very adroit in making sure that many of the suggestions that ended up in this bill were amendments into previous legislation to make sure that actually we got a transport bill that came forward that addressed the needs of the safety concerns of the passengers on VIA and indeed the workers who have to travel in those trains, who work on those trains, who are the engineers, the locomotive engineers, the brakemen, etc., who work on those trains, who deserve, especially today in the International Workers' Day, that deserve the safest place that we can make for them to work. It's an obligation, I think, that we all share, that we should do that. So we're pleased to see this bill come forward. It contains, slightly over 80% of the things we would have liked to have seen. Now, obviously, there are a few other things that we would like to see in it. And it strikes me as ironic, Mr. Speaker, as I look through the history of where things were at over the number of years. There was a report published, and it was called the Advisory Panel's Final Report. And the actual title of the report was Stranger Ties, a Shared Commitment to Railway Safety. I thought that quite striking that using that title, Stranger Ties, because for those who like the rail, those who travel by rail, or those who are just perhaps model railroaders or just interested, as I once was as a kid, as a train spotter growing up in Glasgow because we knew more about trains than we did about anything else. Ties, obviously, are the things that are on the bed of the rails that actually keep the rails firm, to make sure that those rails don't actually come apart. It is the ties, as they call them, those pieces of wood on a rail bed holding the rail, making sure that it's the exact space apart. It's not going to be flimsy and come apart. The spike doesn't leave and so forth. So I actually thought this report in 2007, A Shared Commitment to Railway Safety, Stranger Ties as it was called, I actually found it rather ironic that it took almost 5 years to get us to where we needed to be in 2007. And so as we look at this, Mr. Speaker, we look at the things that have been requested from workers and requested from passengers, which is a safe railway system. The railway system in this country is indeed a safe system. But as in every system we have, there are always things that we can do to make it safer. And that's indeed what New Democrats have been pushing, not only in this Parliament, but in subsequent Parliaments, to ensure that those who travel by rail have a safe passage, and those who work on the rail will indeed go to work and come home safely. And as we know, Mr. Speaker, there are episodes where that doesn't happen. You know, the train that actually leaves my municipality, it starts in Niagara actually and takes itself through the Niagara Peninsula to Toronto, as was pointed out by my colleague from Trinity Spadina, derailed just outside of Burlington. An absolutely tragic accident, but as my colleague pointed out, one that was preventable if indeed Stranger Ties in 2007's report had indeed been implemented in the sense of with the suggestions that my colleague from Western Arctic and Trinity Spadina have suggested, that accident may indeed never would have happened, and 3 men may not have lost their lives, and 3 families may not be suffering through the fact that they no longer have fathers and husbands and sons and uncles and brothers. They may still be with us, but unfortunately That's not what happened. So in the memory of those 3 men who lost their lives in that derailment in Burlington, Mr. Speaker, we need to do everything within our capacity to ensure that that indeed doesn't happen again, that trains that are perhaps not going or are going a little faster than they maybe should be going, when they come to a switchgear, when they're changing tracks, which is a dangerous thing for any train. That's one of the hazards they face when they're switching at a switching piece to a different track. Speed is of the essence and is very critical. That there are indeed mechanisms out there. We don't have to reinvent the wheel, so to speak, when it comes to health and safety. We can actually have mechanisms that allow that train, if it is approaching that switch too quickly, it can be automatically shut down in the sense of slowed up to make sure that it makes the switch appropriately and doesn't come off the rail, as we saw in Burlington. And so, Mr. Speaker, it's unfortunate that isn't part of that bill, but it needlessly shouldn't stop this bill. So it wouldn't be something that's an impediment, in my view, in voting for this, but it needs to be thought about in the future that we need to do this in a more comprehensive way. The same goes for where we may not absolutely find out what happened. That derailment happened and those 3 gentlemen are no longer with us to tell us what happened. Clearly the passengers aren't sure what happened either. They were obviously in the carriages behind, weren't obviously in the locomotive. That's an obvious thing. The passengers don't ride there. But there isn't anyone to actually tell us from the locomotive what exactly happened. And yet, this is a transport system that carries large amounts of people, and in some cases carries more people than what an airplane might. But yet in an airplane we have voice recorders in a cockpit that tell us what it is the co-pilot and the pilot are saying at all times during that flight. And in the case of a crash, heaven forbid that there is any, but indeed there have been over time, we now have a voice recorder and a data recorder that can actually tell us and help us to understand what happened and help us, just as importantly, to understand how to avoid it. And really that's the piece of all of this, is sort of the crux of it, if you will. If we had that voice recorder in that locomotive in Burlington and in others that have crashed, we may indeed, especially when we saw loss of life and we have no independent witnesses who were actually in control of the locomotive. If we had that voice recorder, we could then piece together exactly what happened. What were they saying at that moment or the moments leading up to it? What could they tell us to make sure that we don't repeat the same thing again? That's a critically important piece of information that is missing in this safety bill, and it's unfortunate it is, and I would look to the government hopefully to make sure that somehow that gets done in the very near future. But we do want to make sure, Mr. Speaker, that we get this piece of safety legislation done, because ultimately it is about taking people on the rail. And as my colleagues have pointed out, there are literally hundreds of thousands of people who travel by rail across this country. I had the great privilege once when I was a younger person, headed to Edmonton, to the University of Alberta. I spent some time in the lovely city of Edmonton, University of Alberta. I actually got there by train, Mr. Speaker. Unbeknownst to me, obviously, as a younger person who hadn't traveled the breadth of this country, it took 54 hours to get there, which is a remarkably long time. It's 2 days plus. But that is the breadth of the country. And I have to admit, although I was a student at the time, and of course I didn't have one of those luxurious cabins that people may have today on the train, it was indeed a pleasurable journey traveling across this country by rail because of not only what I saw of the country, but clearly the service that was committed to us as passengers on that particular rail passage. But for us who enjoy trains, and there are many of us who do, as my colleague from Weston pointed out, when it comes to the ability to be able to have to travel by rail, we have many lessons to learn from places around the world, but also including in this country where we see rail, whether it be in Vancouver, whether it be in downtown Toronto, where we see light rapid rail systems. And in fact, if we look back to Niagara, where I live, in the riding of Welland, it's a number of years ago, before I was born for certain,
you could travel by rail. You could get from Lake Erie to Lake Ontario by rail, but you can't today. 100 years after, we can't get from Lake Erie to Lake Ontario by rail, and up until, Mr. Speaker, believe it or not, I know you'll find this hard to believe, but just up until about 6 months ago, you couldn't do it by bus either. And so, congratulations to Niagara Region for implementing a regional bus service, but just think if they'd kept those rail beds, Mr. Speaker. We could actually get on a rail, we could actually get on a train and go from Port Colborne, from my riding, all the way to the member of St. Catharines riding in the north, and get from one lakehead to the other. Wouldn't that be an amazing thing to think that we could do it again? Not for the first time, but again, because we did it over 100 years ago. That's how folks got around. That's how folks went and saw their families if they were living in the north or the south end of the peninsula. Never mind the places that my colleague from Sudbury has talked about. When you're in the north and you're isolated and rail is it. When you think about that, Mr. Speaker, when you think about the fact that there are communities in the north where rail is their mode of transportation. That's how they get materials in, it's how they get supplies in, it's how they move people. What we need to do is continue to support rail, not only from a safety perspective, but let me just say to my friends in the Ontario Legislature, what they need to do is keep Ontario Northland open, because that's a crucial link to the northern part of this province, and that's an absolute imperative. So I would send this message to Mr. McGuinty. Keep the ONR open.
Thank you. Questions and comments? The honourable member for Sudbury.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague from Welland for his wonderful and eloquent speech on rail and rail safety and the importance of rail to Northern Ontario, but most importantly to the country. As I said to my colleague from Yorkton earlier, rail built this country. I once worked summer swinging a sledgehammer for one of the large railways. Really learned what manual labor was all about when you do that. So you tip your hat to the men and women that do that day in and day out. But what we've seen, unfortunately, you talked about it, we're losing the ONR. It's a provincial decision, but we're losing the ONR in Northern Ontario. We really hope the government there changes their mind and keeps the ONR open. But we've seen more and more of the small communities that are linked with rail lose that service if a foreign company doesn't come in and buy that rail to operate it. And we've seen this government not invest in rail, which means the rail lines have started to deteriorate. You can't have passenger service. Freight service is starting to disappear. Wouldn't it be a wise idea for this government to start investing again in the infrastructure like rail to ensure safety and transportation? Thank you, Mr. Speaker.
The honourable member for Welland.
Well, thank you very much, Mr. Speaker, and I couldn't agree more with my colleague from Sudbury. It's amazing what happens when you let a rail system go, in the sense of if you decommission that particular mode of transportation to that community, it's not that much longer after that and the rail line is gone. And I can attest to you in Niagara what has happened in Niagara. There's a trail in Niagara that lets you walk around the entire peninsula. And the vast majority of, Mr. Speaker, it's a wonderful trail and it's a deserved trail for the residents. Unfortunately, it's on a rail bed. A vacant rail bed is what it's on. So basically, they pulled all the track up. So now what's happened is you now have a walkable trail, which is a marvelous thing for folks to do. But the issue becomes, what if you decide to go back and redo the track? The rail bed is now gone. And so unfortunately, you can't do that. But, my colleague talks about this sense of how communities interact, how you get back and forth. I can tell you when I was in Scotland last year, my cousin said to me, "Why don't you go to downtown Glasgow?" And I said, "Sure, I'll drive down." He said, "No, don't drive down. Take the train." Now, he lives in East Kilbride. It's a community outside of Glasgow, not that far. And lo and behold, you can take the train as if it's a bus. It has about 5 stops along the way, and within 25 minutes, you're in downtown Glasgow by train. And it goes back and forth every 25 minutes. And it's packed with commuters so that you don't have to go into a big town. That's a convenience for someone who's close to a big town. Just imagine what it's like, Mr. Speaker, for those who are further away in remote communities whose service is only rail. We need to make sure we enhance the service, not diminish the service, to make sure that those residents have the same attributes that those of us who live closer to big cities continue to get. That's why the ONR cannot be lost, and we must keep it, Mr. Speaker.
Questions and comments related to S4. The Honourable Member for Timmins, James Bay.
Thank you, Mr. Speaker. I was interested in my honourable colleague's comments in the issue of safe rail, the importance of rail, and he talked about the Ontario Northlander, and that what we're seeing here, in its example, the Ontario Northlander is a perfect example of government years of ignoring the importance of rail, ignoring public safety, ignoring the benefits, while the rest of the world is moving ahead and building railways. I'd like to ask him what he thinks about the fact that in Ontario we have a government that is so blind that they take a public asset and public transit and decide that an entire region of the province just doesn't merit or isn't worth that kind of basic level of service.
The Honourable Member for Welland, a short answer, please.
Thank you, Mr. Speaker, and I'll try. I couldn't agree more with my colleague from Timmins, James Bay. The Ontario Northland is a critical link to folks who live in Northern Ontario, just like any other rail line is when it comes to folks who live in remote areas. It is absolutely critical. Now, it isn't a federal piece, but it is absolutely critical that we make sure that we stand up for the Ontario Northland. I know my friend from Timmins, James Bay, and Sudbury will be doing that. That's what we'll be doing for those of us who live in the South, standing up for them. But what we need to do is send a message to the Premier of Ontario. Do not close the Ontario Northland. It is a crucial link for those who live in the North. That is what needs to stay, and that's what we'll be committed to make sure that that doesn't happen.
Resuming debate to the Honourable Member for Vaudreuil-Soulanges. Thank you, Mr. Speaker. I would like us to take a break from these more technical messages to speak in terms of philosophy. I would argue that it's sometimes useful to resort to philosophy to find a better way in terms of our shared future. Before us, we have a bill that affects the railway safety, and railroads are closely linked to the foundation of our country. This is the key element to the marriage of the separate regions that we call Canada.
Successful is based on trust. It is the essential element of any good relationship. When one loses that element of trust, that foundation, no matter what we build on top of it, the relation will crumble. Now, many will say that we are past the days of railways and have moved on to other things, more flashy, more attractive means of transportation. Let us not forget that railways are still a foundation of our nation and of our economy. Canadians need to trust that rail will always be there. This bill is an important part of building Canadians' trust in our railways. But I want to turn to the issue of trust in terms of the presence of rail rather than the security.
Too often in the past, railways were one of the targets for cuts. In 1981, Prime Minister Trudeau cut the popular Via lines. His government reduced the operating budget of the Crown Corporation by 40%. When the Mulroney government came into office, it restored the services that had been cut. But because of the heavy traffic on our railways, we had a terrible accident at Hinton, Alberta, with a CN train and a Via train that collided. 23 people died. This was one of the reasons that we have this bill before us. Via's budget was cut in 1989, 1994, and 2003. Canadians like the train, but they find that it is not as reliable a means of transportation as they would like. To restore confidence, we need more investment.
Marriage and the specifics of this bill before us. In any marriage, you make vows, usually with the intention of creating a bond that will last a lifetime. In the day-to-day, you make negotiations and compromises. Now, the vows, negotiations, and compromises don't mean very much if one of the parties does not intend on enforcing or following the rules. That is why those provisions in S4, which touch upon enforcement, are important. Time will tell if the judicial penalties are effective. I believe that it's important to pass this bill as soon as possible, but I have to say I admit a bit of skepticism that it will solve all railway safety problems. So I believe the government's work in this area is not over, and we will see in the years to come what other measures will be necessary. There are many tools in building trust so that Canadians feel safe about their railways. Mandatory voice recorders in locomotives, for instance, would be a beginning. You know, another thing that would be helpful is separating out elements of budget bills so that proper debate and discussion could take place about security. Instead, the government goes on with its infantile method of putting everything into an omnibus and then claiming that we vote against particular provisions. To return once again to the marriage analogy, it's like the government is a cheating spouse and we, the opposition, who want to make this work, we just want to search through the credit card records to find the hotel where our partner made a dalliance, and instead we get flooded with all the household bills and office papers and every little bit of paper in the household, and we're told that we're never supportive. It's bad faith, Mr. Speaker. Accept criticism where criticism is due instead of using this infantile, you voted against it line. Canadians are intelligent, Mr. Speaker. They see through this kind of politics.
To turn to something else, we have heard rumors that VIA will be privatized. We often hear this government and the minister in particular say that they are not involved in private sector matters, and we will see if this legislation makes sense or not, or whether it is ideological. I remain skeptical about the effectiveness of the government's enforcement measures. The government has shown that it is powerless in dealing with the private sector. We hope that it will change its ways. I would remind the government that the government is supposed to provide services and act responsibly. We have seen this government not really believe in its own legislation, like the 1988 Public Participation Act.
Before, railways are the backbone of our economy. As such, they are an important part of our history and our future. It is our shared responsibility to ensure they remain safe. We in the NDP certainly agree. I would like to conclude, Mr. Speaker, by talking about something important to many people in my hometown of St. Lazare. It touches regulation directly. Presently, we don't have a mechanism which would get municipalities and rail companies to sit together and discuss issues such as vibrations caused by the speed of trains, as well as a panoply of other issues. I've spoken with citizens and with rail company officials. They both tell me that they would like to see a mechanism through which dialogue could take place and that the federal government could play a role in this process. S4 does not have this provision. These
issues, the relations between municipalities and rail companies, directly affect the riding of Vaudreuil-Soulanges as well as Glengarry-Prescott-Russell. The VIA Director of Operations, Mr. Marginsons, has said that from Coteau to Ottawa there are 98 level crossings. This arrangement means that the private owners have to be contacted when the crossings have to be closed, and then there are conflicts and difficulties. We have all the tools we need. What we need is the political will to use them. This government's ideology, though, is that it doesn't want any state intervention.
Railway Association of Canada. Increased proximity between rail operations and everyday life in our communities across Canada is a risk factor that must be addressed to improve rail safety. We believe that Bill C-33, which is the predecessor to this bill, can be strengthened in this area. At the centre of these concerns involving proximity between railway lands and municipal development is the wide variation that exists across Canada with respect to land use planning regulations. Bill C-33 remains silent on this issue. Unfortunately, Mr. Speaker, S4 too remains silent on this issue. We will be supporting it, but as I said before, there are places that could be improved. Recommendation 34 that was made would require a process of consultation, would have been an effective tool in reducing use conflicts and in turn increasing safety. Education campaigns are fine, they're good, but they rarely do the whole job. I quote again from Cliff McKay. We believe that one of the most efficient ways of improving railway safety in this area is to give the Governor and Council the power to make regulations respecting notices that should be given to railways regarding the establishment of a local plan of subdivision or zoning bylaw or proposed amendments thereto, where the subject land is within 300 meters of a railway line or railway yard. We believe 300 meters is a distance that makes sense from a safety point of view. Now, in terms of jurisdictional questions of this quote, they do it already in the Aeronautics Act for air infrastructure, so why not for rail? I admit maybe 300 meters is excessive. It could be less, but it wasn't really even discussed in a serious way, either as C-33 or in its present incarnation as S-4. For Pete's sake, all the companies were asking is that municipalities send a notice of when they're going to make changes that fall within the area of this rail corridor. It's just a notice. They weren't even asking for any sort of decision on these questions. Now those companies are forced to go to 10 provinces and 3 territories to negotiate an agreement with each one. It could be so much more simple and effective, and that's what good governance means, Mr. Speaker. It means that the federal government will take its role seriously in bringing the country together. I hope that in the future the government will move from merely being a force for awareness of these issues and instead act as a responsible public administrator that ensures the marriage between Canadians and their railway lines remains healthy for generations to come. Thank you.
Questions and comments? The Honourable Member for Winnipeg North.
Yes, thank you, Mr. Speaker. Mr. Speaker, I want to pick up on one of the points that the member makes reference to, and that is in regards, once again, to communities. And I want to be able to cite the fact that individuals also have a role to play in this whole issue. When the member made reference to the vibrations quite often that trains will cause in communities and at times even lead to foundation issues and so forth, I know that I had the opportunity to work with residents. Residents had contacted me, and this is the time in which I was an MLA. And citizens can make contact with their elected officials. They can make contact with the rail lines themselves if they feel that that there is an issue that's important for the community to be able to have to deal with. What I have found is, generally speaking, in this particular case, CP was actually very accommodating in terms of listening, and then we actually responded, and we were able to fix a problem by putting in a buffer wall of sorts. And so citizens also do have a role to play in this, and I'm wondering if the member might want to comment on that.
The Honourable Member for Vaudreuil-Soulanges.
Well, I thank the member from Winnipeg North for his excellent question. I, too, have had similar instances where citizens have approached me, particularly about the vibration issue. And I admit we do have recourse. I've spoken to CP several times, and we've had response. However, I have to admit that this process, to all parties, to the citizen, to the municipality, to myself, to the railway company, appears to be ad hoc, that there's no formal process to process these claims. The railway company has their process, the municipality has their process, and we, when we're contacted by our citizens, we have a process too that we work with citizens. Each member in this House will have a different process. What I'm talking about is trying to find a mechanism, a formal process, where we can deal with these issues in a more efficient way, rather than the ad hoc way it's being dealt with now. And you do that through regulation, and you do that through being through this idea of good governance and through being a responsible public administrator. And so I believe in the future we probably will need a formalization of this process so that every citizen can feel satisfied that there's a process in place that they can go through to have their concerns addressed.
Questions and comments? The Honourable Member for Nickel Belt.
Thank you, Mr. Speaker. To the Honourable Member, in general, the NDP supports this bill because it improves the oversight capacity of the Department of Transport. It strengthens that department's enforcement powers, enhances the role of safety management systems. It clarifies the authority and responsibilities of the Minister of Transport. And it expands the regulation-making authorities and clarify the process for the rule-making by railroad companies. So these are a lot of good reasons to support this bill. So if you, the honourable member, could tell me if there was more ways to improve this bill, could you tell me what that would be?
The honourable member for Vaudreuil-Soulanges.
Well, I thank the member for his question. I didn't want to give the impression that I don't support this bill. It's been in the House for a long period of time, and I believe other members have mentioned before that the review process for a bill is about five years, and this bill has been before the House in different incarnations for more than 5 years. So certainly, I know that one of the things that was brought up at committee when this bill was known as C-33 was the fact of what I mentioned to the member of Winnipeg, from Winnipeg North, the formal asking municipalities to give just a notice to railway companies of any changes in land use planning in a set corridor. I think that would avoid a lot of the problems that are created when developments happen next to railway lines. I know my area, which is primarily agricultural, but in the process of changing, in the process of certain areas going through dezoning, people that have been next to the railway, farms that have been next to the railway, condo developments sometimes build up, and the people that move into those condos all of a sudden complain about train noise and things like that. That could have been nipped in the bud if there was a formalization of the process where a municipality would just give a notice to railway companies saying that it intended to make changes in land use.
Resuming debate, the honourable member for Churchill.
Thank you, Mr. Speaker. And I'm pleased to, I'd like to begin by saying that I'll be sharing my time with the member for Timmins James Bay. And I'm pleased to rise in this House to share my support, along with that of so many of my colleagues in the NDP, for Bill S4, an act to amend the Railway Safety Act and to make the consequential amendments to the Canadian Transportation Act. Ce projet de loi vise à modifier la...
This bill is aimed at amending the Rail Transportation Act by providing increased surveillance and oversight by the Transport Department and make sure that safety and security are taken into account in regulations. It will strengthen the department's regulatory ability and create more serious penalties. It will also increase the safety management systems by ensuring that there is more responsibility for safety and security. When employees express concerns, they will have to be taken into account. This bill will clarify the roles and responsibilities of the Department of Transport with respect to rail travel and will strengthen regulatory powers and clarify the responsibilities of railways. It is clear, Mr. Speaker, as my colleagues from the NDP side have said, that this bill will have a positive role. We have been waiting for this legislation for some time. In the last Parliament, my NDP colleagues, the critics, and members who are knowledgeable about rail issues worked hard to have not only greater safety taken into account, but also to force the government to have a system that is safer for all Canadians.
In the NDP, of course, support this bill, but we also wish that these changes had been implemented before, and that there was a real understanding of the sense of urgency when it comes to ensuring rail safety in our country. However, in discussing the well-being of rail transport, the safety aspect is critical, and we must act on it. But that's only one side of the coin. And while we've seen this government hesitate and delay when it comes to making these critical implementations. They've actually been acting in a way that serves to weaken the rail system in our own country. Via Rail funding is being cut by almost $200 million, as indicated in this last budget, something that I and my colleagues in the NDP believe is a crying shame. We all know how critical rail transport is to our country, to ensuring that our urban areas, our rural communities are staying connected. We know how critical the maintenance of the rail line is when it comes to not just transporting people, but also goods across our country. And we know that as we see Via Rail, an institution that belongs to us as Canadians, an institution that we're proud of, see such major cuts in funding, the only thing that we can conclude is that there will be a reduction in services, reduction in the quality of services. And this isn't the first time this has happened. Unfortunately, in recent decades, federal governments, the Liberal government previously and now the Conservative government, has turned a blind eye to rail service in Canada. I know this well from the region of the country that I come from. Having been born and raised in Thompson, Manitoba, many people notice that on the map of Via Rail, there is a line, the only line that goes straight north in the west, is the one that reaches up to Churchill. And it goes through my hometown in Thompson. And we know that years ago, when the Liberals privatized the line, the service, or the line, pardon me, not the service, it had already needed repair for some time. We were hoping that, of course, the government would do the right thing and invest our own taxpayers' money to be able to fix such a critical link between our communities. But in fact, they chose to privatize it, to sell it out to an American company, and a company that has taken far too long to be able to make the kinds of commitments in terms of maintenance that is required on the track. There have been some hopeful signs of hope, I should say, with respect to the work of this company and federal and provincial partnerships that have supported the work along the way. But at the end of the day, the fact that the government privatized this line leaves it out of our hands. And what that essentially means is a reduction in the quality of service and the dependability of service for the people in a part of the country that don't have more choices than to use the rail service. I'm honored to represent communities that live and work on the Bay Line, communities like Ilford, Thicket Portage, Picotinay, War Lake First Nation, communities that connect, that live between Thompson and Gillam and on to Churchill, that have actually no all-weather roads. These 4 communities I just mentioned depend entirely on the rail service for getting back and forth to medical appointments, for making sure that they have foods coming into their community, for making sure that they can bring in materials to be able to build homes and infrastructure in their community. So this is no small issue. This is the link. This is the only link for these communities. And it's deeply disturbing to see the way in which the government has turned its attention away from communities, not just in my riding, but in rural Canada in general when it comes to rail service. I'd like to note that there are a number of other communities that I represent in northern Manitoba that are also isolated. And I've heard from many people, whether it's in Oxford House or Garden Hill or Barons River, I've heard from elders who know what it was like for communities that were isolated to receive the rail line. These communities that are still isolated are saying, you know, what are some of the options that we have to be able to have year-round sustainable transportation, something like a rail service. They're losing, I have to say, in many cases, they've lost hope given the government's reluctance to come to a solution, with respect to the needs they have for transportation. Fortunately, we have a provincial government that's stepped in and has made a real commitment in partnering with especially the Southern First Nations and for the time being in building an all-weather road. However, the same cannot be said for the federal government and building sustainable transportation. Fundamentally, as the federal government, as this Conservative government pulls away from rail transportation in rural Canada, it's pulling away from the kind of quality of life that rural Canadians ought to have. And when we're talking about something like VIA or, community-owned railways, producer cars that communities may own as well, these are things that belong to all of us. And what we're saying is that the federal government should be there to work with communities, to work with our urban centres, to work with everybody around the table to ensure that we've got a dependable rail service, quality rail service, safe rail service. I'd like to point out that whether it's on their actions on the wheat board or whether it's their continued effort to cut away from the kind of basic services that rural Canadians need, this government is turning its back on rural Canadians, many Canadians that see rail as the way to the future. And what I would say in closing is that I'm proud of the work that our party does to be able to stand up for not just rail safety, but rail service in general. And I hope that we can send the message loud and clear that when it comes to representing rural Canada and Canadians that believe in rail service, we are the ones doing it, the NDP. Thank you.
Questions and comments? The honourable member for Essex.
Mr. Speaker, the member believes in rail safety so much they've voted against every major investment our government has made in rail safety. And if they didn't think our budget this time around got the job done, they didn't offer a single amendment in that direction. Now, I hope the member opposite isn't suggesting for a moment that VIA is somehow unsafe. They got a 4 out of 5 ranking in an independent panel study that looked into rail safety in Canada for having a very highly integrated safety culture. We made record investments in the stimulus period to help them renew their fleet. She voted against that, by the way, Mr. Speaker. And she knows full well that with the expiration or the completion of the stimulus projects, that they require less money being sent to VIA than in the last 2 budgets. That's not a cut, Mr. Speaker. That's the end of stimulus. So what the member will also know, and I'd like to ask her if this bill needed more for rail safety or it needed to be improved, why is it that her colleague sitting over her shoulder as the vice chair of the committee gave consent, along with all the other NDP members, to pass this bill in its entirety in less than 10 minutes and not a single amendment, Mr. Speaker? Let her explain that one.
The honourable member for Churchill.
I wish the member across would show the same kind of passion when it came to actually standing up and investing in rail service in our country in a meaningful way. A $200 million cut to Via Rail, and the member across claims to be a champion for rail service. I mean, I know this government is averse to facts, but that's exactly what we're seeing here. Furthermore, I mean, this government is, and let's take the case of rural Canada, for example. Coming from Western Canada and having had the chance to sit down with so many people that live across the prairies, there's real concern about what this government's doing in terms of cutting back on rail service, the impact of dismantling of the wheat board on short-line rail, producer cars, the breaking down of linkages that rural communities depend on. I'd like to see this member turn to his colleagues and show that same kind of fervor in convincing them to invest in the rail service that we all believe in.
Questions and comments? The honourable member for Winnipeg North.
Thank you, Mr. Speaker. I appreciate the member's comments. What I want to focus some attention on, because the member represents the Churchill area. It's an area in which I've had opportunity now to raise on a number of occasions concern in regards to the rail line and the impact, such as the wheat board and so forth. And we talk about economic development with our rail lines and how important those are. But my question is something that I had asked a previous member of her party, and that was in regards to the New Democratic Party's position or policy in regards to the nationalization of a railway. What is the position of the New Democrats currently? Do they see that as something that they're in favour of? And if she wouldn't mind to answer, I would really appreciate it.
The honourable member for Churchill.
Sure. Well, I'd like to bring my colleague's attention back to what we're discussing here today. And he mentioned my riding in his question, and I appreciate the more attention to Churchill, the better. Unfortunately, Churchill's going through some very difficult times as a result of this government's dismantling of the wheat board, and the Minister of Agriculture's insulting commitment of $25 million to hopefully inspire grain companies to ship through Churchill, something that is a complete farce. What I would say is that I'm proud that our party has always stood for public services and ensuring that when we have something like Via Rail, a Crown corporation that we believe in, that we recognize that it's there to be invested in to the benefit of all Canadians, and the threat of privatization under this government is a very real one. Unfortunately, the Liberals got the ball rolling on that one in a big way, and we've seen the impacts: a decreased quality of life in many parts of rural Canada, an unwillingness of young Canadians to move back to rural Canada, and what we're saying here is that the way to do it is to stand up for a critical service in all ways, safety and funding, and I'm proud that we're doing that.
I have the honour to inform the House that a message has been received from the Senate informing this House that the Senate has passed the following bill to which the concurrence of this House is desired. Bill S. 1003, an act to authorize Industrial Alliance Pacific Insurance and Financial Services, Inc. to apply to be continued as a body corporate under the laws of Quebec. This bill is deemed to have been read the first time and ordered for a second reading at the next sitting House. Resuming debate, the Honourable Member for Timmins James Bay.
It's always a great honour to rise in this House and speak on behalf of the people of Timmins James Bay, a region that exists because of the railway. It's also important to talk about this bill on safer railways at a time when we have so many issues facing railways in Canada. It's clear. If you look at the simple test for whether or not government has vision, whether government understands the issue of infrastructure, whether government has a forward-looking vision, look no further than rail. Because rail has been the kicking dog of Liberal and Conservative governments looking to squeeze it, to undermine it, to so-called privatize it, and we've seen a continuing loss of service while the rest of the world moves forward with smart high-speed rail. I think, Mr. Speaker, just this past February, where the Via Rail train derailed at Burlington, we had 3 people injured, killed, 42 passengers injured. We see the $200 million in cuts that are coming to Via Rail now under the Conservatives. We see the undermining of rail links in important jurisdictions across rural Canada like Churchill, Manitoba, and we see this government's complete lack of interest in the importance of a high-speed rail corridor that would connect Windsor to Quebec City through our most densest populations and allow people who are being pretty much trapped because of the density of traffic in its suburban regions of this country to be able to move at a reasonable rate. But nowhere do we see it more, Mr. Speaker, than in the deliberate dismantling of the Ontario Northland Railway by a government that, if you look up myopic in the dictionary, there Dalton McGuinty would be. Mr. Speaker, let's talk about the Ontario Northland as an example of the failure of federal and provincial governments to address railway services. I know he's a good friend of the Foreign Affairs Minister, but I hope the Foreign Affairs Minister doesn't mind me castigating his friend in this House of Commons. Mr. Speaker, the story of the Ontario Northland is interesting because at the turn of the last century, Queen's Park had zero interest in the land that was considered north of the French River. They didn't have any desire to spend a dime on it until they found out that Father Paradis and the Oblates were bringing Francophone settlers over Lake Temiskaming to settle into Ontario, and suddenly the good orange Protestant burghers of Queen's Park were outraged, and they had to find a way to get Anglophones up into land that was now being settled by Francophones. That was the only time they ever wanted to spend money in Northern Ontario. So they decided they'd push a rail line north of Lake Temiskaming. But as they were getting to Lake Temiskaming, at mileage 103, they hit the largest silver deposits that had ever been found there, and they were found by railwaymen, Fred LaRose and Mr. McKinley and Mr. Dara. And suddenly, Queen's Park thought, maybe there's a use to Northern Ontario. What we'll do is we'll go up and we'll find all the resources we can, and we'll take it out. And that's been pretty much the colonial relationship between Northern Ontario and Southern Ontario ever since. And, Mr. Speaker, it transformed the economy of Ontario, in particular Toronto. Toronto was a sleepy backwater at the time of the silver rush and cobalt. But so much investment dollars were coming in from the United States and from London that they needed a place to set up. And so they set up in Toronto because the train line got them within 6 hours of the biggest rush since the Klondike. That ease of access on the train transformed economic development. And so Toronto established itself, and it still has that claim today. It's the largest center for international capital for mining exploration in the world. That started from that rail line. And out of cobalt, the prospectors went north. They went to Val d'Or in the east. They went as far as Red Lake in the west because they knew there was a value to the land. So the Ontario Northland Railway was set up as a development corridor. And all the communities were built along that. Now, Mr. Speaker, fast forward 100 years, and the Ontario Northland still plays that important role. It's not just with trains, not just with buses. We have the role of telecommunications to isolated small communities that would otherwise pay exorbitant rates. So they are now under Ontario. Mr. Speaker, a few weeks ago we had a flood in Fort Albany up on the James Bay coast. And the flood separated the community from the mainland. And people were contacting me and saying they had run out of food. They needed food to get up there. So we spoke with the Cochrane Food Bank, and we managed to secure 1,200 pounds of food to get into Fort Albany. And we did that through my office. The question was, how are we going to get 1,200 pounds of food to Fort Albany in the middle of this flood crisis? Well, we called the Ontario Northland, and we said, we need you to move 1,200 pounds of freight to help this community in need. Ontario Northland said, get us to the freight yard in Cochrane tomorrow. We will get it to Moosonee. That's the end of the rail line. From there, you find how to get there. So we managed to work with Air Quebec, and we got it in. It wasn't even a question when we asked the Ontario Northland, are we going to get paid to help one of our communities in Northern Ontario? They did it as a public service because they are there for the public. And I want to commend the excellent work that the Ontario Northland did in that situation, and they've done time and time and time again. So, Mr. Speaker, the rail plays an important role, and it's fascinating that you have the Liberal government in Ontario deciding that public transit is something that they don't invest in if it's rural public transit, that it's not right to subsidize public transit if rural people use public transit. If you're in an urban area, well, it's implicitly understood that there's going to be some kind of support because public transit is not about making profit. It's about offering a public service. So we see the McGuinty government will exaggerate the numbers. Every time there's an investment on the Ontario Northland, they claim that's a subsidy. Mr. Speaker, how could anybody run a province if they figured that every time they had to make an investment, they were somehow subsidizing the province, subsidizing the people? The fact is that this is an investment just like the highways. They never say that they're subsidizing the highways, but whenever there's work that needs to be done to ensure a safe rail corridor, because, Mr. Speaker, we have had accidents on the Ontario Northland Railway. I think of the situation south of Temagami about 12 years ago when we had the acid tankers go over. You need to invest, just like you need to invest in roads, and yet there seems to be a double standard that it's okay to invest in highways, even though they don't do much investing in highways in Northern Ontario, I'll tell you, Mr. Speaker, but it's not okay to invest in freight. So in Northern Ontario, on the Ontario Northland Railway, we are moving thousands of tons of freight a day, and we are moving passengers. It plays a unique role. And yet beside that, we have two-lane traffic run through some of the most roughest rock cuts in Canada, which happens to be the Trans-Canada Highway. So it's the trucker route across Canada. So in January, Mr. Speaker, I don't know how many times I've sat at North Bay because you're not going north because some poor driver has hit a rock cut or hit passengers. And yet beside it, we have a perfectly safe, reasonable rail system. And the government's solution is, you know what? We're going to save a few bucks here somehow along the way, and we're going to get rid of that rail service, and we're going to put that freight, and we're going to put those passengers onto the 2-lane ribbon of moose pasture that runs through Northern Ontario, and somehow that's going to be more efficient. And perhaps most galling, Mr. Speaker, was, there's Mr. McGuinty's assistant in Northern Ontario, Rick, the anti-minister of Northern Ontario, Bartolucci. And their explanation is, listen, the reason we're cutting out your development corridor, the reason we're allowing it to be cherry-picked by some private sector who pick this or that but leave the rest to fall apart, is we're going to reinvest it in health care. Well, Mr. Speaker, Northern Ontarians have seen a lot of dubious mining deals over the year, and they aren't saps. And they know that for people who are getting cancer treatments in Kirkland Lake, Cochrane, Iroquois Falls, Timmins, New Liskeard, Englehart, North Bay, that they have to go on the train to go down and get medical services. I don't know how many families I've seen on the Ontario Northlander with a sick child going down to Sick Kids for cancer treatments. And they can travel on the train because it's at least comfortable for the family. Yet Dalton McGuinty was telling us, don't worry, we're going to put those sick kids on a bus and you're going to get better service. Mr. Speaker, people in the North know better. And they remember how just last year the ONTC, and I don't blame them for this because they get no support for the fact that they offer public transit in the North, we're actually trying to save money by excluding going into some of the most major communities on the route because they don't have enough money to serve the public. So, Mr. Speaker, when we talk about development of the rail lines and when we talk about safety, it is about an investment. And it's fascinating that the McGuinty government is looking to rip up the rails and ditch the development corporation for Northern Ontario at a time when the Ring of Fire is about to be developed. And the Ring of Fire is going to be the largest mining development perhaps in the last half century, perhaps in the last century. And the fundamental question is about getting access to this ore comes from rail. So if they're going to rip up their lines, if they're going to get rid of the development corridor, the question is this all about a plan to take unprocessed ore and ship it off by truck to China? Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Winnipeg North.
Yes, thank you, Mr. Speaker. I appreciate the opportunity to say a few words in regards to the member's comments. And I think that the member seems to focus his attention on the Ontario Liberal government as if the NDP, for example, in the province of Manitoba, I can assure the member, have no better an approach at dealing with rail line abandonment or improving rail line services to people that live in northern Manitoba. In fact, one could talk about the impact of the wheat board and how that's going to impact the community of Churchill, which is dependent on the rail line. And the government of Manitoba was truly quiet. The NDP government of Manitoba was truly quiet on it. Mr. Speaker, I think it is important to recognize that all three levels of governments do have a role to play in rail line safety. And that means there needs to be that sense of cooperation from the federal government, provincial government, and the municipal government in order to deliver better, safer rail line services. And this is what this bill is all about. And I'm wondering if the member can maybe comment on the fact of how important it is that governments work together in order to be able to provide better quality rail line service across the country.
The Honourable Member for Timmins James
Well,
Bay.
thank you. I thank my honourable colleague for the question, and I assure him I'd like to invite him to Liberal Ontario, and he'd probably go back and be singing the praises of the New Democrat government in Manitoba, because once you've lived under Dalton, it's something that you will, and that's something my honourable colleague across the way would agree with. But I'm not trying to make this an issue of partisanship. This is not about being partisan. This is about the facts. We're dealing with the fact that at the provincial level we are dealing with a myopic government that doesn't understand the need for investing in infrastructure. So they think they can just walk away from it and it'll magically take care of itself. What I think their real message, Mr. Speaker, is they figure they can just walk away from it and people in Northern Ontario will just shut up and take it just like they are supposed to take it every time Queen's Park pulls out another service.
Questions and comments? The honourable member for Nickel Belt.
Thank you, Mr. Speaker, and I'd like to commend my colleague from Timmins, James Bay. He certainly represents his riding quite well, and I'm sure that his constituents are quite happy with the member. The member referred to Rick, the anti-Northern Ontario Minister Bartolucci, and he made the announcement about the cuts to Ontario Northland, hundreds of kilometres away from the Ontario Northland's headquarters. He made the announcement in Sudbury instead of North Bay. And I'd like to ask my colleague why he thinks this minister would make such an important announcement so far away from the headquarters of Ontario Northland.
Before I go to the member for Timmins James Bay, I would like to remind all honourable members that the matter before the House is S4, which deals with certain matters, and that I would encourage all honourable members to make their comments relevant to that and to the questions as well. The honourable member for Timmins James Bay.
Thank you, Mr. Speaker, and thank you for that excellent intervention, because we are talking about rail safety, and rail safety needs fundamental investment in order to ensure safety. And so, you know, I don't want to talk about whether Mr. Bartolucci has invested in safety or not. I like the man. Rick's a good guy. But I think the fact that he would not even come into the communities that are affected, that are worried about rail safety, I would invite Rick Bartolucci to come with me to North Bay or come with me to Englehart, especially come with me to Cochrane and see how well the McGuinty budget is going down and the McGuinty lack of investment in Northern Ontario is going down.
Resuming debate, the honourable member for Windsor West.
Thank you, Mr. Speaker, and I'd like to advise the House that I'll be splitting my time with the member from Scarborough Southwest. And I'll thank you for the opportunity to speak on this matter as the NDP critic for high-speed rail between Quebec City and Windsor. And actually, the dream eventually is to connect it into Detroit and Chicago. We have an incredible opportunity with rail in our future. I'll get back to that in a minute, though, Mr. Speaker, but I do want to note on S4 a number of things that are important in terms of jurisdictional changes and updating and modernization of the Act that are very important, not only in terms of the overall economy in Canada, but also how it relates to people in our constituencies. And I'd like to start by thanking Mary Riem and Mary Kavanagh in Windsor because we have a rail issue taking place with CP right now, and I'm pleased as well to note Robert Taylor and Randy Marsh from CP, Councillor Alan Haberstadt, and also staff Ian Bodden, where we're currently now have agreed to meet to work on a rail noise and vibration and flooding issue. And I want to talk a little bit about that, Mr. Speaker, because the modernization of the Act provides for a little more accountability and hopefully be some more cooperation that will take place in the modernization of our rail issues. And what's taken place in Windsor, Mr. Speaker, is that we were able to get funding to separate a grade that was very important in Howard and at Howard Street in Windsor, Ontario, very busy, where we had a lot of issues with regards to backing up of cars, trucks, vehicles, pedestrians, and so forth. And so we actually got funding under the Let's Get Windsor Moving Fund. This is for border infrastructure improvements to separate the grade there. But what took place, Mr. Speaker, there wasn't a proper process in place, or it was missed somehow in the planning process, is the repercussions to the residents when the separation grade took place. What happened consequently is that the area behind them and the residents now on Memorial Drive, and I'd like to thank those residents for their patience, have now been subjected to flooding, noise, vibration changes, a whole series of things, and they've actually now submitted into petition for a panel to look at this. But perhaps with a meeting coming up, we can identify this. So it's important to note that rail still, to this day, even though it's the birth of the country in many respects, plays a role on the daily level to its constituents that needs to be held accountable, and it actually has changes that take place. So we're going to see from the macroeconomic scale of rail and the importance of its future coming up with the opening of the Panama Canal. That's where you're going to have a lot of goods and services that we're going to come into the Port of Montreal and Halifax, and I think a lot of those will probably be going on the rail system is what some of the anticipation is as we actually transfer goods and services into the Midwest United States, because they don't have the deep enough ports necessary and they're not as attractive as what we have on the East Coast. So the Rail Safety Act review is really important. As a former transport critic, we went through many hearings at committee that looked at this issue, and it's everything from safety management systems that were taken in place as well to the infrastructure requirements that are necessary. And so I think it's important that when we always seen the romantic notion of rail being part of our past, but it really is going to be much more of our future. And as well, too, Mr. Speaker, I think that it's important to note higher speed rail as well, too. And the Rail Safety Act is going to modernize some of the issues that, if we can get to higher speed rail, would be very important. And I do want to talk a little bit, Mr. Speaker, about high-speed rail. We saw that with the VIA incident that took place, and the tragedy, and condolences to the families and to those that are injured. But we know that the rest of the world is moving forward with higher speed rail investments. In fact, that many G8 countries are doing that, and Canada is the only G8 country not to have high-speed rail. We're the only ones that have been left out of that equation. And modernizing the Act is important, but at the same time, we do need to have funding allocation. And what I've been doing, Mr. Speaker, is I've been working on the Quebec City to Chicago run. Last year, I went into Michigan and met with the department there and wrote a letter to Kirk Scruto, the Michigan Department of Transportation, and to inquire about what's happening on the American side, because the American side, when you connect into Quebec City all the way down to Chicago, there's tens of millions of people that live along this corridor, so it could be great urban planning as well as an opportunity to improve the environment and also better the economy. So we asked what they were doing over there, Mr. Speaker, and they actually are doing improvements that will eliminate a series of choke points, therefore relieving congestion and resulting in increased speed to a maximum of 110 miles per hour. Our long-term version also includes doubling the number of daily round trips in this corridor. So that's Detroit to Chicago. And, Mr. Speaker, there is a rail tunnel that connects Canada and the United States. There's two in Windsor. And there has been availability for this tunnel for passenger rail again. In fact, in the 1930s, it was when it stopped, I believe. But we did have passenger rail between the United States and Canada through this corridor in the past. And we still have that infrastructure today, and it is available for us. So it's kind of exciting. So there are improvements, Mr. Speaker, is Kalamazoo, the Dearborn Service Development. There's $200 million in total that they're doing. And there's also the Ann Arbor Station project, where they're increasing the station in Ann Arbor. And as well, too, they're doing the Midwest Corridor Regional Equipment Pool. Another $268.2 million was awarded to purchase 48 more passenger rail services. And I want to read a quote of here, and this is from Kirk Strudel. He's the director of Governor Schneider here. He said, "It is our understanding that investments being made in high-speed rail service in Michigan will prompt similar projects and studies in Canada, which would allow expansion of a high-speed corridor from Chicago to Montreal. Improved and expanded service along this corridor will enhance our economic competitiveness, promote energy and environmental efficiency, and support interconnected communities by providing a more reliable passenger rail service. MDOT will look forward to working closely with you to bring new investment to our region." And sadly, I've seen the Department of Transportation on this side actually cut $200 million from VIA on this side. So you have the United States going in the exact opposite direction. They're investing, they're improving, they're seeing the merit of this project. They are open and want to connect into this corridor. They see a bigger vision, and you can imagine, you have Chicago, Detroit, Toronto, Montreal, Quebec City, and maybe eventually you build a separate spur or improvements to Ottawa. There's several options out there that are really important to note, that we could actually have a good passenger rail service around this corridor and economic investment that is critical at this point in time. So I wrote and what I proposed, I think, was a modest strategy, Mr. Speaker, is that similar to the Detroit corridor there, if the Minister of Transport convened a special working group, and it's been done before with the Canadian Auto Partnership Council, and I think it's important to lay out a little bit of the strategy behind this, where the CAPC model for auto, they brought in not only the auto manufacturers, they brought in the union, they brought in the dealers, they brought in the parts people, tool and die mold making, the entire automotive chain. And what they did from there is they laid out a business plan and a measurement system on how to deal with our auto sector. Sadly, this government hasn't convened a major meeting of this in, I think, 2 or 3 or 4 years, and they've only had some executive meetings, and it's sad because that's a model there that I could envision, and I was hoping the minister would take that up, where he would bring in the cities. And I've had a chance to meet with Mayor Fontana of London. He's interested. The Mayor of Quebec City is interested as well, and moving forward on something. So there's the Mayor of Windsor is supportive. So we have a number of municipalities that would provide an opportunity and some guidance with regards to this project. Then you would have on top of that, Mr. Speaker, the rail, CP Rail, CN Rail, and VIA, and a whole series of other groups that could, look at the overall business plan of what's taking place with regards to passenger rail and rail issues, and get the low-hanging fruit, get the things that that are stopping some of the improvements that could take place. And what the whole goal is, Mr. Speaker, and what they're doing in Michigan is what they're doing is they're getting rid of the low-hanging fruit and improving the overall line. So that's really critical because once they actually eliminate some of those things, so be it separation grades, whether it be improvements to the line so they can go faster. In Michigan, they're buying some of the lines. Those municipalities will know those problems and those weak spots. And so it would be very important for us to get them together and then look at what they cost and how do we have the improvements. And I think that would be a good, positive way to approach things, Mr. Speaker. And so as I conclude here, I really hope that the government here and the minister rethink their decision and take advantage of this opportunity for economic development and environmental development along the corridor with Michigan, because that would be a real benefit to all of us, and I think it would be an economic issue that would really be championed by municipalities, the province, and also the federal government in a positive way.
Questions and comments? The honourable member for Winnipeg North.
Yes, Mr. Speaker, just to pick up on the member's comments, we look at the rapid and the potential of rapid transit that's taking place in many of our municipalities, but he highlights one area specific in which there is a great deal of support in terms of trying to move ahead and come up with some ideas and look at the possibility of things such as feasibility studies and so forth. Bottom line is, for many of the municipalities that we're talking about, and that, if we can put it, that Toronto corridor, that there is great merit. And would ask the member, in terms of when you take a look at rail line safety, that this whole concept of a high-speed corridor is something that ultimately could even be incorporated into future amendments, because it's one of those things in which we want to make sure that it's done in such a way that it preserves the integrity of having safe rail lines.
The honourable member for Windsor West.
Thank you, Mr. Speaker. Yeah, I agree, and I think it can be, and I thank the member for the question. And I think it becomes a larger issue too, Mr. Speaker. When you're looking at that corridor and high-speed rail, you also could be doing protecting, say for example, farmland and other types of areas where there's urban sprawl, because you have development along the corridor as well in terms of strong urban planning. So it becomes a natural attraction to live along the corridor, to use the corridor, and to work along the corridor. You look at how many people commute now from Kitchener into Toronto, for example. And there's a good point, Mr. Speaker, is that what it does by improving our rail safety, whether it be through the Act or whether it be improvements for via and passenger rail, it'll also improve our capabilities to protect our other infrastructure, being the 400th highway system, which gets pounded on by excessive excessive car and truck traffic. So I would look to see that the benefits there as well.
Questions and comments? The honourable member for Essex.
Thank you, Mr. Speaker. I appreciate the member opposite his intervention. A nice discussion about high-speed rail. I wonder, though, since this is a bill about S4 is about Safer Railways Act, whether he has any comment on the requirements for a rail operating certificate. Thank you.
The honourable member for Windsor West.
No, I don't. Thank you.
Questions and comments? It is my duty, pursuant to Standing Order 38, to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The honourable member for Scarborough Rouge River on pensions.
The honourable member for Beauharnois-Salaberry. Asbestos.
Honourable Member for Davenport on housing. Resuming debate, the Honourable Member for Scarborough Southwest.
Thank you, Mr. Speaker. And I would just first off like to congratulate my colleague for his tireless leadership on the rail issue and for his involvement in the Rail Caucus and everything he does to try to improve rail and rail safety in this country. And it is certainly a shock still, Mr. Speaker, that today a country as vast as Canada does not have a high-speed rail link, I mean, we're even having trouble speaking about a higher speed rail, which would involve getting rid of, for instance, the level crossings that exist in many areas in some of the corridors, which would help to also improve rail safety. Now, with its far-flung population centres and vast landmass, Canada is unique in its geography, and as such, our railways have always been an integral part of how we connect with each other across this massive country. Railways are not just a means of transportation, they tie us together at a much deeper level, as many of the speeches today have done, in particular the member for Timmins James Bay speech just a little while ago. I know that a great number of members in this House, myself included, Mr. Speaker, rely on Via Rail as a means of getting to and from our constituencies. Myself, just in the 1 year since I've been elected, have already traveled over 25,000 kilometers on our rail network. Now, railways are used every single day by thousands of people and has been this way for hundreds of years now. The benefit of railways are clear. Trains are substantially more fuel efficient than motor vehicles when it comes to moving passengers and especially cargo over great distances. And of course, by potentially electrifying rail lines, greenhouse gas emissions could also be reduced in the coming years. Now, despite the shortcomings of safety regulations, traveling by train is still roughly 5 times safer than using a car and is still the main mode of transportation for our Canadian goods. With 70% of all freight in our country shipped by rail, it is literally the backbone of our economy, Mr. Speaker, and every interruption to our rail network comes with great costs to our economy. Rail lines provide crucial links to our biggest trade partner, the United States, and of course also connects to our ports in Halifax and Vancouver and Churchill to provide access to important overseas markets for Canadian companies. In large urban centres, commuting by rail is a vital component of our public transit networks, helping to get millions of Canadians to their workplaces every single day. Via Rail connects to our country's most vibrant cities, carrying more than 4 million passengers a year, and it can do a lot more with more government support, Mr. Speaker. The Railway Safety Act was implemented in 1989. It sets out a regulatory framework to address for railways under federal jurisdiction matters of safety, security, and environmental impact. Transport Canada has noted that the Canadian rail industry has changed significantly since the Act was amended in 1999. Operations have become increasingly complex, and traffic is growing rapidly. The Department points out that in February 2007, the Minister of Transport, Infrastructure and Communities launched a full review of the operation and efficiency of the Railway Safety Act through an independent advisory panel. According to the Department, the findings indicated that although the Railway Safety Act is fundamentally sound and efforts have been made to improve rail safety, more certainly needs to be done. The advisory panel's final report, Stronger Ties, a shared commitment to rail safety, published in November 2007, included 56 recommendations for the improvement of rail safety, some of which require further legislative changes to the Railway Safety Act. And then in 2008, the Standing Committee on Transport, Infrastructure and Communities issued its own report, which included an additional 14 recommendations. Now, of course, recently on February 26, 2012, a Via Rail train derailed in Burlington, Ontario, killing 3 people, Via employees, and injuring 42 passengers. We're still in the early stages of investigation, but the indications would seem to suggest that speed and a lack of signals inside the train may have played a role. The crash reinforced what the NDP has long said, that although railways in Canada are relatively safe, that tragic accidents can and do still occur. These preventable accidents should be avoided at all costs, and the federal government has a key role to play in the effort to make train travel safer. Federal initiatives like Bill S4 would go a long way into making train travel safer for passengers and rail employees, but other initiatives like the NDP's call for positive train control and our calls for the Conservatives to reverse their cuts to Via Rail and transport safety programs, including rail safety, would also help to create a safer rail system, Mr. Speaker. While we applaud the passage, or the eventual passage of S4, it's unacceptable that this bill and the important provisions it contains has taken so long. Now, more than ever, we need to see these changes realized. The NDP welcomes this bill, and we see it as a step forward for Canada's rail safety. But it's a time for the Conservative government to take action and satisfy the long-standing demands from the independent experts at the Transportation Safety Board. More talk is not what we need. Action is what we want. By the time the bill is passed, it will have been 5 years since the recommendations of those experts were first published. Now that, Mr. Speaker, is too long to make changes when safety is concerned. Canadians are demanding on us to make the railways safer, and we are more than happy to oblige, Mr. Speaker. We're happy to see this bill before the House, but it's a pity that it has not been a priority of this government. The government that likes to boast that it's the champion of the safety of Canadians, but let it try to say that the families of victims of the derailment in Burlington or to the families who lost their home in Saint-Charles-de-Bellechasse in 2010. The safety of Canadians is important, and this bill is needed in order to protect railway workers, passengers in the trains, and people who live near railway lines. And it is also, Mr. Speaker, as I said before, important to our economy because every disruption to that rail network affects potentially millions of dollars worth of goods and time. The government likes to advocate for smaller government, for getting the government out of everyone's business. Large rail companies and their employees, the shippers that use the rail lines, and citizens who live near the railways and passengers who travel by train, Mr. Speaker, would all disagree. They understand the government does have a role to play. It has a role to play as a regulator, as a protector, to ensure the safety of all Canadians, and it is a shame that it has taken this government so long to provide the measure that will ensure that safety is enhanced, and it could still go further, Mr. Speaker. Unfortunately, in the ideological zeal of the government, safety and well-being are often left to free market forces to decide. The government expects industry to regulate itself, but that rarely happens. And so unnecessary accidents and the tragedies that follow occur, and I'd like to use my remaining time to focus on some propositions we have made since the bill was introduced. First proposition from our party is that the government should not cut safety from its budget. The upcoming budget will cut money that could go towards safety. The parliamentary secretary mentioned that the amount of money spent on something should not be the measure of its effectiveness. Yet the people who enforce safety regulations and develop new safety systems need to be paid. They need to be remunerated for their work, and it is not work that anybody can do. It takes experts to do that work, and we cannot shortchange them, nor can we cut corners in this area. When corners are cut on safety, we see the results. People working in the transportation sector say that it jeopardizes safety, and the government cannot say that it defends safety on one hand and then cut safety on the other. We've also asked that the proposed cuts of $2 million to Via Rail be reversed. Via Rail has challenges and it needs to implement certain systems. The NDP would like positive train control implemented in Canada. It was done in the United States, Mr. Speaker. In California, there was a very tragic accident in 2008, and the leaders decided that positive train control should become part of the system. There are positive benefits to implementing it. Yes, it is costly, but there are companies in Canada that contribute to this technology, and investing in this technology to improve safety would also be an investment in our economy, Mr. Speaker. It would stimulate the innovators who are contributing to positive train control and other technologies that make our railways safer. We'd also like to see voice recorders in locomotives. This would help to find out what happened when things go wrong, when an accident happens, and it's in the interest of everyone to find out the full story of what happened in a rail accident so that things can be improved in the future. We must always be vigilant, Mr. Speaker, in working to make sure that we never take our hand off and that we're always working to ensure that life becomes safer and safer for Canadians as they travel, go about doing their business, and contribute to the economy. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Winnipeg North.
Yes, Mr. Speaker, the member brings up a good point in terms of just how frequent we should be actually looking at railway safety and bringing in legislation that's necessary in order to make changes. The last time it was done prior to this bill, which has yet to pass, would have been during Jean Chrétien's era of back in 1999, I believe, Mr. Speaker. And I think there is a great deal that has changed since then. And yes, the Conservatives have dropped the ball in the sense that given the type of support that this bill has received, is that there is no reason why this particular legislation could or should not have passed years ago. Many of the measures that are there today that are being proposed were in fact known and well established even a few years ago. My question to the member is how often does he believe that this bill should in fact be reviewed? Should it be reviewed every 4 or 5 years? Does he have any thoughts in regards to that?
The honourable member for Scarborough Southwest.
Well, thank you, Mr. Speaker, and thank you to the member for his questions. Of course, he mentioned that, yes, it had taken a little while, and as I said in my speech, it's taken 5 years from the time that the recommendations came out to the point where we're at now with this bill. And with the support from all sides, one wonders if it could have passed in a minority parliament that existed for the last several years, and I think it would have, and probably would have been one of those bills that all sides of the House could have looked to proudly to say this is how minority governments work when we work together. But unfortunately, it was not a priority for the government, and it didn't happen, Mr. Speaker.
Questions and comments? The honourable member for Essex.
Thank you, Mr. Speaker, and I appreciate the member's intervention. This bill was in the last Parliament, and I'll point out that the NDP didn't have much zeal to pass the bill at that particular time, but they did have zeal to cause an election that caused the bill to die. Now, to the issue of voice recorders, I know the member has raised the issue. Unions have been clear that they have some difficulties with the idea of voice recorder technology being implemented on trains, precisely because the issue has not been settled at this particular point about who would have access to the voice recorders. Now the point is well taken that voice recorders can have some positive impact, but is he suggesting that the government should make a decision that the other partners in rail safety, the unions and the companies, have not arrived at a solution on? Is he suggesting the government should move ahead of that right now, mandate the technology, or should he wait till the working group has resolved that issue first so the government can then move ahead on that issue?
The honourable member for Scarborough Southwest.
Thank you, Mr. Speaker, and I would suggest that the government take a vastly different approach than it has taken with practically every other labor issue that has come up since they've been elected in May 2011. You know, we look at the workers at Canada Post, we look at the workers at Air Canada time and time again, and you know, this government shows absolutely no respect for labor and for labor agreements that have been negotiated. So what we would say is that the negotiations have to take place. We have to treat all of the stakeholders and parties with respect and come to an agreement on the issue. You know, we have voice recorders in airplanes, Mr. Speaker. We can certainly implement them in a way that respects all sides, and where, of course, that information would only be used in the strictest of circumstances. And, of course, Mr. Speaker, privacy laws would apply.
I think that the honourable member for Montmagny would like to have the floor. Thank you, Mr. Speaker. I'm rising in the House today to respond to a question of privilege raised yesterday by the honourable member for Westmount-Ville-Maquis. I first want to thank my colleague, the member for Skeena-Bulkley Valley, who is the House leader for the official opposition, for having spoken yesterday, as well as the honourable member for Richmond-Athabasca, even though he wasn't aware of the fact, wanted to speak as well. Without any other contradiction, I want to present my most humble apologies to the member for Westmount-Ville-Maquis for the loss of the items intended for him. I recognize without hesitation that the error was my responsibility and mine alone. I would therefore like to try to repair the damage as soon as possible. I want to say that this was an honest error done in good faith. The facts go back over 2 months now. I learned of them last Thursday when my assistant mentioned to me that an email had been received from a member of the staff of the member for Westmount-Ville-Maquis. After learning about the situation, I went back to my office for the riding of Montmorency, Charlevoix, Haute-Côte-Nord to get the details, and I can confirm that this was an honest error. There was no intention to do any harm. I accept responsibility for this unfortunate error. Here are the facts. A package which was intended for my colleague was delivered by mistake to my office, was opened by a member of my staff who did not notice that the package was not intended for our office. As my colleagues know, we receive a great deal of mail, including packages, and this is why not everything is looked at in detail, but that is not an excuse. I would point out that the mail indicated by my colleague was such that it added to the confusion, because we did receive the package and it was in my office, though he did not mention that at the time. The promotional items that it contained were such that we do receive in our office, and I often distribute this type of item in my riding. I note that the member for Westmount-Ville-Maquis did not try to contact me directly to clarify the facts. The first time he spoke to me was here in the House through the question of privilege. This is an unfortunate miscommunication, however. I recognize that I am at fault, but I would say that this was not out of any ill will, and I am still offering my apologies. I would be happy to reimburse any costs involved, and I will be pleased to make a charitable gift.
The Chair thanks the Honourable Member for his point of order, and I believe this may bring this matter to a close. The Honourable Member from Winnipeg North is rising on the same point of order.
On the same point of order, Mr. Speaker, although I appreciate the sentiments that have been offered by the member, I know that the member from Westmount was quite concerned, as the Liberal caucus was concerned in regards to it, and had advised the Speaker that at some point, or I would like to take this opportunity to advise the Speaker, at some point I believe the member from Westmount might want to come back and provide additional comment. There was concern that was expressed yesterday in regards to the contents of the package. From what I understood, was that of toy shuttles, which was going to which was meant to be for a fundraiser for children, and I think people could make the association of it being a shuttle, given the former background of the Liberal House Leader. So at this point, Mr. Speaker, I would suggest that we leave it for the member from Westmount to be able to report back, because we do believe that it is of a fairly serious nature, because it involves not only the opening but also the consuming of the contents of a letter, as opposed to opening it, finding out that it's not yours, and then returning it. And that would have been, I think, more understandable as an innocent as an innocent thing. So I would like to continue to leave the matter open. Let's wait for the Liberal Party House Leader to be able to respond to the member's statement.
Before others rise on the same point of order, maybe we could, the House could agree that that the Honourable Member for Westmount-Ville-Maquis ought to have the opportunity to review the statement made a few moments ago, and that if he feels it necessary to further pursue the matter, that would be left to him rather than to others in this place. The Honourable Member Welland on the same point of order.
Yes, Mr. Speaker. In hearing my colleagues, and I can appreciate the member from Winnipeg North and what his comments are, but clearly, Mr. Speaker, what I heard you say was, after we had heard the member speak, you had said that closes the matter. And so, to be fair, Mr. Speaker, I believe my colleague from Winnipeg Centre was really no longer involved in the point that the member from Westmount Ville Marie was talking about. This becomes a point of debate, it seems, at that point in time, because clearly you had said after the intervention by my colleague that you felt that from the chair that this matter was now settled. So I would suggest that perhaps this matter is now settled.
I'd like to reiterate, the chair would like to reiterate what I said a couple of minutes ago, which is that I think the best course forward is to allow the honourable member from Westmount Ville Marie to review the statement that was made. That honourable member has the right at any time to bring forward a point of privilege or in this place, and that rather than other members speaking on behalf of others, that we could proceed, and we will see where this takes us. We'll put it in that context. Resuming debate.
Resuming debate. The honourable member for Gaspésie-Île-la-Madeleine.
Thank you, Mr. Speaker. Thank you for your intervention. I think it was very fair. With regard to Bill S4 and railway safety in Canada, there's no doubt that this is a particularly important bill for citizens in my riding. We have a railway that has been there for over 100 years, has a very particular history, and I'll share that with you in a few moments. But the important thing here is that we're talking about improving railway safety in Canada at the same time that we're talking about privatizing railways in Canada. I fail to see how both can happen at the same time without being concerned with the fact that railways have been left by the wayside and degraded over the years. There are train routes that have been cancelled because of the degradation of this railway. We've been waiting for a bill of this magnitude for a long time, something that can improve the safety of our railways. We also have to remember that the railway cannot be degraded. There is no railway safety if the rail bed itself, the railway, is in such bad shape. If you cannot allow a train to pass on there. For example, we have two railways in Canada that have degraded to the point that trains no longer use it. The Malahat, it goes to Vancouver. The Via Chaleur train to the Baie des Chaleurs, it no longer travels. And that's why there's serious degradation of the railway. You can no longer guarantee the safety of passengers. You can no longer allow cargo to pass on there. There are communities that rely on those railways, but that are in a precarious situation because they depend on tourism that those rail lines had brought in, the trade, that the goods that were using that railway. They no longer have that, and that's because the government has been dragging its feet about ensuring railway safety, and that allowed for this kind of situation where the communities affected by this degradation are in bad shape. They can no longer do what the Conservative government is proposing, that is taking over. We tell the communities, remote communities, don't worry, you have a railway, you can restore it yourselves. So we'll adopt a bill that says that once you've restored them, I'm sorry, Mr. Speaker, I forgot to mention that I will be sharing my time with the member for Notre-Dame-de-Grâce-Lachine, with your permission. So, as I was saying, The fact that a bill is being proposed today by the Senate, and incidentally I find it a bit disappointed that the Senate had to propose such a bill, but that's a whole other matter. But when it comes to the bill before us on the improvement of railway safety, this is pointless if the railway is that degraded and nobody can afford to restore it properly. The privatization that the Conservatives are trying to convince us is a solution to every problem in Canada will not work. In the Gaspé, a firm of consultants, experts, was hired. They assessed the state of our railway to figure out how much money would be needed to restore it properly. Repair was estimated to cost $93 million. And now we're being told that the municipalities of the Gaspé are supposed to find $93 million to restore their railway. That does not work. They can't do it. Moreover, the government sold them a project in 2006 saying, here's your railway, we're going to privatize your trunk. We'll push this on to the municipalities, create a corporation of municipalities, and that corporation or cooperative will be responsible for the repairs that are needed. But the CN, with their allies in government at the time, instead of doing a real assessment of the needs, they came up with a figure out of thin air saying it would cost $19 million to restore the railway. That's not the case. We now see 5 years later that the real price is $93 million. So that means a deficit of $73 million to restore our railway. We put the question to the Conservatives, are they prepared to help us improve our railway? And the answer is silence, no answer whatsoever. The communities of the Gaspé, and I think that the same would be true on Vancouver Island, we depend on our railway. That is a job-creating vehicle. It generates wealth. It's worth far more than the $93 million we're supposed to find to restore it. It creates jobs. It allows for tourists to come to our region to spend money. It allows new companies to get established there and have reliable and effective and efficient transportation, but we cannot afford the restoration. If they really want to be serious and have a bill that really says that safety is important, well, safety is important, but the service has to be accessible to people. It's closed. The railways in the regions will be left by the wayside. They will continue to deteriorate. They continue to privatize it. People no longer believe in these remote railways. They're totally abandoned. Now they decide that what they're going to do is put an emphasis on railways in urban regions. I'm very glad that emphasis will be placed on the urban regions. But even here, I think that the Conservative government is abandoning us. There's no doubt that in the regions, there's no money for this. The Conservatives are not prepared to support us. We cannot afford it ourselves. We cannot hire people and buy the resources necessary to improve the railway. I'd just like to give you an idea of the railway we have in the Gaspé. I have 4 minutes left, Mr. Speaker. Is that correct? 2 minutes. Okay. Well, I'll try to do this faster. The railway in Gaspé is a single trunk. It's unique, 200 miles long. It's probably the trunk with the most bridges in all of Canada for the kilometers involved. 93 bridges on 202 miles. That's why our railway is so expensive. And that's why it was left to deteriorate to that extent. It's the bridges that have deteriorated, and that's why we don't have via service now. We have via bus. We expect that the railway in the Gaspé be able to be Class 3, 45 miles an hour. That's about 70 kilometers an hour for those who are more used to the metric system than I am. Right now, on some of the bridges, they can only travel at 5 kilometers an hour. That's why VIA said, we're not using them anymore. This is ridiculous. Not only do they go 5 kilometers an hour, but they have to brake on these bridges. They cannot brake, rather. If they braked on a bridge, the bridge could collapse. There's a high risk of that, so it's very worrisome. It's very important that money be spent to restore this properly. It's all very nice to adopt bills that are useful in theory, but the Conservatives don't seem to be prepared to put real resources at our disposal. So that bill is useless. It's pointless. It's more theoretical than anything else. We must go far further than what the Conservatives are proposing right now. A real national transportation plan, that's what we need. A true plan that will improve transportation for Canadians. A plan that takes it for granted that the environment must be protected. A green plan. Something that will be profitable, that will generate wealth and jobs. Right now, I don't see that. I'm waiting for the Conservatives to come up with something to that effect. Thank you, Mr. Speaker.
Questions and comments?
Reprise du débat.
Resuming debate. The Honourable Member for Notre-Dame-de-Grâce-Lachine. Thank you very much.
I'm very happy to finally have the rail safety bill at this stage. I know that it has been many years and many people, including our party, have fought to pass this legislation. It is not perfect, we know this, but overall anything that makes rail safer for our workers and passengers can never be a bad thing. As we do have some time to speak to this bill, I think that it is important that we highlight some of the issues that are missing in the legislation for the future. This bill is an important first step that everyone wants to see, but it is not the final one. The Transportation Safety Board has had a wish list for some time, and it should come as no surprise that one of the safety issues needed is positive train control. This will improve both passenger and freight trains. Voice recorders are essential on airplanes and naval ships, but not trains. Without voice recorders, we have a hard time knowing what exactly went wrong. The TSB has been clear about wanting this since 2003. It is now 2012. Did we leave this out of the rail safety bill because the United States does not have this regulation? That's what we heard in the committee. Is this government afraid of creating a regulation that will keep our people safe just because the Americans do not have the same rules as we do? Every time there is an accident, we don't know what happened. We don't know. We cannot get to the bottom of it because there are no voice recordings. The voice recorders are essential to train safety. They should be reviewed only by independent safety experts so that the employees do not feel that they are only in place to spy on them and their place of work. The Minister has supported the idea of voice recorders on trains, as does the Department of Transport. When this law is passed, it will be important to continue to move on rail safety to make sure every Canadian is protected. This bill will put more emphasis on safety management systems, or SMS. This is not a bad thing when you first look at it. SMS provides a nice check when it comes to making sure that all the safety inspections are done. However, I do have a worry, not with the concept, but with the implementation. This bill's amendments have allowed for a discussion between employers and their union in the development and implementation of SMS. This is a good thing. I sit on the Committee of Transport, Infrastructure and Communities, and I have the Dorval Airport in my riding, so I get to see many transport issues. SMS has been implemented in the airline industry, and if they are working properly, they are a great thing. What has been happening, however, is that the safety management system takes over the job of rail inspectors. The workers have alerted us that they have less access to planes since the takeover of safety management systems. With the passage of this bill, we as legislators must always be aware of problems with implementation. There is a little sense in creating unnecessary regulations that only detract from real safety. As I will repeat several times for the benefit of my colleagues, the companies and the workers, this bill must be passed, but we must remain vigilant to the problems that could arise. We cannot rely too much on the paper checks. Safety management systems cannot be used to take jobs away from workers, thus compromising safety and defeating the purpose. The bill does not mandate research and development, which may be helpful in creating new ways to make rail even safer. Although, it is nice to see that the bill will encourage the introduction and use of new technologies under the rules. It still comes down to implementing positive train control, which all sides agree this will be a good idea, employers and workers alike. Railway companies can be forced to implement positive train control today under the Act, so I trust that we will come together as a House and make sure that we improve the safety of our trains even more. Finally, we will get to see punishments for those companies that break the law. The only possibility for punishments for these offending companies was prosecution. That method of punishments takes so much time, costs a lot of money to the taxpayer, which makes it basically ineffective for many violations. Civil aviation and marine modes of transportation already have monetary punishments for violators, which have given those industries extra tools to improve compliance. Now we are bringing in punishments for offenders that violate the Act. Punishment is not the only way to improve safety. We must make sure that the trains have all the safety features they need. After many years and many passages through this House, it is time to do the right thing and pass this into law. My speech is to remind all of us that this is just a first step and not the end of the rail. Rail safety is something serious and should be taken seriously. We must work together on protecting all Canadians, and I look forward to the passage of this bill. Thank you.
Questions et commentaires?
Questions and comments?
The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. I did catch the beginning of the members' the comments and appreciated the way in which that she's indicating that the party is supporting it. She would like to see the bill ultimately move forward. Thought maybe that this is something that could have been done at an earlier time. And I think that most Canadians would recognize and share the concerns that all parties have expressed in terms of seeing this particular bill passed, because we recognize the importance of rail line safety, and would ask the member, does she anticipate that the bill would be passing today or at some time, at what point in the future?
L'honorable député de
Honourable member for Notre-Dame-de-Grâce-Lachine. Thank you, Mr. Speaker. Yes, I think that this bill should be passed today. We've been waiting long enough. What I wanted to emphasize is the fact that I think that there are gaps in the bill. It was important for us to have it passed as is, but not stop there. This is no reason to say, well, in 2012 we improved this situation with this bill, we improved railway safety. Let's postpone this for another 5 years. I think this is something that has to be improved right away. We shouldn't wait too long. Questions and comments?
Reprise de débat.
Resuming debate. The honourable member for Haute-Gaspésie, La Métis, Matane, Matapédia. Mr. Speaker, thank you. The members for the Bloc Québécois will vote in favour of S4. That's no surprise to anyone. We have before us an apple pie issue, really. Everyone loves apple pie. Nobody can be against this. So the Bloc is, of course, in favour of railway safety. S4 amends the Railway Safety Act in order to encourage railway companies to maintain a culture of safety. Let me discuss some of these points. Protect whistleblowers who report poor railway safety, make sure that directors are responsible for safety from a legal standpoint. The bill allows the government to punish any offenders with fines that are severe and increased legal sanctions. The amendments also improve the surveillance by the Transport Department. They must obtain a certificate to operate a railway with safety regulations. It clarifies authority of the Transport Minister regarding railway safety. How can you be against that? But it's very easy to tell railways that they need to be safer. If we don't help them, however, and if we leave major trunks deteriorate over time and just cross our arms and observe the danger, we're not part of the solution, we're part of the problem. So the terrible state of our railway network, particularly in Quebec, is the fault of this government and its predecessors. Let me give you an example in my area. On Wednesday, January 18, 2012, there was a Radio Canada article which, incidentally, can no longer call into question the authority of this government if a new regulation comes into effect. Gaspé needs $93 million to save its railway. Let me read you this brief article. Citizens are mobilizing to maintain the railway in the Gaspé from Matapédia to Gaspé. A series of actions that will be taken in the coming weeks were announced Tuesday at a press conference at New Carlisle. Members of the Railway Corporation need $19 million per year to repair the railway and improve safety. The study was conducted by the Gaspé Railway Corporation and published last year. It concludes that between $93 and $100 million would need to be invested to maintain and repair 320 kilometers between Matapédia and Gaspé. During the event in New Carlisle, the directors launched an ultimatum to Ottawa and Quebec City. Without a commitment by governments, operation on this trunk between Matapédia and Gaspé could be irremediably suspended by March 31st, 2012. Via Rail no longer uses these Gaspé railways since December 21st. For safety reasons, Via Rail brings its passengers to Gaspé by bus. The mayor of Gaspé, François HoC, is aware that $95 million is a lot of money, but that remains necessary to ensure the survival of this trunk. He stated this before citizens and elected representatives. So members of this railway corporation want to meet with Jean Charest as soon as possible, as well as the minister responsible for economic development in Quebec. It's difficult to have private investment in the region without that money, and I'm quoting Mr. Lebel, the federal minister. He reacted to these needs on Tuesday. He said that he could not make a commitment to respond to this immediately, but promised to look at the file. This is a very soft answer by the minister. Via Rail have stopped serving the Gaspé. How can they justify dragging their feet to ensure the safety of Via Rail when they threaten back-to-work legislation on the grounds that it could harm the economy? Closing down this trunk truly ruins the economy. It's easier, though, to do this to the workers than to help the passengers or the other users. We will vote for this bill because we think that a railway is essential for the Quebec economy. In fact, if the Conservatives propose the creation of a high-speed train between Quebec City and New York, the Bloc would be in favor of it. But it's not because we'll vote in favor of this that we do approve of the Conservatives' way of doing things. They make others pay for what they broke. They threaten railway safety for years. They are asking companies to use them even though they're unsafe. So the government has to be coherent and tighten safety while allowing these companies to get the money necessary for the maintenance especially in the Gaspé. So, Mr. Speaker, I reiterate that the Bloc will support the bill, and I thank you for the time allowed for me to speak.
Questions et commentaires?
Questions and comments?
For Nickelbelt.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I would like to ask my honourable colleague from Quebec. I know that in his province there is a Liberal premier, as there is in Ontario. And in Ontario, the provincial Liberal government is not helping the situation at all with regard to rural railroads in Northern Ontario. So I would like to ask my colleague if he believes that the same thing is happening in Quebec with the Quebec Premier, the Liberal Quebec Premier. The Honourable Member for Haute-Gaspésie, Matapédia. Thank you very much. The provincial government in Quebec has already confirmed that it will provide financial assistance, but obviously does not cover the entire amount. We're talking about $17 million that could be granted. However, you heard earlier that the amount that would be needed in the short term to maintain the railway and to make sure that it is safe is some $95 to $100 million. So obviously the Quebec government has already been clear about its intentions, saying that it will contribute financially. But we're still waiting for a response from the Minister for the Quebec Economic Development Agency. So it's high time that the federal government gives us an answer, especially concerning the Gaspésie Railway.
Questions and comments? The Honourable Member for Saanich Gulf Islands.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I would like to thank my colleague from the Bloc for his speech. I also will be supporting this bill for safer railways. This is very important for Canada.
The House is moving to a place where we may have wanted to be some time ago, of members prepared to see this bill passed. I wanted to just add my words of support for the bill, and I think we are perhaps unanimous. I turn to my friend from the Bloc if you have any additional points. We do need to ensure that rail safety is a priority. This is a very important, if housekeeping bill. I hope that once this is passed, we can move on to look at the other issues that have come up in debate about improving access to rail, passenger rail, improving the freight lines, and potentially moving Canada into the 21st century of rail travel through high-speed rail. But those all are points that go beyond the legislation before us.
L'honorable député de Haute.
The Honourable Member for Haute-Gaspésie, Matapédia. I would like to thank my honourable colleague from Saanich Gulf Islands for her extremely pertinent comment. We are at a point where all the parties are ready to support this bill and adopt it. I think it is very important to strengthen rail safety. There's no doubt about that. I alluded earlier to this motherhood and apple pie issue, who can be against these kinds of things. But we do have to think, I apologize, we do have to think further ahead. This bill has to be adopted, and I would reiterate the importance for the government of having a very clear policy that would allow railways, regardless of where they are in the country, to be able to benefit from funding for the maintenance of this infrastructure, which is costly, but which it does a lot for our environment, for sustainable development, and for transportation, whether it be cargo transport or passenger transportation. So a clear policy of investment in our railways across the country.
Questions and comments? Resuming debate. Is the House ready for the question? And the question is as follows. Mr. LaBelle, seconded by Mr. Gossel, moved that Bill S4, an act to amend the Railway Safety Act and to make consequential amendments to the Canada Transportation Act, be now read a third time and do pass. Is it the pleasure of the House to adopt the motion? Yes. Agreed. I declare the motion carried.
Third reading of this bill, troisième lecture de ce projet de loi.
I believe the Honourable Chief Government Whip is rising on a point of order.
Yes, Mr. Speaker. I ask that you see the clock at 5:30.
Does the Chief Government Whip have the unanimous support to see the clock at 5:30? Agreed and so ordered. It being 5:30 p.m., this House will now proceed to the consideration of private members' business as listed on today's order paper.
Private members' business, consideration at second reading of Bill C-394, an act to amend the Criminal Code and the National Defence Act, criminal organization recruitment, standing in the name of Mr. Gill.
Mr. Gill, seconded by Mr. Albus, moves that Bill C-394, an act to amend the Criminal Code and the National Defence Act, criminal organization recruitment, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Debate, the Honourable Member for Brampton-Springdale.
Thank you, Mr. Speaker. Mr. Speaker, I'm thrilled to have this opportunity to share with the House the important measures introduced in Bill C-394, an act to amend the Criminal Code and National Defence Act, criminal organization recruitment. The focal point of Bill C-394 is to protect Canadians, especially our youth, by making the act of criminal organization recruitment, or in other words, gang recruitment, an offence under Canadian law. All of us can agree that our youth are our future. Absolutely. This is a statement that holds no partisan or political undertone. Each one of us in this House and every Canadian would agree that our youth will define the trajectory of this country, and that trajectory will be determined by the types of opportunities our youth are given. Young Canadians today have a sense of vulnerability about them. There are challenges that all youth face. My 3 young children constantly remind me of how important it is as a parent to provide for their safety and to protect them from any real or imagined dangers. I, like every parent, want the best for my children. I want them to be given every opportunity to succeed. To do this, I strive to create a safe environment in which they are free to grow and explore their potential. Unfortunately, not every kid or teenager gets to experience the life that they deserve. Sometimes the pressure to fit in or join a certain group are just too overwhelming, leaving youth vulnerable to those who might exploit their desire to belong. In a 2008 publication, the RCMP found that street gangs in Canada are increasingly aggressive with their recruitment tactics. In a disturbing trend, these criminal organizations are targeting youth under the age of 12 and as young as 8 years of old. These ruthless gangs pursue our vulnerable youth for several reasons. They know that those falling within this age range cannot be formally charged with a criminal offense. They also know that our youth can be easily pressured to participate in a variety of criminal activities. Our innocent and most vulnerable citizens are being manipulated, coerced, at times forced to embark on a life that no Canadian should ever experience. Gangs exploit our children by forcing them to participate in criminal activities such as drug dealing, robbery, theft, and prostitution. When I had the opportunity to speak with current and ex-gang members who led recruitment initiatives, they told me of a world that knew no boundaries. For instance, gang members will use drug addiction to manipulate potential recruits to take part in criminal activities that support the gang. This means that children, young kids, who should have been playing soccer on schoolyard are carrying weapons, drugs, and money. In the eyes of gang, these youth are dispensable and easily controlled. It is worrisome and heartbreaking that Canada's most violent criminal organizations actively recruit youth and teenagers. How can we as a nation sit by and watch this happen? I remember vividly what the director of Regina Anti-Gang Services told me as we sat side by side in a small room amongst hardened gang members seeking to exit that lifestyle. She told me that once recruited, these innocent children and teenagers were lost to the streets of the city forever. Promising young lives would vanish into the criminal culture forever. What makes this lifestyle so deadly is that leaving a gang is next to impossible. As I mentioned earlier, I had a chance to speak with several former and current gang members. I sat beside a young man, a mere 19 years old, who had been a gang member for more than 7 years. When I looked at him, I saw a kid. But as we got deeper into a discussion about his past, there was nothing in his life that resembled that of a youth. He was recruited into a gang at a very young age. Instead of school, friends, family, sports, he was robbing drug dealers, trafficking and attacking rival gang members, and selling drugs on the streets. This was a kid who excelled in a criminal organization because that's the only life he knew. I can't help but picture his work ethics allowing him to lead an extraordinarily successful, law-abiding life. Now he is battling a drug addiction, and because he is seeking to exit the gang, he constantly looks over his shoulder, fearing for his life. He told me that no matter what you do, you are never really out of gang. People that he recruited into the gang have experienced the same pain as him. He looked me in the eye and asked, by recruiting others into the gang, how many lives did I ruin? How many families did I hurt? And how many people have experienced pain at my hands? So I ask you, what type of life is this for a young person? We see lives being shattered by gangs, families destroyed, and our community safety placed in jeopardy. As a father, I fear the presence and power that a gang wields over a community and its most vulnerable citizens. As a members of parliament, I know there is more that we can do. In 2006, CSIS estimated that number of street gangs members under the age of 30 was approximately 11,000. Wow. The report cautioned that this number would continue to grow rapidly over the coming years. In Peel region, which my family and I call home, the number of gangs has exploded in the last few years. In 2003, there were 39. Today, there are well over 110 street gangs within our neighborhoods. This means more people live in fear, more young people are targeted, and more violence is used. Gang members in Canada have a blatant disregard for the safety and well-being of those around them. For instance, in some communities, families are afraid to leave their home or let their children play outside. Gangs also pose a significant risk for law enforcement officers. The increase in gang recruitment has far-reaching and systemic effect on our country as a whole. Our safety, security, and well-being are placed in jeopardy. The purpose of Bill C-394 is twofold. First and foremost, we're seeking to further protect our youth and our communities by criminalizing the act of gang recruitment. Far too many communities in Canada are facing a gang problem. It is vitally important that we maintain the security and safety of our neighborhoods, our streets, and our families. By tackling gang recruitment, we can help reduce the number of innocent and vulnerable citizens who would otherwise be lost in this dead-end lifestyle forever. This is about protecting our children, our neighborhood, and our future. Criminal organizations use fear, intimidation, and violence to advance their objective and grow within a community. This behavior can no longer be tolerated. Second, Bill C-394 is designed to provide law enforcement officers with additional tools to address gang recruitment. I had the opportunity to meet with numerous stakeholders across Canada to discuss this issue. The valuable insight we gained were used in the development of this bill. We spoke with several law enforcement officers who praised the bill's direction, scope, focus, and resourcefulness. The 2002 Canadian Police Survey on Youth Gangs, conducted under contract to the Department of the Solicitor General Canada, was the first of its kind in this country. This landmark study identified some startling figures. Of 264 Canadian police services surveyed, 57% believe that youth gang problem is getting worse. Most concerning is the fact that 44% reported that youth gang members have established a relationship with larger organized crime groups. The common theme that we witnessed while meeting with law enforcement officers was that more tools that they have to fight what they call the war on gangs, the better the outcome can be. Bill C-394 has taken that request and seeks to augment current efforts. Youth gang membership has and will continue to grow in this country if we sit back and do nothing. Restorative and preventative approaches complement other justice responses to criminal activity, but they cannot replace them. Bill C-394 is focused on addressing the criminal action that allow a gang to proliferate, strengthen, and grow within our communities. We are tackling the criminal conduct that is destroying our youth's lives and placing others in jeopardy on a daily basis. With this being said, I strongly committed to supporting a balanced approach to engage recruitment by advancing preventative and education-based programs across this country. We are focusing on bolstering our law enforcement, legal justice system to respond to the increasingly aggressive gang recruitment strategies that are ongoing. Bill C-394 will allow our justice system to appropriately hold those who recruit individuals into criminal organizations accountable for their devastating actions. By doing so, we will be able to take these dangerous criminals off our streets for good. This not only maintains the safety and security of our communities, but it offers the opportunity to severely inhibit a criminal organization's growth. When I spoke with the president and CEO of the Boys and Girls Club of Winnipeg, he told me a story that exemplified the need for this proposed legislation. At one of their inner-city club chapters, gang members will wait under the parking garage directly behind the building. Their sole purpose for being there is to engage those leaving Boys and Girls Club in hopes of recruiting them into their gangs, a targeted strategy that is not a coincidence. This example highlights the reality that our youth in our communities face. Education and prevention programs are only part of our response. We need to provide our justice system with the ability to respond through legal action. Imagine for a moment if these children, youth, teenagers were empowered to report those trying to recruit them. Imagine if our community members knew that something could be done about gang recruiters who operated in their neighborhoods. It would empower communities to take action. Today we have an opportunity not just as members of Parliament, but as Canadians to come together and make a difference in our neighborhood. I urge each one of you to view this bill for what it is, an important new tool in our criminal justice system that will benefit families, communities, and future generations. It is time that we take back our streets from criminal organizations that are increasingly threatening their grip on our freedom, safety, and security. It is time we take a stand so that every child, teenager, and adult can experience the life that they deserve to live. Thank you, Mr. Speaker. Merci beaucoup.
Questions and comments. The Honourable Member for Beaumont-Missisquoi. Introducing more and more mandatory minimums into the criminal code is increasingly depriving judges of their discretionary power in sentencing. So I would ask my honorary colleague, why does the government insist on going in this direction that has been severely criticized by a number of legal experts?
Member for Brampton Springdale.
Thank you, Mr. Speaker, and I'd like to thank the honourable member for his question. As I mentioned, there was a very detailed consultation done
on this private member's bill before this was introduced. I traveled across the country, spoke to thousands of parents, stakeholders, law enforcement agencies, boards of education, and this bill was developed with everyone's input. I don't believe there is anything that we can do which will not help our young children, our youth, our future, in order to protect them. So whether that's minimum mandatory sentences, judges do have the discretion that they can use for a maximum prison time of up to 5 years. But in terms of youth under the age of 18, I believe it is essential that we have minimum mandatory sentences to hold these criminals accountable for their actions who are destroying our youth and ultimately our future. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. Mr. Speaker, this is a very serious issue in the province of Manitoba, as I'm sure many Canadians are concerned about it. During the 90s, in fact, there was very little marginal gang type of activities, and it wasn't until the turn of the century where the numbers really started to increase. Today, unfortunately and sadly, gang activity is somewhere between 2,000 to 3,000 estimated in the province of Manitoba, which causes a great deal of concern. It is one of those issues, Mr. Speaker, that is of great concern to my constituents, as we try to make this a priority issue. But I can tell the member, and I would ask the member, that in looking at trying to deal with gangs, the best way to deal with gangs and gang recruitment is, in fact, to try to provide alternative activities for those individuals that are what I would classify as high risk and susceptible to being recruited by gang members. And this is really where the government has really dropped the ball. So to fight gang recruitment activities, I would suggest to the member that one of the things that the government really has to put more emphasis on is trying to find those alternatives to keep kids and young people out of the situations. He made reference to the Boys and Girls Club as one example. Somewhat sad story that he made reference to. Thank you, Mr. Speaker.
Member for Brampton Springdale.
Thank you, Mr. Speaker, and I'd like to thank the honourable member for his question. I'm all for alternative measures, but the problem is those measures alone do not solve the problem. There are criminals that will, their sole purpose or their sole objective is to target youth, and these are repeat offenders. They're doing this over and over and over again, destroying our youth. So I feel it is absolutely necessary that we give these tools and resources to our law enforcement officers and also our justice system so they can hold these criminals accountable for their actions.
That's right. Questions and comments? Questions et commentaires? Reprise de débat.
Resuming debate. The honourable member for Brome-Missisquoi. Thank you, Mr. Speaker. At the outset, I want to announce that the NDP will support this bill, Bill C-394, at second reading. But this isn't a blank check. We will be considering this bill in detail in committee with expert witnesses, and we will examine each clause in Bill C-394 and look at what amendments may be needed. I'm pleased to speak today on Bill C-394, an act to amend the Criminal Code and the National Defense Act. This is a private member's bill that amends the Criminal Code and creates a new offense with respect to organized crime, which is the recruitment of someone for an organized crime organization. There is already a set of rules in the Criminal Code prohibiting criminal organizations, the participation in criminal organization activities, an offense for the benefit of a criminal organization, or charging giving a person directions to commit an offense for such an organization. This bill would add a fourth offense,
which would be that of recruiting an individual for a criminal organization as defined in the criminal code to increase the ability of such an organization to carry out criminal acts. Through this bill, my honourable colleague would like to reduce the recruitment by gangs. Gangs are criminal organizations that exist across Canada and have done so for decades in Quebec, Nova Scotia, Ontario, Manitoba, Saskatchewan, Alberta, and British Columbia. Criminal organizations, these gangs, are growing, and we must do everything we can to combat them. Gangs are changing in how they work, and there are increasing numbers of young people joining them. The members of gangs are often young people from vulnerable socioeconomic backgrounds with family problems. The gangs also target young girls and those who are in prison. I would like to thank my colleague for having introduced this bill that is at least a partial solution to the gang problem. Public safety and security is a priority for the official opposition, and we are always very interested in examining any kind of legislation that would amend the criminal code. However, although I acknowledge the legitimacy of this bill sponsored by my colleague, I believe that the penalties under this new provision are inappropriate. The bill calls for a maximum sentence of 5 years, and for recruitment of a minor, a mandatory minimum sentence of 6 months. The principle of mandatory minimums is one that has been criticized from a legal point of view because it deprives judges of their discretionary powers, which are fundamental. This penalty would therefore restrict the powers of judges. We feel that we do need to take action against criminal organizations, but this will not be enough to eliminate the problem of gangs and their influence in our society. Prevention is as important as enforcement and repression, and we have to encourage more programs to be set up to help young people who live in cities where gangs are particularly present so that our society can move in a positive direction. We also need to encourage cooperation among the various stakeholders. To illustrate my remarks, I would quote Louis Lacroix, who's responsible for a program dealing with young offenders in Montreal. And he said that all of us were doing good work in our area of expertise, but no one was able to really deal with the gang problem. American studies have shown that a concerted approach within a community is more likely to succeed than any action that is taken in a silo. There are various projects that have been carried out in various provinces, and the federal government, through the National Crime Prevention Center, the schools, the associations, the music industry, various foundations, banks, municipalities, the legal profession, correctional services, and the police have all taken part. It is important to build on these initiatives, and the government should support them. It is essential to provide the funding and the human resources to police officers on the front lines. However, it seems that the current government has failed in this responsibility. It has not taken into account the suggestions made by these professionals who deal every day with street gangs. I would also like to quote the report comparing the approaches used with
young people at high risk of being brought into gangs that was made public in 2011. And the report indicated that in 2009 there was a meeting with the Canadian Association of Chiefs of Police that led to the recommendation and adoption of a national strategy to deal with gangs. The strategy would help by providing additional police resources so that street gangs could be dealt with. But this strategy has not yet been adopted. This shows that the current government is refusing to provide funding for municipal frontline officers and lacks vision to deal with public security. The Conservatives say that they want to deal with criminal organizations by trying to reduce recruitment of people into gangs, but they are not meeting the needs of our Canadian public. They announced in 2011 that they were going to slash the funding for the activities that tried to fight gangs. The NDP reacted to that and called for prevention programs. And because of the NDP, the Harper government changed its mind and provided funding for the program. The government has disappointed the provinces by not providing enough funding to recruit more frontline police officers. Though the fund was created in 2008, it will expire in 2013. And once again, the Conservatives have not kept their promise. Canadians are expecting that this House will take reasonable steps to meet their expectations, because living in communities without crime and violence is a priority. This bill is a partial solution, but we need a balanced approach between repression and prevention so that our society will be more harmonious. Thank you, Mr. Speaker.
Debate. The honourable member for Mount Royal.
Thank you, Mr. Speaker. While the debate this evening is on Bill C-394 and criminal organization recruitment, it reflects and indeed invites initial comment on the overall approach to criminal policy by the Conservative government in general. For in this bill, we see the problems of this generic approach to criminal law, namely that everything is a matter for the criminal law, even if there already exists an offence in the criminal code on this issue, that the only way to address these criminal matters is through the prism of punishment, and that the best approach to punishment is through the use of mandatory minimums. Frankly, Mr. Speaker, this is at variance with long-standing principle, policy, and an evidence-based approach to criminal justice. And the government's preoccupation with this type of legislating is not only somewhat disingenuous, but also ineffective, wasteful, prejudicial, constitutionally suspect, and simply put, bad public policy. I realize that colleagues in this place may be somewhat surprised that I'm beginning with this type of approach and perspective, but I believe that as a chamber, given this whole approach to policy making, that we must take a step back and gain some perspective on what we are doing. I know that the government is very quick to pounce on these type of critiques and to label those who make them, be it the Liberal Party or others or myself, as being soft on crime. But, Mr. Speaker, we all have a shared commitment to combating crime. The issue is, how do we combat it? Whether we are smart and effective on crime, or whether we are in a situation where we are simply legislating for the sake of legislating and sending a signal as if we are tough on crime, when in fact the very subject matter may already be present in the criminal code. And so, Mr. Speaker, if one looks at the legislation, it proposes to punish anyone, and I quote, who recruits, solicits, encourages, or invites a person to join a criminal organization. This offence would become the new Section 467.111 of the Criminal Code. But, Mr. Speaker, and this is the important point, enhancing the ability of a criminal organization is already a crime under the Criminal Code. Section 467.11 of the Code, the very section to which this bill adds a subsection, clearly states, and I quote, every person who, for the purpose of enhancing the ability of a criminal organization to facilitate or commit an indictable offence under this or any other Act of Parliament, knowingly, by act or omission, participates in or contributes to any activity of the criminal organization is guilty of an indictable offence. Mr. Speaker, I have no problem with legislation that sometimes seeks to make a necessary clarification to the law or indeed to enhance the law. But what is being suggested here is that somehow, without this bill, there will be no offence with respect to gang recruitment. Yet recruitment previously was one of the issues on the minds of the legislators themselves in this House, as evidenced by the fact that when enacting Section 467.11 in 2001, the then Minister of Justice, Anne McClellan, said in this place upon the introduction of what is currently in the Criminal Code, and I quote, in order to reference that this was already anticipated and then implemented as law. And I quote, we know that successful recruitment enhances the threat posed to society by criminal organizations. It allows them to grow and to more effectively achieve their harmful criminal objectives. Those who act as recruiters for criminal organizations contribute to these ends both when they recruit for specific crimes and when they recruit simply to expand the organization's human capital. Thus, the express provisions of the proposed participation offence make it clear that the Crown does not, in making its case, need to link the impugned participation, in this case recruitment, to any particular offence. In fact, these words could have been spoken by the introducer of this particular bill, because that particular section in the Criminal Code already covers what this bill purports to do, as reflected in the words of the then Justice Minister at the time. Indeed, Mr. Speaker, this is the current state of the law, and Section 467.11 of the Criminal Code goes on to note that in a prosecution for an offence under Section 1, subsection 1, it is not necessary for the prosecutor to prove, and it goes through a whole series of factors which, for reasons of time, I will not enter into here, only to state that if one looks at the offence, one sees that it already covers that which this bill purports to do. Mr. Speaker, I don't therefore wish to dwell on some of those technical points of law. Suffice it to say that the behaviour this new offence seeks to criminalise is something already criminal under another provision of the Criminal Code. And indeed, whatever act that would give rise to this proposed section would also likely be criminal under another section, such as the offences relating to counselling, aiding, abetting, conspiracy, and the like. As such, Mr. Speaker, Bill C-94 is both duplicative and arguably duplicitous as well. Duplicative in that it essentially repeats what is already in the Criminal Code, and somewhat duplicitous in that it is being presented as if this is our only option with respect to combating gang recruitment, and as if there is no present offence that deals with this issue before us, and that those who somehow will oppose this piece of legislation are, again, as I indicated, somehow soft on crime or don't care about street gangs and the like. As I mentioned, Mr. Speaker, in my introduction, Conservative crime policy, regrettably, is all about punishment. Yet, Mr. Speaker, we should be seeking to prevent young people from joining gangs to begin with. This involves an understanding and appreciation of the serious initiatives that need to be taken with respect to education, social services, and the like, in order to allow people to stay in school for as long as they can, to provide them with employment opportunities so that young people are shown that there are alternatives to gang life. Yet, Mr. Speaker, this would involve, and this is the core of my remarks here this evening, this would regard and require us to address the underlying causes and concerns relating to gang crime. Housing, poverty, income equality, employment, minority inclusion, access to education and the like, and an understanding of why young people, in fact, do join gangs. Mr. Speaker, there is no young person in Canada contemplating gang life because they believe there is no offence against it or their recruitment in the criminal code. Indeed, Mr. Speaker, as I said, there are plenty of offences in the criminal code, an ever-expanding list that has grown tremendously with the adoption of Bill C-10. And yet, this does very little to address the root causes and concerns of crime. In fact, many of them will only lead to an increase in crime. Here, Mr. Speaker, I am speaking in particular of mandatory minimum penalties, something which Bill C-394 seeks to add yet again to the criminal code in the matter of gang recruitment. While I have spoken many times in this House on this point, once again one finds an ignoring or marginalizing of the evidence with respect to the fallout of mandatory minimums. Simply put, not only do we know that mandatory minimums do not deter crime, rather they tend to increase crime, both within prisons, which become schools for crime, and outside prisons. They do not deter crime is not my conclusion, Mr. Speaker. It is one reached by studies the world over and even our own Justice Department here in Canada. They remove necessary prosecutorial and judicial discretion, leading to pleas for lesser offences or forcing trials where there may have been none. This clogs the courts, and as the Canadian Bar Association has warned that, with the addition of more mandatory minimums, we may end up in a situation where more accused are in fact set free, contrary to the intention and objectives of the government's legislation to begin with, simply because their charter right to a fair trial within a reasonable period of time has been invited. Moreover, mandatory minimums will lead to further overcrowding in prisons. Yet prisons in this country are already overcrowded, and we have seen in the U.S. court judgments that overcrowding amounts to cruel and unusual punishment. Lastly, though perhaps most important, such sentences also invite constitutional critiques and have struck down such mandatory minimums as we saw recently in the Ontario courts for being cruel and unusual, arbitrary, disproportionate, outrageous and intolerable. While I do not have the time to elaborate further, Mr. Speaker, I would like to conclude by simply reminding members that the criminal law should be as much about prevention as it should be about punishment, and our approach to social evils should be as much to ensure that individuals and groups have a viable way of avoiding that which leads them into gang recruitment through all the causes and concerns that I addressed earlier in this regard. Thank you, Mr. Speaker.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice.
Mr. Speaker, it's my honour and pleasure to rise to speak in favour of Bill C-394, an act to amend the Criminal Code and the National Defence Act, recruitment by criminal organizations. Mr. Speaker, it's an honour for me to table a bill that is very dear to my heart and that is very important for the House of Commons.
C-394 is relatively straightforward and has as its focus a practice that enhances the ability of organized crime groups to engage in criminal activity, that is, the recruitment of members to join criminal organizations. In particular, the bill's sponsor, the member for Brampton-Springdale, seems particularly concerned about the recruitment of young persons to join criminal organizations. In this regard, I strongly support his proposals, and I am sure that his amendments will be met with wide support. J'encourage mes collègues à voter pour.
I encourage my colleagues to vote in favour of this bill.
The substance of the proposed amendments, I think it is important for me to provide some context regarding the state of organized crime in Canada. According to 2011 estimates by Criminal Intelligence Service Canada, 729 organized crime groups are active in Canada. This number tends to change from year to year. The reasons for this fluctuation include changes in intelligence collection practices, the relative fluidity of some of these organized crime groups, and law enforcement policing practices that have disrupted the activities of these organizations. Many of these groups are street gangs who are active in the trafficking of illicit commodities. Most notable among these goods is drug trafficking. However, street gangs are also widely known to be involved in street-level prostitution, theft, robbery, fraud, and weapons offenses. The wide range of organized crime activity undermines community safety, interferes with legitimate economies, and costs Canadians millions of dollars each year. Furthermore, organized crime frequently resorts to violence to achieve their criminal objectives, putting the public at risk as a result. For organized crime groups to be successful, they must constantly ensure that they have enough members to carry on their criminal activities. When people are successfully recruited into a criminal organization, it enhances the threats posed by these groups to society at large. As the members increase, the criminal influence of those gangs or chapters of gangs are increased. Frequently, these groups or individuals acting on their behalf target young people. Organized crime groups may do so because young persons are more vulnerable and can be convinced that joining such groups will bring them money, respect, protection, and companionship. They may convince young persons to engage in criminal activity by telling them that even if they get caught, the justice system will be lenient on them because of their age. Mr. Speaker, parliamentarians and indeed all Canadians should be rightly concerned about this. Bill C-394 proposes to create a new indictable offence that would prohibit anyone, for the purpose of enhancing the ability of a criminal organization to facilitate or commit an indictable offence, from recruiting, soliciting, encouraging, or inviting a person to join a criminal organization. This new offence would be punishable by a maximum of 5 years imprisonment and also proposes a mandatory minimum penalty of 6 months imprisonment where the person recruited is under the age of 18 years. It is worth noting that this offence mirrors the language of the existing criminal code offence of participating in the activities of a criminal organization found at section 467.11. It also has the same maximum penalty. This is appropriate, Mr. Speaker, because recruitment is a specific example of participation. In fact, the existing participation offence has been used to address recruitment in the past. Now, some members in the House might question the need for this standalone offence, given what I have just said. These same members may argue that the existing participation offence is adequate and that duplication or overlap in the criminal code should be avoided. In my view, the enactment of a specific offence which explicitly prohibits the act of recruitment serves a more than valuable function. It sends an unequivocal message reflecting Parliament's intent that such conduct must be condemned in the clearest of terms. It educates the community and reflects the important principle that the law must not only be clear, but must also be clearly understood. There can be no doubt that this offence will put on notice those who would seek to recruit others to join a criminal organization. One of the most important aspects of this new offence is that it provides police and prosecutors with an additional tool and will allow them to make a determination of which offence best fits the facts of a particular case. Let me be clear, Mr. Speaker. This bill provides additional tools to law enforcement officers. In addition to this offence, the bill proposes a number of other amendments. These amendments would ensure that the new offence would be treated the same way as the other criminal organization offences in respect of procedural, evidential, and sentencing matters in the criminal code. As I'm sure all members know, the criminal code contains a number of special rules in relation to organized crime. For example, in cases where someone has been charged with a criminal organization offence, there is a reverse onus, which requires an accused to show why their custody pending trial is not required. Another example is that for persons convicted of any of the specific criminal organization offences, any sentence that is imposed on them must be served consecutively to any other sentence for an offence arising out of the same series of events. So the proposed consequential amendments in Bill C-394 ensure that the Criminal Code is consistent and coherent in its treatment of organized crime investigations and prosecutions. I strongly support these amendments. Mr. Speaker, before concluding, I wish to pause in order to draw attention to a couple of technical concerns that I have identified with this bill, and which I expect could be readily addressed through technical amendments without interfering with the objectives of the bill. The first relates to the way the new offence is characterized. In the bill, the offence is called recruitment of members by a criminal organization. While it is certainly true that much of the recruitment will be done by gang members, it is not, strictly speaking, required. That is, the offence is not limited to recruitment by gang members. This is an important distinction, Mr. Speaker, because we don't want an overly restrictive offence. So in order to make it clear to everyone, I would support a technical amendment to change the way this offence is described. I would also note that there appears to be some discrepancies between the way the English and French versions of the bill are drafted. For example, in the English version of the offence, the words used are, quote, to recruit, solicit, encourage, or invite a person to join a criminal organization, end quote. In other words, the recruitment can refer to any criminal organization, whereas in the French version, the recruitment must be done into the specific criminal organization that will be enhanced. So as currently drafted, the English is broader than the French. Based on my understanding of what this offence is trying to do, as well as looking at the existing criminal organization offences, the French version seems to be more accurate. And so a technical amendment to address this discrepancy should be made. Mr. Speaker, these are minor changes that I think will strengthen the bill.
I'm prepared to debate an amendment that would allow us to specify this intention. I would ask all members of the House to support Bill C-394.
Strongly support this bill and look forward to working with the sponsor and all members to move it quickly into law. Thank you, Mayor.
Reprise de débat.
Debate. The Honourable Member for Châteauguay-Saint-Constant. Thank you, Mr. Speaker. It's with great interest that I speak today to Bill C-394, a bill tabled by the member for Brampton-Springdale that I congratulate for this initiative and recognition of the fact that the problem of criminal gangs of Canada continues to grow. And this is a major problem that we have to address. So I thank the member for having allowed us to look at solutions that could be brought forward to solve these problems. I'd like to say at the outset that the NDP feels that legislating on the problem of street gangs will not be a panacea for this problem. We have to look at other solutions as well, rather than just legislate. In the NDP, we feel it's important to protect our young against gangs and criminal organizations. We feel that this is an important tool to stop the growth of the phenomenon of street gangs. This is why, during the election campaign in 2011, we'd included this important issue on our platform. We advocate a balanced approach in public safety matters, combining prevention and repression. The priority of the NDP is to fight gangs by adopting a balanced approach. This allows us to meet the expectations of our fellow citizens who want to live in communities with no violence while preventing crime and having more programs that will be effective to combat the recruitment of the young into street gangs. There are 3 offenses in Section 467.11 of the Criminal Code: participation in the activities of a criminal organization, the commission of a crime for the profit of a criminal organization, and charging a person with committing a crime for the benefit of a criminal organization. So the bill adds another offense, recruiting a person for the benefit of a criminal organization for the purpose of enhancing its ability to facilitate or commit a criminal act. So this is a new legislative tool, and that's the central measure of this bill. We have no problem supporting it, but we do have reservations concerning minimal sentences. Allow me to remind the member on the government side that every time an attempt was made to have minimum sentencing in the criminal code, the Supreme Court invalidated such minimal sentences because they don't allow a judge to take into account mitigating circumstances that could have been in play during the commission of a crime. That can be a major problem. And I would have liked to see the Conservative members stop always being tempted to impose minimal sentences, because that's not always appropriate, Mr. Speaker. Let's remember that for young people, there is a fundamental human need to identify and belong to a group. If young people don't have that sense of belonging to their family or their school, for instance, they may unfortunately turn to gangs to find this feeling of belonging. Peer pressure, the desire for protection, and the need for identification can influence the decision of a young person to join a criminal organization. Families and children in poverty or unemployment or with family problems are often more vulnerable to gang recruitment. In certain urban areas, for example, where poverty and violence are a daily occurrence, young people may feel vulnerable to the point that they will want to join a gang because it's a guarantee of survival. That may seem to them their only option. So joining a gang can seem to them the best alternative to their current life situation, particularly if they come from a poor environment or if they were the victims of physical or sexual abuse in their youth. By stopping gang recruitment, we're also tackling the very foundation of these organizations, recruitment in order to continue illicit activity. Data indicates that almost half the members of street gangs in Canada are under 18. They're mainly between 16 to 18 years old in 39% of cases, and almost half are under 18. They also come from various ethnic groups, a huge number of them. Although young people's gangs are mainly made up of young men, we starting to see a stronger proportion of young women in these gangs because there are many ethnic factors, geographic, demographic, and socioeconomic factors. So a growing number of teenagers run the risk of being involved in these gangs or being influenced by them in the future. In 2008, it was estimated that there were 900 gangs and almost 7,000 members. Many of these young Canadian gangs are involved in criminal activity that is very worrisome, such as assault, drug trafficking, robbery, burglary, breaking and entering, and vandalism. There's a worrisome relationship between a large number of youth gangs and organized crime. Most gangs require that a new member go through a form of initiation that can go from beating, which means getting beaten by a number of other gang members for a certain number of minutes. Most of them will also be asked to commit a crime in order to join the group. This applies both to girls and boys. Like many criminal organizations, women are not considered equal in these groups. They are mainly invisible or not important until the male members need them to do something. Women who are members of these gangs usually participate in the same activities as the men in the group. However, they take a lot of risks and don't have the same status as their male counterparts. Moreover, Female gang members are often the victims of abuse such as rape and assault by male members of the gang. They can also be sexually exploited by the male members of the gang. Gangs and criminal organizations recruit more and more young people that are younger and younger. That's why we have to address recruitment to protect our youth. Not only must this be made illegal to recruit into gangs and criminal organizations, but we have to emphasize prevention of crime among youth. It is through these kinds of programs that we can identify the young people who may be vulnerable to recruitment. It's important to break the radicalization process so our young people can develop without any negative influence from these gangs. In addition to the criminalization of recruitment, we want to see more resources allocated to prevention of crime programs, especially those targeting the young. We want our police forces to have sufficient resources to protect communities throughout the country, but to achieve this, we have to cooperate with the provinces, the territories, and communities such as the First Nations. The battle against crime must be done in partnership with all players in the legal and social sectors. We've pleaded for increased investment in frontline policing. We've also asked for financial means to fund programs for crime prevention programs for the youth, but the government has refused to fund these programs for frontline municipal police officers. So the Conservatives have disappointed the provinces concerning a provincial police officer recruitment fund in order to recruit more officers to work on the front lines. That would be a very useful program, and it will end in 2013. Once again, the Conservatives say that they want to fight criminal organizations, but they don't respond to the expectations of Canadians. In closing, I just want to reiterate the importance of prevention programs. The punitive approach has limits. The best way to prevent the recruitment of young people into criminal organizations is to combat poverty and the various factors that push individuals to participate in organized crime. Crime is caused by a number of social factors, and that's what we have to combat. That's how we will have a greater impact in our fight against crime and the indoctrination of young people within criminal gangs. Thank you, Mr. Speaker.
Before I recognize the Honourable Parliamentary Secretary to the Minister of Finance for resuming debate, I'll just let her know I'll need to interrupt her about 4 minutes into her speech, as this is the end of private members' business for today. The Honourable Parliamentary Secretary to the Minister of Finance.
Well, thank you for that, Mr. Speaker. And I'm going to begin by reading some of the speech that I've prepared for today. But then I do want to take a moment to give you some practical examples of how this is actually affecting the youth in not only my community and in my province of Manitoba, but in many communities across this country. So please let me start. Bill C-394, of course we know, would create a new offence that addresses the practice of recruiting or encouraging persons to join a criminal organization. And the person who is recruiting must be doing so in order to enhance the ability of the criminal organization to commit or facilitate the commission of an indictable offence. Organized crime, to be successful, requires a constant stream of new recruits, and these individuals replace others who have either been incarcerated or perhaps worse. New members join the ranks of an existing organization so that the group can maintain or expand its criminal enterprises into new territories or new activities. What is particularly disturbing is when young people are targeted. And in many instances, the job of the recruiter is very easy because they target our most vulnerable young people. Now, this leads me into some examples. As you know, Mr. Speaker, I have been a police officer for some 19 years with the Winnipeg Police Service. I intend to go back to the police service. What brought me here to this House, in fact, was the failure of the previous Liberal government to address our youths being recruited by criminal organizations, our youths being exploited into the criminal element. The Youth Criminal Justice Act was created by the previous Liberal government. It was supposed to address this exploitation of our youth. It was supposed to address the fact that our kids were being dragged into gangs. Well, it did none of that. In fact, it removed denunciation, it removed deterrence from the Act itself. It created an environment where criminal organizations can actually easily target our kids into gangs. As a result, I myself, as a police officer, and many police officers across this country, experienced direct recruitment by gangs of our youth by providing them with incentives. Now, I know that the Liberal member from Winnipeg North is in the House right now. I really want him to pay attention because it is in his area that I experienced this kind of recruitment that was fairly common in Winnipeg following the Youth Criminal Justice Act put forward by the previous Liberal government. First of all, what the criminal element will do is they will target a vulnerable youth that perhaps does not have parental supervision, perhaps is in a low-income family, perhaps they haven't been able to eat, or perhaps they aren't going to school. They target these kids and they convince them by incentives to become gang members. They give them $50 to go into Safeway to steal a tube of toothpaste. They give them $50 after that to go into a house that the adult will break into, but they'll ask them to steal a tube of toothpaste for $50. And then they'll start to ask them to deliver packages for $50. What's in the package? Drugs. Now the child, without knowing, is a drug dealer. The gang member then discloses that they have this information and threaten the young people to stay in the gang and work for the gang, which is despicable. This is what the Youth Criminal Justice Act did to the children in my community. And this bill will help us to stop that kind of behavior. And I applaud it 100%. I know police officers across the country will applaud it. And I encourage the members of both opposition parties to please consider supporting this. It is absolutely necessary. It will do such wonders for our youth in our communities. And it is high time that we address these victims who are unnecessarily being put at risk. Thank you, Mr. Speaker.
The honourable member for St. Boniface will have 6 minutes remaining when the House resumes debate on this motion. The period provided for private members' business has now been expired, and the order is dropped to the bottom of the order paper. Now, pursuant to Standing Order 38, a motion to adjourn the House is deemed to have been moved and seconded at this time. Therefore, the question is that this House do now adjourn.
Honourable member for Scarborough, Rouge River.
Thank you, Mr. Speaker. I'd like to also thank the Parliamentary Secretary for being here tonight. Mr. Speaker, this winter we learned of the Conservative government's plan to raise the eligibility age for OAS from 65 to 67. This announcement goes against one of their own election promises, which was, and I quote, Mr. Speaker, "We will not cut transfer payments to individuals or to the provinces for essential things like health care, education, and pensions," end quote. Just for the record, that can be found on page 23 of the Conservative 2011 election platform. The Prime Minister reiterated this promise on June 7, 2011, when he stood in this very House and said, quote, again, this government has been very clear. We will not cut pensions, end quote. Currently, there are nearly 5 million seniors collecting OAS and 1.7 million seniors collecting GIS. That means 1 in 3 Canadian seniors receive the GIS. What will this eligibility change mean to Canadian seniors? The lost income to Canadian seniors from this change will be significant, Mr. Speaker. It will mean a loss of roughly $30,000 to the poorest seniors over these 2 years and roughly $13,000 over these 2 years for Canadians who receive only OAS. This is a substantial loss, Mr. Speaker. Unlike the CPP or private savings pillars, the OAS is a universal pension that does not depend on a retiree's previous labour market participation or their participation in a registered pension plan or savings plan. In the words of the Canadian Centre for Policy Alternatives, the OAS and GIS are the, quote, basic building blocks of the public universal system. They go on to say, which make up the anti-poverty part of the system, end quote. The OAS pays a maximum benefit of $540 per month. On an annual basis, the maximum OAS payment is $6,481. The average monthly payment, Mr. Speaker, in the fall of 2011 was $508.35. High-income seniors must pay back all or some of their OAS benefit due to a formula set by the government. Above an income of $69,562, the OAS begins to be clawed back. By an income of $112,772, the OAS benefit is completely clawed back. Because many senior women were not part of the labor force earlier in their life, today's seniors, the OAS and GIS are particularly important retirement instrument for these seniors. Senior women are less likely than senior men to draw an income from the CPP, private pensions plan, RRSPs, or employment earnings. This makes universal programs like the OAS and GIS particularly important for our female seniors. The median income for a senior woman is about 2/3 that of the median income for senior men. So let's be clear, Mr. Speaker. The OAS is really an anti-poverty and an equity tool used to ensure that seniors can retire with dignity, to have funds to support their retirement. Mr. Speaker, it is loud and clear. This government's priority is to spend billions of dollars on corporate tax giveaways to their friends while slashing the services that Canadians rely upon. That is wrong. Will this government listen to the expert advice they were given from the Parliamentary Budget Officer, the leader of the OECD pensions team, and the head of the BMO Retirement Institute, among others? Stop manufacturing a crisis to take away future benefits from Canadian seniors and keep old age security eligibility at age 65.
The Honourable Parliamentary Secretary to the Minister of Industry.
Well, thank you, Mr. Speaker, and I thank the honourable member for her question or her speech. I want to start by assuring the honourable member that our government is taking action today to protect seniors of today and tomorrow. In her original question, the honourable member spoke of young Canadians who are concerned about the financial security in their senior years. I want to point out that this is exactly the reason why we're making changes to the old age security now, to protect it and to ensure that it's affordable and available for all Canadians in the future. As pension expert Keith Ambachir observed recently, we're facing large demographic changes that we cannot ignore. Mr. Ambachir, who's the director of the University of Toronto's Rotman International Centre for Pension Management, has gone on record saying that there's a serious fairness argument that can be made regarding the future of OAS. He says, and I quote, "We can't just willy-nilly put the burden on a relatively smaller cohort that's going to be the workforce 20 years from now and say, well, you know, that was the deal back then, so too bad. We don't care that there's less of you than there is of us," unquote. Let's look at that relatively smaller cohort that he spoke about, the working-age Canadians of the future. We already know that the ratio of working-age Canadians to seniors is expected to fall. Within 2 decades, it's projected that there will be close to 2 workers for every retiree. That's a stark contrast to today's ratio, where there are 4 workers for every retiree. What will happen, of course, is that as this ratio shifts, is that the younger generations will be forced to carry the bulk of the tax burden. This will hamper their ability to save and will have an adverse impact on their future, on Canada's future. Mr. Speaker, younger Canadians will be carrying the bulk of the tax burden as they're raising families, paying student debts, making mortgage payments, and just trying to make ends meet. Speaking of the future, there are a few other projections I'd like to focus on. According to the Chief Actuary, the number of basic OAS recipients is expected to almost double over the next 20 years. He projects the number growing from 4.8 million in 2010 to 9.3 million by 2030, when the last of the baby boomers reach 65. When we consider these numbers in the context of our aging population needs, we have to be willing to acknowledge that change is necessary. Mr. Speaker, Canada's prospects are bright. Among the G7 countries, Canada has posted the strongest growth in employment, with 693,000 jobs created since the depths of the recession. Thanks to the strong leadership of our Prime Minister and our Conservative government, Canada is in the enviable position of having the financial flexibility to phase in these changes over a very lengthy period of time. This will ensure the maximum time for Canadians to adapt to these changes with minimal disruption to the quality of life future generations are counting upon. We must confront both our fiscal and demographic realities as we decide what's in our best interests moving forward. Thank you, Mr. Speaker.
The honourable member for Scarborough Rouge River.
Thank you, Mr. Speaker. I'm not sure where the parliamentary secretary is getting some of his numbers, and of course the government, on his behalf, the government. We've heard from the parliamentary budget officer that the OAS is easily sustainable and is actually projected to decrease in cost relative to the size of the economy in the long run. Furthermore, these changes are really coming at the cost of Canadian youth, as I mentioned in my previous question, and as the parliamentary secretary mentioned himself. These youth are already struggling to find good jobs while carrying an enormous amount of student debt, meaning that they will make less money over their lifetime than their parents and grandparents did. Now, we're forcing them to work 2 years longer to pay for a crisis that this government is manufacturing. This government isn't helping our youth. They're further hurting them. They're cutting from the poor to give to the rich, Mr. Speaker. Since coming into office, this government has given $72 billion in tax giveaways without a single promise or guarantee of a job. Will this government commit to reversing the change in the age of eligibility for OAS?
The Honourable Parliamentary Secretary.
Well, thank you, Mr. Speaker. And Mr. Speaker, I know this honourable member. I know her to be a smart individual. I would implore her to actually look at the math here. We have 4 people paying for every retiree, 4 workers paying for every retiree now. In 2030, we'll have 2 people paying for every retiree. This is not complicated math. By way of a parallel, maybe consider a house rented by 4 university students. If the rent is $1,600 a month, they each pay $400 right now. If 2 of them leave, there are only 2 left to share the rent, and those 2 will each have to pay double. They'll each have to pay $800. When the landlord comes for her money, the NDP strategy of blocking their ears and repeatedly saying that there isn't a problem isn't going to change the fact that the cost has doubled, Mr. Speaker. So again, I urge the NDP to actually look at the math behind the decision the government's taking, and when they do, I'm confident that they'll support us on this.
L'honorable député de Beauharnois.
The honourable member for Beauharnois-Salaberry. Thank you, Mr. Speaker. Mr. Speaker, numerous studies have shown how dangerous chrysotile asbestos is for the health. According to the World Health Organization, all forms of asbestos are carcinogenic and can cause mesothelioma, which is a form of lung cancer, larynx or ovary cancer, or asbestosis, pulmonary fibrosis, and the appearance of plaques. It is estimated that 125 million people are exposed to asbestos in the workplace. Over 107,000 people die each year from a disease resulting from exposure to asbestos. The use of asbestos is banned in 52 countries, and most of the countries in the world have supported the addition of asbestos to the list of dangerous materials under the Rotterdam Convention, but Canada is opposed to this. The WHO says that the best way of eliminating a disease related to asbestos is to put an end to the use of all types of asbestos. And yet, many types of materials can replace asbestos. For example, inorganic synthetic fibers, such as textile fiberglass or insulating wool, from glass material or rock material. Organic synthetic fibers can also be used as insulation. Also called chemical fiber, they are generally obtained from plastic materials or polymers.
And it is worth looking at materials that are less damaging to our health. According to the Canadian Cancer Society, all forms of asbestos, including chrysotile asbestos, which comes from Quebec, cause cancer. The Society has indicated that every effort must be made to eliminate exposure to asbestos and to eliminate the diseases associated with it. It has called on the federal government and the provincial and territorial governments to adopt a strategy that would cover all aspects of asbestos, including legislation
to ensure worker safety and support to include chrysotile asbestos in the Rotterdam Convention. In 2004, a report published by the Quebec Public Health Institute found 800 cases of mesothelioma between 1982 and 1996 when the asbestos industry was at its height. In 2006, Health Canada warned the government and the public about the dangers of this cancer-causing material. The Director General of the program indicated that we cannot say that chrysotile asbestos is safe. Health Canada would rather see it included on the regulated materials list. Despite all these warnings, Canada has sent over 750,000 tons of asbestos around the world since 2006, and we are the 5th largest producer of asbestos. The governments of Canada and Quebec continue to support the production of asbestos and have funded until very recently the Chrysotile Institute, which has just closed its doors. It is clear that the material is increasingly being shunned by countries. We have actually gone backwards instead of moving forward. We know that the Chrysotile Institute has said that there is a way to use it safely, and the government has supported that. But is that true? When I asked the government in February why it was continuing to support asbestos, it said that it was possible to use it safely.
De développement économique pour
Honourable Parliamentary Secretary. Thank you, Mr. Speaker. Canada promotes the safe and controlled use of chrysotile around the world and has done so for over 30 years. We promote the safe use of this material and we promote that use. Canada has not banned the substance which is naturally in our environment. Our government will not put a Canadian industry in a position where it is discriminated against in a market where sales are permitted. Chrysotile asbestos is strictly regulated. There are maximum levels of exposure, and there are limits set by the federal, territorial, and provincial governments. Certain types of products to be used in the workplace or to be consumed cannot be exposed to asbestos. Importing countries alone are responsible for the use of materials including chrysotile. We want to encourage these countries to use this resource and protect their workers and citizens. We have put in place the means to protect those working in the mining sector, including the workers who have to deal with chrysotile. For a number of years, we have been making a distinction between amphibole asbestos and chrysotile. We have regulated the industry in order to protect workers in it. The diseases that occur in countries where fiberglass fibers are used intensively are due to inappropriate regulation of the type that has been banned in Canada for the past 40 years. It would be useless and inappropriate to ban chrysotile because the uses that are being criticized are no longer in existence now. Canada has protective measures for those who work directly or indirectly with chrysotile, and we comply with the ILO Convention on Worker Safety. We are signatories of this convention. The intention of the regulations are to ensure that workers in the industry avoid negative health effects.
Bournois-Celebury.
Honourable Member for Bournois-Celebury. Thank you, Mr. Speaker. My colleague not only did not answer my question, but he does not seem to see any problem with exporting the risks to other countries that are associated with asbestos. The government often refers to studies carried out by the Chrysotile Institute. But in fact, the exposure limit of 1 fiber per cubic centimeter, according to the Institute, does not present any risk for health. But other studies show that chrysotile has a shorter life in our lungs. They call this biopersistence. But these studies have been refuted. Dr. David Eagleman of Brown University showed that biopersistence does not apply in this case. When it comes to the safe use, people say that if asbestos is in concrete and therefore not dangerous, but in fact, when it is transported and exported, there are real dangers. Why is the federal government, instead of supporting dyeing industry that kills people, why does it not help regions? Order, please. I have to interrupt the member because her time is limited. The Honourable Parliamentary Secretary. Thank you, Mr. Speaker. Canada has promoted the safe use of chrysotile in Canada and around the world for over 30 years. We have promoted its safe, controlled use. The government has indicated that we will not restrict the use of our natural resources and their exporting around the world because we do not want to subject our industries to negative discrimination. Here are two quotes from Premier HoC. He said that we will continue to defend the safe use of chrysotile. And he said this April 12, 2010. He said that Quebec encourages the safe use of chrysotile. We use it safely here, and we encourage that type of use around the world. This is Jean Charest on January 29th, 2011.
Davenport.
Well, thank you, Mr. Speaker, and it's an honor to be here tonight to stand before you and Canadians from coast to coast to coast, and especially the members of my riding of Davenport, the men and women who elected me a year ago tomorrow to this place. And you know, Mr. Speaker, the very first day of this Parliament, I rose in this House and asked the government where their housing strategy was. In particular, when were they going to introduce a national housing strategy, and in the absence of one, perhaps they'd like to get on side with the one that we subsequently tabled in this House. And you know, Mr. Speaker, every single time that I've gotten up in this House to ask this question on behalf of Canadians from coast to coast to coast, we have never gotten an answer, not one answer. In fact, I'm going to read the answer I got from the Minister of Finance. One of the last times I asked a question on this, he said, "Mr. Speaker, what is not to love about the Mayor of Toronto? He's 300 pounds of fun." Self-described by the Mayor. I didn't make that up. The Mayor is doing a wonderful job in Toronto. He's leading the transit reform charge, straightening out the finances of the City of Toronto. It will be the ultimate great service for the taxpayers of that city to have control of the fiscal future of the City of Toronto, which has been mishandled for a long time. There was not a single mention of housing in that answer, Mr. Speaker, and that's the kind of thing that's happened time and time again, not just to me, but to every member on this side of the House, every member of the official opposition. And quite frankly, Mr. Speaker, Canadians are getting very concerned about the lack of accountability, the lack of transparency of this government. With respect to housing, Mr. Speaker, the Canadian Federation of Municipalities has underlined the fact that housing is the #1 issue facing municipalities, both big cities, small towns, rural municipalities, that access to affordable housing is becoming increasingly more difficult, not just for those in our society who are struggling economically, but also for those who we once called middle class. Now, this government likes to say that they're on the side of working people. But, Mr. Speaker, I got to say that the facts do not bear that out. Mr. Speaker, we've got approximately 1.5 million households, that's households, in core housing need in this country. 1.5 million Canadians in core housing need. 25% of those families are lone parent families, single parent families. And what we hear from this government time and time again is, hey, we're doing this, we're doing that. But really, Mr. Speaker, whatever they think they're doing, it's time for them to acknowledge, admit that their plan is not working. We need a national housing strategy. We're the only G20, G8 country that doesn't have one. How can that be good public management? How can that be a good social policy? It's certainly bad fiscal management, especially when you consider the multipliers that investments in housing bring into the economy. Their decisions are ideological, Mr. Speaker. It's time they started working for Canadians. Thank you so much.
The Honourable Parliamentary Secretary to the Minister of Finance.
Thank you, Mr. Speaker, and I'm very pleased to stand here today to answer the Honourable NDP member's question. However, I have to indicate right off the bat I'm somewhat disappointed in the member from Davenport. As he began his speech, he was very clear about reading a response from the Minister of Finance, but what he neglected to do is actually read out his personal attack on the Mayor of Toronto, Rob Ford, a personal attack that frankly does not meet the standard that the official opposition leader has set for the NDP. Nevertheless, I intend to answer the question about housing because I and this government take this serious issue to heart, and unfortunately this member is displaying how he takes this issue and attempts to attack other politicians with it and neglects to actually admit that when he does it. I would like to first tell Torontonians that the affordable housing situation is a situation that has been addressed by this government in a number of ways. As I talk about the ways that housing has been addressed, I would like to reflect on the record of the NDP as I do this. And so in saying that, let's think back to the Economic Action Plan, in fact. Think back to the historic investments that our Conservative government made in social housing that totaled roughly $2 billion. Combined with provincial and territorial support, this joint investment in social housing allowed for the construction and renovation of 16,500 housing units for low-income families across Canada. This included over 400 construction projects for low-income seniors and persons with disabilities, and over 11,000 existing social housing renovation projects. But there's more, Mr. Speaker. Our Conservative government also invested $150 million to renovate and retrofit federally administered social housing, supporting over 1,310 projects that helped some of the most vulnerable in our community, single-parent families, recent immigrants, and, of course, Aboriginal people living off reserve. But we also invested $400 million to build and renovate housing in over 500 First Nations communities. And let's not forget the $200 million in the north to address the territory's housing needs, supporting over 200 projects. Those are real investments, real projects, helping real people, and doing so right across Canada, including in Toronto. And they're not empty rhetoric or theoretical strategies as suggested by the member opposite. These are real efforts. These are real commitments, real investments. And in the words of the Canadian Housing and Renewal Association, I quote, Canada's Economic Action Plan addresses important needs facing people living in rundown social housing and certain groups, seniors, on-reserves Aboriginals, and people with disabilities waiting for decent, affordable housing. But amazingly, the NDP stood up and voted against all of these investments. That seems rather shocking given all of the statements that get made about supporting social housing. But Torontonians need to know that when it comes to supporting and putting our words into action, it is this Conservative government that actually gets the job done. It is the NDP who stands up, but they only stand up to vote against social housing measures, against investments for those who are most vulnerable. I stand here proudly supporting the government because of the actions they've taken, and I ask the NDP to start to show some compassion, start to show some effort here, support the measures we're putting forward. It's for the sake of Torontonians, after all. Thank you, Mr. Speaker.
The honourable member for Davenport.
Well, thank you, Mr. Speaker. Well, okay, well, let's talk about effort. We've tabled a national housing strategy. This government, your government, hasn't said a word about it. In fact, this government likes to compare us, Mr. Speaker, to OECD countries when it suits them. And yet, in this instance, as in others, national transit strategy comes to mind, another glaring lack on the part of this government. And you know, Mr. Speaker, there's very little in this national housing strategy that any government couldn't buy into. In fact, you know, one of the main points here is that once this national housing strategy comes into law, it compels the minister to convene a meeting within 180 days. It's 180 days you have to talk to major stakeholders, to the provinces, to municipalities, to those that provide social housing. It's a way for the government to actually do the job that Canadians expect their government to do, which is to plan and to prudently plan for the kind of housing Canadians need. Thank you so much, Mr. Speaker.
Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. And the member can play politics all he wants. That's his choice. We on this side remain very much focused on building a better Canada, and that includes the Toronto area. Only recently we introduced Economic Action Plan 2012, and our plan includes incredibly positive developments for Canada and especially Toronto. Furthermore, the Action Plan announces the creation of Canada's first national near-urban park in the Rouge Valley in Toronto, something that has been incredibly welcomed. Listen to what Toronto City Councillor Glenn de Beermaker had to say about it. Quote, "To see the Prime Minister and Finance Minister saying loudly and clearly that they'll protect this land is a dream come true for us." End quote. But what did the NDP and the member opposite do from Davenport? Unfortunately, Mr. Speaker, they voted against the Rouge Valley National Park and against Toronto. Unfortunate. Thank you, Mr. Speaker.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 2 p.m. pursuant to Standing Order 24-1.